Just to remind everyone, I hope everyone's checked in as usual into the inquiry, into the venue, and give you the usual reminder to maintain physical distancing. I know everyone's been doing that through the inquiry. Okay, we're moving on to planning evidence today at the inquiry. We'll go first to Mr. Trinick, who I believe will lead evidence from Mrs. Alison Sidgwick, then to Mr. Steele, who's to lead evidence from Mr. David Bell, and to Mr. Brown for the Council, who's to lead evidence from Mr. Templeton. So unless anyone has any initial points, I'll go to Mr. Trinick.
Thank you, sir. Good morning. I call Alison Sidgwick. Now I'm going to ask her to read her precognition, or most of it, and I've already notified documents that will be required, and I've told Helen in which order they are. The first one's up already, indeed. The order is, for those who want to know it, 6:10, then 5:20, then 11:07, then 5:31, 14:24, 14:35, and then CD 1-2, Chapter 3 of the ES, and finally CD 1-3, Volume A. I'll go to the figure when I get there. So, Mr. Sidgwick, would you please go to your precognition and read it from paragraph 2 on page 2 to the end, uninterrupted. There'll then be some additional questions.
This application comes before the reporters This application comes before the reporters under the Electricity Act 1989. For such applications, Section 25 of the Town and Country Planning Scotland Act 1997 is not engaged. Paragraph 3.2 of Schedule 9 requires the Scottish ministers, when considering such applications, to have regard to the desirability of preserving natural beauty, of conserving flora and fauna and geological and physiographical features of special interest, and of protecting sites, buildings and objects of architectural, historic or archaeological interest, being the assets named in paragraph 3.1. Paragraph 3.3 of Schedule 9 requires the Scottish ministers to avoid, so far as possible, injury to fisheries or to the stock of fish in any waters. The duty of the ministers is not to preserve the qualities of the environmental assets recorded in paragraph 3.5 of Schedule 9, but to have regard to the desirability of doing so. In my view, the applicant has provided the reporters and the Scottish ministers with sufficient information to enable the discharge of their duties under Schedule 9 of the 1989 Act. Policy framework. The international, UK and Scottish contexts set a framework of ambitious targets associated with climate change, including those for renewable energy and net zero greenhouse gas emissions from a range of sectors. Details of these are provided in my inquiry report. If these targets are to be met and the economy is to decarbonise, then the need for generation of renewable energy is critical. Key to this is the delivery of renewable forms of electricity generation. Onshore wind farms are an important part of this provision. The decision in the Heathrow case makes clear the importance which should be placed on the Paris Agreement and the obligations of the Climate Change Act 2008. It is clear that the Paris Agreement is part of the UK government policy. In considering this application, it is submitted that the reporters should have regard to Scottish planning policy and the National Planning Framework 3. These documents provide sound locational advice with respect to wind farm developments. However, it must be remembered that they do not contain the current Scottish Government thinking on targets and the climate emergency, nor do they reflect the current situation post the Heathrow decision and the green recovery post-COVID-19. Nor, in my view, do they reflect so far as it may be necessary, the trajectory of the UK Government on these matters. The Moray Council position seems to be that Moray has accommodated enough wind farm development and that the Scottish Government is moving away from onshore wind as a measure to address climate change and reach net zero. I agree that the Scottish Government is looking at a number of ways to decarbonise the economy, but that is in addition to, not at the expense of onshore wind farms, which indeed enjoy enhanced policy support. Since the publication of SPP and MPF3, the Government has declared a climate emergency. Even prior to this declaration, a clear step change was indicated through publications such as the Scottish Energy Strategy, the Onshore Wind Policy Statement, annual energy statements and ministerial statements. More recently, this step change is manifest in the references to a green recovery following COVID-19 contained in the letter to Rosanna Cunningham from the Committee on Climate Change and the report of the Advisory Group on Economic Recovery. The development plan for the site comprises the Moray Local Development Plan 2020, and the key determining policy for the purposes of this application is DP9. I understand that the supplementary guidance on onshore wind, which was part of the Local Development Plan 2015, has fallen with the adoption of the 2020 LDP and has not been replaced with new supplementary guidance, statutory or otherwise. To the extent that Moray Council argues a position to the contrary will be a matter for legal submissions, which I will address in oral evidence, so far as may be necessary. Benefits of Clash Gour. The proposed development would have an installed turbine capacity of between 164 and 225 megawatts, with a further 50 megawatts associated with battery storage. Improvements in turbine technology may mean that the proposed development could have a capacity of up to 256 megawatts. Clash Gour has the potential to contribute 7 times the average capacity of Scottish wind farms on and offshore consented over the last year, and is in a location with good wind speeds, which will generate a high yield. The project benefits from a grid connection offer which can be implemented on-site with no additional off-site infrastructure, including poles or underground cable requirements. Clash Gour would make a contribution which can be regarded as nationally important to the achievement of policy goals of the Scottish Ministers. This contribution of as much as 0.25 gigawatts to renewable energy generation is key in terms of the need case for this development. There are a number of other benefits associated with the proposed development. These benefits are proposed so far as necessary to be secured by condition and will include the following. The proposed development would produce between 651 and 752 gigawatts of electricity annually. This would power between 167,699 and 193,038 average family homes. It would result in carbon dioxide savings. These could be between 6 and 7 million tonnes, assuming a 30-year lifetime and a grid mix of electricity. A habitat management plan, the outline of which has been subject to discussion with key consultees. The final HMP will focus on habitats and species. It would bring about overall improvements to the peatland, and the HMP would complement the HMP for Berryburn Wind Farm. A forest plan which would result in more species and age diversity and a more economically sustainable forest. A public access management plan which proposes circular walking routes within Dallas Forest and opportunities for links to wider routes in the area. Socio-economic benefits, including construction and long-term operational effects, which respond to the Moray economic strategy and are set out in the evidence of Mr. Blackett. If consented, the proposed development would offer the opportunity of a shared ownership scheme, which is well developed. This has created a level of anticipation in Moray, as shown by the evidence of energising Moray and the City and Royal Borough Elgin Community Council. These initiatives respond to the Moray economic strategy. Conclusion. Gour wind farm presents a rare opportunity to realise approximately 0.25 gigawatts of renewable energy in an SPP Group 3 area, with no outstanding agency objections or any objections based on impacts on nationally recognised landscapes or other natural or cultural heritage interests. The proposed development is located in an area which has recognised potential for wind farm development when considered in the context of Table 1 of SPP. This locational support in national policy should carry significant weight in the decision-making process. The proposed development derives support from climate change and renewable energy policy at international, UK and Scottish levels. The weight to be attached to such policy can be emphasised after and as a result of the Heathrow decision is considered to be very significant. The UK and Scottish governments and Moray Council have all declared a climate emergency, and the proposed development presents an acceptable opportunity to contribute to the efforts to tackle this emergency. There has, as discussed above and in my inquiry report, been a step change in the advice given on the need to tackle the climate emergency and to promote green economic growth. The ministers cannot simply adopt an SPP 24-based business as usual approach to decision-making pending MPF4. I do not consider that the Scottish Government is replacing onshore wind with other technologies to decarbonise the economy. It is my opinion that a key plank of government policy is to seek additional technologies to achieve the government's goals, over and above existing technology, including onshore wind, which still enjoy significant policy support. The evolution of the design of the proposed development from the start has sought to balance the energy potential of the site and the environmental impact. Integral to this was consultation with the public and with the required consultees in order to properly understand and promote a mitigation-led approach to design. The proposed development is located in a landscape which has capacity to accommodate it, and the only resultant significant environmental effects are limited to landscape and visual impacts. Such will be the case for all commercial wind farms, and in an SPP Group 3 area cannot of itself justify the rejection of the proposed development. The evidence for this concluding point on landscape is derived from Mr. Welsh, who considers that the proposed development is acceptable in landscape and visual terms, and his evidence is commended to the reporters. The proposed development would result in positive socio-economic impact, as set out in the evidence of Mr. Blackett. Mr. Blackett concludes that the proposed development will deliver substantial national and local economic benefits, both during the construction and operational period. Mr. Blackett concludes that there is no evidence to suggest that there would be a negative impact on tourism as a result of the proposed development. The evidence of Mr. Blackett in respect of socio-economic effects of the proposed development is commended to the reporters. I have a spelling mistake in the following paragraph, and I will read it as I would correct it going through it, if that's okay. The applicant has had regard to the matters set out in Schedule 9 of the 1989 Act in respect of the desirability of preserving the natural beauty of the countryside, of concerning flora, fauna, and geological and physiographical features of special interest, and of protecting sites, buildings, and objects of architectural, historic or archaeological interest. These are all matters which have guided the evolution of the project through the design process and who have informed the EIA process associated with the application. There is sufficient information to allow ministers to be satisfied on these points. This is a case where there's clear blue water between the positive case for the proposed development and the material adverse impacts identified. On the evidence presented by the applicant, Gour would give rise to no adverse effects which could remotely justify the refusal of an application for the development, with such potential to deliver green energy in an SPP Group 3 area, a conclusion supported by the development plan and the locational advice in the Murray Wind Energy Landscape Capacity Study. I have concluded that, based on the evidence presented on behalf of the applicant, a Section 36 consent and deemed planning permission should be granted for the proposed development at Gour.
Thank you, Mr. Sidgwick. Some additional points. Firstly, in terms of the supplementary guidance, we now know about the updated position. You won't know more than we've been told so far, so I'll put no more questions to you on that. But would it be right to say that legal matters relating to the SG, the 1997 Act, and the 2013 Development Planning Regulations, that's not a matter for you, that's for legal submission?
Yes.
And so far as the materiality of the community ownership offer, are you also leaving that to legal submissions?
I am.
Thank you. Now, would you take up Mr. Templeton's inquiry report, please, at section 3.3 on page 8?
Yes.
Helen, sorry, that's CD 16.3. Now, in this section, Mr. Templeton talks about the draft programme for government, CD 517, has been superseded, I think, by CD 1539, is that right?
Yes.
That's the finally issued programme for government, which is before the inquiry. He talks of the draft programme, indeed I think it's the same for the final programme, not making a specific reference to onshore wind as being a key part of the government's approach to addressing the climate emergency. What do you want to say in response to that?
It's just not true. There's clear support from the Scottish Government for onshore wind. This is set out in evidence in my inquiry report in section 4.4. There's been clear support for renewable energy in response to the COVID-19 situation.
Take it slowly.
COVID-19 situation as set out in my inquiry report in section 4.5, and in the context of the climate emergency, which is section 4.6 of my inquiry report. These sections set out the support that's contained in documents such as the onshore wind policy statement, which is document CD 610.
Yes, let's go there, shall we? And I think you want paragraph 3, is that right? If you have the words, you don't need to go to the document yourself.
Yeah.
What do you want to tell us about the onshore wind policy statement in this context?
It clearly acknowledges that there's need for larger turbines, along with the expectation that onshore wind will remain at the heart of a clean and reliable low-carbon energy future in Scotland. And it says, in order for onshore wind to play its vital role in meeting Scotland's energy targets and a material role in growing our economy, its contribution must continue to grow. Onshore wind generation will remain crucial in terms of our goals for a decarbonised energy system, helping to meet the greater demand from our heat and transport sectors, as well as making further progress towards ambitious renewable targets which the Scottish Government has set.
Yes, I think this is there's another document you want to refer to, an appeal decision, which may say something about the same subject. Is that CD 11.7?
It is.
And if we get that out, please, Helen, at paragraph 80. What do you want to extract from this document?
I think this document reinforces that position, and between paragraph 80 and paragraph 83, the reporter comments on it and concludes that I agree that, as a material consideration, this increases the value I should attach to the renewable energy benefits of the proposed development.
Thank you. And has the government taken recent action in terms of fiscal support for onshore wind, which is relevant to the message you're giving to the inquiry?
Yes, it has. The UK government has recently announced that onshore wind will be included in the next round of Contracts for Difference, CFD.
Thank you. I'm changing topic now. I want to go to Mr. Templeton's paragraph 3.4, which you'll find starting at page 10 of his inquiry report. And would you also get out, please, CD 531, which is the document of which he speaks. Now, in paragraph 341, Mr. Templeton provides a quotation from this document. I think you want to add some context.
Yes, I think what Mr. Templeton has used is incomplete, and it doesn't put the document into its context. And I think the context of the document is clear from the introduction of the document, which at paragraph 1 states, we have
That's on page 03, is that right? Yes, it is.
Yes, it is.
Okay, carry on.
And that states, we have a clearer picture than ever before of the crisis in our climate and our natural world. Global assessments have highlighted the scale and urgency of action needed to avoid the worst impacts of climate change and to halt the loss of the Earth's biodiversity. And the references that have been made in Mr. Templeton's inquiry report need to be seen in that context. It is acknowledged that Murray has some special landscapes, and they're rightly designated as such, but this development is not in a designated landscape, and there's no objection to it from SNH or from Cairngorms National Park Authority. The impacts on the designated sites have been considered as part of the EIA process and are found to be acceptable by Mr. Welsh.
Thank you. The next point takes us to, and I don't think we need go there, I can just record, that Mr. Kelly, in his inquiry report on behalf of Save Wild Murray, if you've got the paragraph reference, that's fine, refers to the issue of the need case for the development and to the decision letter for the Gordon Bush extension, which is CD 1424. And he refers to paragraph 4 of CD 1424, where, hold fire, will you take us there? I've lost it for the moment. Carry on.
It's the reference is on page 4. And
Page 4. Yep, carry on. What do the ministers say there?
it's the last sentence of that page, and it says the needs case for the proposed varied development is not a material planning consideration.
What's your take on that?
Well, the application for Gordon Bush was for a variation of an existing consent under Section 36 of the Electricity Act. The application was made under Section C of the same Act. The principle for a wind farm on the site had been established at Gordon Bush Extension. And this is different to the current case. In the current case, it's an application for development on land that has not previously been subject to any consent or application for wind farm development. And in the case of Gour, the Gour application, the matter of need is an important consideration in the planning balance. It's not for me to say whether the ministers were right or wrong in what they said in their letter.
Thank you. Turning to more local level, the Murray Council Climate Change Strategy, if we go to paragraph 339 of Mr. Templeton's report, we don't actually need to go there. He tells us that the Council is developing its own climate change strategy. Has anything happened there, to your knowledge?
Yes, a draft document which is the subject of consultation was published at the start of this month, and I understand it's subject to consultation until the end of October.
Fine. You've looked at the document. Is there anything you want to draw from it which might provide contextual information?
There's one matter. On page 19, there is information in respect of the CO2 emissions associated with Murray, and it advises that Murray has the highest per capita CO2 emissions of any local authority in Scotland. And it attributes this to the whisky industry, to food production, and the 2 MOD facilities. And to my mind, this really just demonstrates the complexity of climate change issues. It's not just a product of urban and industrial areas, but it is also a product in rural areas, such as Murray. And this underpins the need to work in all ways possible to achieve the position of net zero.
Thank you. We're on our final 2 points. Firstly, grid connection. Would you please get out CD... Well, no, you don't need to. CD12, Chapter 3, paragraphs 324 to 326 describe the grid connections options open at that stage. And I believe that was refined. I'm just giving references at the moment. In SI 2019, which is CD 115, Volume 1, Chapter 3, Paragraph 35. I think it's that the line of the grid connection has now been confirmed. Is that correct?
Indeed.
And if we went to CD 13, we do need to go there now, Volume 3A, at figure 314A, please. Does that help you tell the reporters where the grid connection is actually going to be?
Yes, it does. It's in the northwest of the site near the property known as John Stripe, and it can be seen in the location of it can be seen in the small figure in the top of that drawing.
Is that 1A, substation 1A?
Yes.
Close to that?
Yes.
But, yeah, I see the line there. And I think there's a condition, is it 15 on the Dean, offered on the Dean planning permission, which relates to the design of the substation. Are there any, well, what is the distance between the substation and the grid connection point?
I think it's less than 50 metres, but it's of that order. And if you look at an OS map and indeed the site layout plans, you can see the 275 kV line on that, sitting very close to the location of the substation.
So this being a 250 megawatt or thereabouts plant, it'll connect at 275 kV, is that right?
That's my understanding.
Yeah, okay. And is there any overhead line needed to connect in that 50 metres?
There may be an overhead line between the substation and it, yes. But that will all be within the site boundary.
All within the site boundary. And what is the proposed, or what is the allowed date for this connection?
2024.
And that, I think, is specified in your inquiry report at paragraph 478.
It is.
So, in your view, if this development were to obtain consent and noting the 2024 connection, would there be anything else to stop it connecting at that date?
Not as far as I'm aware, subject to the usual discharge of any conditions and if there were any other licences.
Now, my final point is that you've heard some questions put to a number of witnesses in this inquiry concerning what might be the position if the scheme were to be reduced in size by the elimination of some turbines. Obviously, there are legal issues which arise here on which I'm not asking you to comment, but I'd like a planner's perspective, please, on the issues which may arise if it's intended to eliminate turbines. Before giving your answer, I believe that a substantial part of your career has been in EIA project management.
It has, yes.
And in planning for wind farms.
Indeed.
And attending planning design meetings.
Yes.
then please give your view.
As you say, the potential to refine the scheme as part of the decision-making process is a matter for legal submissions. However, I consider that it's impossible to make a judgment on whether or not it is possible without understanding what is actually proposed by way of a reduction in turbine numbers. The potential effects of deleting turbines would be dependent on which turbines were to be removed. The removal of turbines could give rise to a number of effects and indeed unintended consequences. In the case of some environmental considerations, a reduction in turbine numbers could be seen as positive, for example, in respect of traffic, where if there were less turbine numbers, you would expect to see less traffic movements. However, in the cases of other disciplines, the changes may be much more subtle. For example, the removal of some turbines may result in a redesign of the track layout, and that could have different ecological effects, for argument's sake, or hydrological effects, for argument's sake. When, as part of the design process, some turbines are removed, the remaining turbines are often repositioned slightly or indeed by wider distances in order to maximise their potential and to help resolve any new landscape or visual effects which may arise as a result of the turbine's removal. So I'm thinking if you remove one turbine and it creates an issue in a different viewpoint, you might tweak things in order to try and get the balance right. In my experience, any changes to design on landscape grounds are always reviewed and considered by the other technical disciplines involved as part of the EIA process in order to consider unintended consequences. And it's for that reason I think it's impossible to say if the information is available to remove turbines from part of this proposed development without actually knowing what is proposed.
And is the evidence for the design of this development before the inquiry a CD17, a design and access statement?
It is.
But were you involved in the development of that document?
Yes.
How would you rate that document as a DAS?
It goes above and beyond the usual DAS in respect of that would accompany a wind farm planning application. It goes into more detail. It explains much more of the design rationale than many documents do.
Mr. Sedgwick, would you please stay there? There may be some questions for you. I'm not aware of having, and if I'm taking his name in vain, I do apologise, Mr. Brown, I'm not aware of having received a list of documents for cross-examination for Alison Sidgwick. If we could have the list and then have time for Mrs. Sidgwick to get the documents in front of her, that would be appreciated. As I say, if I'm wrong, I apologise.
I think we've just received it. I received it at the beginning of the examination in chief, didn't we?
Sorry, sir, I'll just check with my solicitor here.
I think we have an email from Helen at 9:35. Copied to
Yes,
parties.
Madam, I understand. My apologies for the fact it was just as late, and certainly, Sir and Madam, if it's acceptable to you, I have no objection whatsoever to Mr Trinick having an opportunity to consider it first.
It's not for me to consider it. It's up to you what you raise. But just, there's no problem at all. As long as we have a few minutes to get the documents out, that's fine. But if we could have that list. Has it been emailed to us?
I'm told it has.
Oh, that's fine. And I've been busy doing other things, but Kirsty has probably got it.
So I can confirm that we received it during the course of the evidence in chief, which has probably made it a little bit difficult for Ms Sidgwick, or indeed Mr Trinick, to receive it and read it.
Yeah. Should you take 10 minutes, so 10:15? Yeah. Mr. Trinity. Sorry, Mr. Brown.
Thank you, sir. Ms Sidgwick, good morning.
Morning.
Could I take you to page 12 of your report, please?
Yes.
And in particular, the part of that page where you address the Heathrow decision.
Yes.
And that ultimately leads to a conclusion to be found at paragraph 4.315.
Yes.
Sorry, I'll just wait until Helen has brought it to the... Thank you, Helen. Where you say at the end of paragraph 4.315 that this means that the Paris Agreement is a matter of UK policy which must be taken into account in decision-making processes.
Yes.
Now, what do you mean when you say it must be taken into account in decision-making processes?
I mean that the requirements of the Paris Agreement associated with net zero and things should be taken into account in decision-making processes.
Yes. So are you saying that the decision-maker is bound to follow the Paris Agreement?
I'm not a lawyer and I'm not sure that that's a question that I can answer, whether or not they are bound to.
Well, you have included it in your report, and I'm asking whether your position as the decision-maker is bound to follow the Paris Agreement.
My understanding is that it should be taken into account, yes.
But you accept that taking it into account and being bound to apply it are different concepts?
Legally, they may be.
Well, let's have a look at the decision. And the reference is CD 1134.
I have that, thank you.
And Helen, if you could go to electronic page 72, please.
Can you give me paragraph numbers, because I'm
Yes,
going to get stuck otherwise?
Yes, I'll do that as well, Mr. Trinick. That's not a problem. Now, the issue here...
Sorry, I'm not sure what page electronic 72 is. Could you give me the paragraph number, please?
It's at paragraph 222, where we start to cover it. Yeah, unfortunately, the pages aren't numbered in the hard copy.
Thank you.
Now, the issue in this case was it not, if we look at paragraph 222, the issue was that under section 5.8 of the Planning Act, the Secretary of State for Transport was directed to take account of government policy. Do you see that in paragraph 222?
That was the submission of Mr. Crossland.
Yes.
Yes, I see that.
Yes. And at paragraph 223 in the decision, it said that it is important to start by emphasising what section 5.8 does and does not require of the Secretary of State. It does not require him to follow or act in accordance with government policy. In terms, what it requires is that the ANPS should explain, and that's the statement, the Airport National Statement, should explain how the Secretary of State has taken into account government policy. It's necessarily implicit in that obligation that the Secretary of State must indeed first have taken that government policy into account. This is an important aspect of the transparency of the Secretary of State's actions and his accountability both to Parliament and to the wider public.
Yeah, these are fair questions in the sense the witnesses give evidence on the point, but all the planning witness has done is to record what the decision says, which he's done in the last sentence. If it helps you, there will be no submission from this side that the decision maker in this case has to follow the Paris Agreement. All that the Heathrow decision said was that it is a matter of government policy which must be taken into account. That's as far as any submission will go if that helps. But bear in mind, this is not a legal witness, it's a planning witness.
Yes, well, thank you for that, Mr Trinick. It may be better that we cover the point in legal submissions if you're happy to do that.
Yep.
Could I move on then to CD 611, please, which is the Scottish Energy Strategy.
I have that, thank you.
Could I ask you, Helen, please, to go to page 42, which hopefully will be the right electronic page. Oh, sorry, Helen, it's actually electronic page 44. Yeah, that's the one. Now, could I ask you, sorry, Helen, could you maybe scroll up just a little so we can see the start of the photograph? Sorry, down, sorry, the other way. Yeah, thanks. Do you see a paragraph just above the photograph there, which says successive Scottish governments, through a mixture of ambitions, targets and direct action, have enhanced our renowned reputation for renewables, wave, tidal, solar and wind?
Yes, I see that.
So, if we can continue on to the next page, please. And again, just above the photograph of the turbine, there's another paragraph. All renewable and low-carbon solutions will have a role to play. This section focuses briefly on some of the key sectors and opportunities. So would you accept that this strategy is actually looking at the question of renewables across the spectrum of the different types of renewable energy sources that are available in Scotland?
Yes, it is, and it goes on to talk about the different technologies in the following pages.
Yes, and for speed, we can go to them, but would you accept that the document then goes on to talk about offshore wind on page 45?
It does. Before that, it refers to onshore wind.
Yes, sorry, it does talk about...
On page 43.
Yes, it does. It talks about onshore wind, I accept that. But it also talks about offshore wind.
Yes.
Page 45. On page 46, it talks about island wind.
Yes.
On page 49, it talks about wave and tidal energy. On page 4, it talks about solar and photovoltaic panels. Sorry, page 50, solar and photovoltaic panels.
So I've got that on page 47, but I don't suppose that matters.
No, but it does discuss that.
Yes.
It then goes on to discuss bioenergy.
Yes.
And it also talks about hydropower.
Yes.
So, setting all of that in context, it's actually talking about a number of different renewable sources. It's not all about onshore wind, is it?
No, it's not all about onshore wind. It's all about the mix of renewable technologies.
And Helen, if I could ask you to turn to electronic page 44. Oh, sorry, 46. And, thank you. And do we see on the left-hand side a column there which deals with the point you had raised about the fact it covers onshore wind, and it says, we will push for UK-wide policy support for onshore wind and take legal action of our own to prioritise and deliver a route to market combined with a land use planning approach which continues to support development while protecting our landscapes.
Yes, that's what it says.
Yes. So you accept from that that landscape remains a relevant consideration,
Yes,
even in this document?
yes. It's one of a number of matters which have to be taken into account.
Could I take you next, please, to CD 610, which is the onshore wind policy statement? And if I could take you to page 6, please, which is electronic page 7. And if we could go to the bottom of that page, paragraph 3, which talks about the role onshore wind will play. And if we can then scroll to the next page, please, and look at paragraph 4. And it says there that this means that Scotland will continue to need more onshore wind development and capacity in locations across our landscapes where it can be accommodated.
Yes, that's correct. And as I said, landscape is one of a number of considerations that have gone into the design of the proposed development through the development process and the EIA process.
And if we could turn, please, to page 9, which will be electronic page 10. And we have a look at paragraphs 24 and 25. And in 24 it says the technology shift towards larger turbines may present challenges when identifying landscapes with the capacity to accommodate larger scale development, as not all will be suitable. However, fewer but larger wind turbines may also present an opportunity for landscape improvement, as well as increasing the amount of electricity generated. And then in paragraph 25, it says the Scottish Government acknowledges the way in which wind turbine technology and design is evolving and fully supports the delivery of large wind turbines in landscapes judged to be capable of accommodating them without significant adverse effects. So again, do you accept that the statement is again acknowledging that there may be an impact upon the landscape and the landscape must be judged to be capable of accommodating the turbines without significant effects?
Yes, I mean, that is what it says, and I don't dispute that. I think it's important to note that any wind farm will result in some form of landscape effect. To the best of my knowledge, a wind farm has yet to be designed which has no landscape effect.
Yes, and if I could, thank you. If I could take you to CD 1539, which is the programme for government. Now, in this document, there is a chapter which starts on electronic page 23. And this is about a national mission to create new jobs, good jobs, and green jobs. So this is the section where we find the references to the environmental considerations. Now, to the best of your knowledge, in this document as a whole and in this chapter, is there any specific reference to onshore wind?
I don't think there is a specific reference to onshore wind. There is reference to the need for renewable energy and green energy, and part of that is onshore wind.
Yes. If we could turn to electronic page 49, please. Sorry, if you can just bear with me. Sorry, I've got these numbers wrong. It's electronic page 47. Sorry, can I just see the page number for that, Helen, at the top? Sorry, I'm sorry, I'm confusing things. It's hard copy page 47. If you would turn to that, please. Thank you. And do we see there in the right-hand column, second paragraph down, that the government is planning to publish an updated offshore wind policy statement?
Yes.
So there's no reference to onshore, but the programme includes reference to offshore wind and the fact that a policy statement is to be updated on that topic.
It does, and it also refers to the publication or the forthcoming publication of a refreshed energy strategy, which currently covers onshore wind, and I would expect that it may cover onshore wind as well. I'd just add to that a lot of what I've read in this document is talking about helping and promoting technologies which are not as far advanced and not as mature as onshore wind, and therefore need more of an injection to get them going. Onshore wind is established low cost part of the renewable energy mix, and my reading of this is helping technologies that are not as advanced and not as mature to come forward and to give them the assistance to do that.
Yes, but the point remains, though, does it not, that the government is thinking more diversely about how energy can be derived from renewable sources in Scotland. It's not just focusing on onshore wind.
The Scottish Government is not entirely focused on onshore wind. It is looking at a mix of renewable energy. But I think, as is clear in a number of these documents, onshore wind is a vital part of that.
Yes, and you mentioned that this document refers to the refreshing of the energy statement. But, of course, the issue there must be that we don't know what may be in that refreshed statement, do we?
No, we don't. If they're refreshing it, I would expect them to look at all the technologies that are currently in there and to do, as they say, refresh. But no, I have no idea what that document will say.
Yes, and given we don't know what it will say, it may still include the references in the existing statement about the landscape.
I would expect it to continue to include reference to the landscape.
Now, if I could take you to section 4.5 of your report, where you consider the response to COVID-19, and that's to be found at page 17. Now, you've spoken of your experience in assisting with the development of wind farms, so you'll be aware of Scottish Planning Policy 3 and
Yes.
paragraph 170, which says that areas should be suitable for use in perpetuity
Yes.
for wind farms. Now, in the context of the response to the pandemic, would you agree that there's uncertainty about what it will mean for the economy? Yeah. Would you accept that there is uncertainty about what the pandemic means for the economy in the sense of how long-lasting the impact will be?
Yes, I don't think we know what the long-term economic effects of COVID-19 will be, no.
Yeah, so there's uncertainty there. And would you also accept from the documents you've produced that there needs to be planning for the recovery?
Indeed.
Is there not here a risk of a knee-jerk reaction in the sense that if SPP says that areas should be available in perpetuity, that as a knee-jerk reaction, short-term decisions are made which have a long-lasting effect upon the landscape?
I think we have to trust the decision makers to get it right.
Okay. Now, you've referred to 4 separate documents here. The first is the Climate Change Committee advice to the Scottish Government on the recovery from the COVID-19 crisis. You mentioned that on page 17. Then on page 18, you refer to the Chief Planner and Minister for Local Government, Housing and Planning letter of May 2020. And then you refer to the Scottish Renewables written evidence to the House of Commons, Scottish Affairs Committee inquiry into coronavirus in Scotland. And then on page 19, you refer to 8 policy packages for Scotland Green Recovery, July 2020.
Yes.
Now, are these documents not just advisory to the government?
The first one, the Climate Change Committee's advice, is advice to the Scottish Government.
Yes.
The second one is a letter from the Chief Planner and the Minister for Local Government. And they are very clear that planning is key in is a key part of addressing the COVID-19 economic recovery, both in the short term and the long term. It's not a policy statement, but it is coming from the Minister. The Scottish Renewables written evidence to the House of Commons is exactly what it says. It's written evidence to them. It's not policy. The advisory group on economic recovery is an advisory group that is advising the government, and the climate emergency response group is again saying to government what they think needs to happen. I think what is clear is that there are a lot of people setting out a strong case for the need for a green, clean recovery.
Yes, but none of these documents are policy documents in the sense of being promulgated by the government.
They're not published by the government, although, as I say, one is a letter which comes from the Minister.
Yes, well, on that letter from the Minister, at paragraph 453, you've quoted what is said in the letter, but does the letter say anything about the change of approach, or whether there should be a change of approach to the process of determining applications such as this?
Could I have a look at the letter, please?
Yes. It is CD 521. CD 521.
Fine. And your question was, does it tell us of any change to the planning system?
Yes. Or more specifically, any change to the approach which should be taken to applications such as the one which is before us today.
Okay. Well, the first paragraph talks about further actions that they are intending to take to enable Scotland's planning system to continue to function effectively, confidently and with fairness during difficult times. So they are looking to take steps to continue to ensure that the planning system continues to function properly.
Yes, but in the context of this letter, And given the date of the letter, is that not really intended to make sure that planning applications can continue to be considered and determined? It's not saying that there should be any change in the way in which applications are actually considered when it comes to the merits of the planning application.
I don't believe it's talking about the different weights that one may put into the planning balance. I think it is seeking to ensure that the planning system functions as effectively and efficiently as possible.
Yes, and as a result of that, we are here today during the pandemic holding this inquiry.
Indeed.
Now, although these documents to which you've referred you accept are not policy, I do wish to have a look at them with you. So could we start with the first document which you've referred to, which is the Climate Change Committee advice to the Scottish Government on the recovery from the COVID-19 crisis, and that is CD 520. And if you could turn to page 2 of that document, please. And this is talking about the opportunities for Scotland's renewable energy industry for the immediate stimulus of the economy. And if we look through the list, do we see any reference here to, well, in paragraph 10, it does say, which is on page 3, paragraph 10. Sorry, it's page 3. Unfortunately, the pages aren't numbered.
I don't have a paragraph 10.
Oh, sorry. Sorry, I've misread the document. Yes, sorry. This document is talking about the 6 principles.
Yes.
And if we turn to the last page of the document, the
the last page of the letter or the last page of the annex, please?
Yeah, the last page of the annex.
Thank you.
Yes, and it's the penultimate paragraph I'd like you to look at, where it says the UK and Scottish governments have already declared their intentions to deliver large-scale national infrastructure programmes. Many of these projects are critical to preparing for climate change and achieving net zero emissions, flood and coastal erosion risk management, electric vehicle charging infrastructure, hydrogen production and carbon storage infrastructure, onshore wind, so there's certainly mention of that, offshore wind and solar power. Acceleration of these projects should take priority. So again, do we see there that the Climate Change Committee is thinking broadly about renewable sources of energy, and that onshore wind is only one of 7 different initiatives it's thinking about?
Yep. Onshore wind is part of the mix, yes.
Yeah, that's part of the mix.
And it's an important part of the mix.
But what this document is not doing is that there's no discussion about the planning balance which has to be brought to bear in determining whether to grant permission for wind farms.
No, this document, as I read it, isn't providing advice in respect of decision-making on applications for any of the sorts of development that are mentioned in that final or second last paragraph.
Right, thank you. Could I take you next to the third document which you refer to, which is Scottish Renewables Written Evidence to the House of Commons Scottish Affairs Committee Inquiry into Coronavirus and Scotland. And that is to be found at paragraph, sorry, it's CD 523. And if we have a look at the third page of that document, please? And it's paragraph 10. Thank you. It does say that Scotland has a strong small-scale renewables sector. These solar, wind and hydro projects provide energy security to communities across Scotland, support energy resilience and allow communities to engage with and take control of their own energy systems. Now, apart from that, is there any other reference in this document to onshore wind?
I'll take your word for it. There's not a specific no other specific reference to onshore wind. But what this document is doing is it's a submission made on behalf of Scottish Renewables, whose focus is renewables across the board, and it is making the case for renewables generally to be a key part of the green economic recovery, and part of that is onshore wind. But it's not the only form.
Yes, so if we were to turn back to paragraph 7, for example, which is on page 2, thank you, we can see there reference to renewable technologies like heat pumps and solar thermal panels.
Yes.
So it's thinking more broadly about the concept of heat. Paragraph 8, if we could scroll to that, please. It's talking about shovel-ready projects, which presumably could immediately stimulate the economy. But if we look down that list, they first mentioned RACs. That's as a pumped storage hydropower station. Is that correct?
Yes.
The next one, SSE Renewables, has proposed a pumped storage scheme, and I'm not going to attempt how to pronounce that, near Loch Lochy.
Yes, at Corriglass.
Yeah, at Corriglass. And again, that's about pumped storage.
Indeed.
Then the third bullet, we've got the Murray West offshore wind farm. And then the fourth one, we've got the SSE Renewables Seagreen offshore wind farm, correct? Is that
yes.
correct? And then again, lastly, we've got the Inchcape offshore wind farm.
Indeed.
Correct?
My understanding is that most, if not all of these, have the consent they require and therefore are shovel-ready and ready to go. I wouldn't expect to see a wind farm still in the decision-making process in this list.
Yes, but again, when this advice has been prepared, is there any reference to the approach which should be taken to considering from a planning perspective whether a proposal should receive consent?
No, because that's not what the document is aimed at. The document, as I read it, is aimed at emphasising the role in which renewables can have immediately in the economy. They talk about the large number of jobs that have been created as a result of renewable energy and things like that. So they're talking about it across the board, but they're looking at the economics of it rather than the merits of cases.
Yes. Now, could I take you to CD 11.7, please, which is the Millen-Durdale decision, which you referred to earlier?
Yes.
And could I take you to paragraph 83, please? This was a paragraph which I believe you were taken to earlier, where the reporter is referring to the need to respond to climate change, the urgency and scale of that challenge, and the contribution of wind and other renewable energy in doing so, and that they are all considerably heightened in importance. I agree that, as a material consideration, this increases the value I should attach to the renewable energy benefits of the proposed development. Mm-hmm. However, the reporter goes on to say, however, these benefits still have to be weighed in the overall planning balance.
Yes.
So do you accept that, although the reporter said there may be heightened importance to the need to generate energy from renewables, nonetheless, there still had to be the exercise of balancing out all the competing interests? you accept that?
Yes, I do. I mean, I believe that everything has to be put into the balance.
Yes. And what was the outcome of Millinderdale?
The application was refused.
And why was that, ultimately?
I understand it was largely on landscape grounds, but I'm not...
Yes,
I don't know the full details, but I do know that landscape was involved.
Well, for a point of reference, if we could scroll back up, please, Helen, to paragraph 67. And I'll not take you to this, but it's more just a point of reference for the explanation as to how the reporter got to her determination when
Yes,
she
it was
considers...
to do with the coastal landscape, as I understand it.
Okay, could I take you back to your report, please? And go to paragraph 5.4.11, which is on page 26. And what I'm looking at is a sentence which starts 7 lines down. There's a line which starts with the word recovery. Do you have that?
Yes.
And then in the middle of that line there's a sentence which starts, it is submitted that the reporters and the ministers must attach significant weight to what has happened since 2014, including recent government policy documents and the COVID-19 situation, and reflect what policy now requires. Now, what do you mean by "and reflect what policy now requires"?
I mean the way in which SPP was came out in 2014, it's a document of its time. It is not up to date in terms of the targets it states, for example. And what I mean is that the reporters and the ministers, as the decision makers, need to consider what SPP says. It has some important information, but when it comes to information on targets and things like that, I believe you need to look beyond SPP.
Yes. So if you're looking for the policy, it's to be found in SPP, but targets lie elsewhere. Is that correct? Is that what you're saying?
Yes.
But are you suggesting to the reporters that they should be formulating a policy before seeking to apply it?
No.
So why do you say what policy now requires?
Because I believe that there is policy that towards the onshore wind policy statement talks about the critical role that wind energy and other forms of renewable energy take. And I think documents like the energy strategy, the onshore wind policy and things need to be taken into account.
Yes, they are the policy, but it's those policy documents the reporters should be taking into account.
They need to have regard to, yes.
Yes. Could I take you to page 46 of your report? And could I ask you to look at paragraph 8.2.16?
Yes.
And this is a paragraph where you deal with the spatial framework. And just so we get our bearings on it, because we've not been here before, I'll just read it. It is not disputed that the spatial framework as shown in the MLDP has been prepared in accordance with SPP with one exception. It is understood that the spatial framework includes a 2-kilometre buffer around rural groupings as well as settlements. The inclusion of rural groupings is not in accordance with SPP Table 1, which advises that an area not exceeding 2 kilometres should be applied around towns and cities and villages, with an identified settlement envelope in local development plans only should be included in the spatial framework. Now, as we know, the Murray Local Development Plan went to examination and the reporter produced a report
Yes.
on the plan. Did the reporter not accept that that was an appropriate way to deal with the spatial framework? And in that connection, Helen, if I could have CD 59, please. And hopefully it's electronic page 142. And it's paragraph 32. And did the reporter not say there, about 5 lines from the bottom, whilst the buffers have been established within the spatial framework, more detailed consideration is allowed for within the policy in relation to the impact on local communities. I am satisfied, therefore, that the general approach to the spatial framework follows SPP and a finer grain of analysis would be expected as part of the development management process, as set out within the policy.
That's what it says, and it says the general approach to spatial frameworks follows SPP. It doesn't say it completely follows it. And above it talks about the lack of objection from the Scottish Government in respect of the rural groupings. So, I mean, I'm comfortable that the SPP, that the spatial framework follows the SPP with the exception of the rural groupings, which has been accepted by the Scottish Government, and the reporter finds follows the general approach of SPP.
Yes, but that might be a pedantic point to pick upon that word, is it not? If the reporter was concerned about the way this had been prepared, do you think the reporter would have said that she was satisfied in relation to the position?
I think if she was concerned about it, she would have said something in the same way as she did about the guidance maps 3, 4 and 5. So, no, I mean, I'm not making an argument on the spatial framework and the LDP.
Thank you very much. I have no further questions. Thank you, Ms Sidgwick.
Thank you.
Right. Just looking at Mrs. Black to see if she has any questions.
I just have the one question
Okay.
for you. You mentioned in your inquiry report and also in evidence, you refer obviously to the various ambitious, the international, UK and the Scottish Government targets. Do you have any indication as to whether we're meeting those targets? I'm thinking about specific figures. Do you have that information?
The most up-to-date position that was, I think, covers Q1 of this year was submitted as a document, and I can find that reference for you. It's in document CD 628, which is the Scottish Government Energy Statistics from March 2020, so it's probably the last quarter of last year it covers.
And that's a quarterly report.
It's a quarterly report, and I think there is also, there is also the June one as 623.
Do you have any specifics that you want to highlight from that in terms of the targets?
They're very ambitious targets, and to get to net zero is going to be hugely challenging. And I think we need to be doing everything we can to decarbonise to get to that point. In order for other industries to decarbonise, they need clean energy, and a solution to that is renewable electricity, and part of that is onshore wind. And this development could do a sizable chunk towards that. It's 0.25 of a gigawatt, or up to 0.25 of a gigawatt. It would have a very real impact.
Thank you.
Thank you.
I have a few questions. The first couple are just about cumulative developments, and I just wanted to know the background of a couple of permissions. Highland Council had indicated that the existing permission for Carn Dewey may soon run out. Just what information do you have about the consent status of Carn Dewey?
My understanding is that the consent would expire in October of this year, and to the best of my knowledge, there's been no application to extend that, but I wouldn't necessarily be party to that knowledge.
Okay. And I may have picked this up wrongly, but I think there was a suggestion earlier in the inquiry that Meikle Hill wind farm may not go ahead, notwithstanding being consented. Do you have any information on anything to do with Meikle Hill?
I'm afraid I don't.
Right, okay. Is there any other update on applications or consents that may be relevant to cumulative effects for the proposed development?
I think you're aware of the Berryburn extension application having been in, and to the best of my knowledge, that's the main change in the cumulative baseline.
Now, you were asked about, in section 4.5 of your report, about the Climate Change Committee advice to the Scottish Government. Has there been any response to the Scottish Government on that advice? Has it given any formal response?
Not as far as I'm aware.
And on the Scottish Renewables written evidence to the Scottish Affairs Committee, how did the committee handle that advice? Has it produced its report yet?
Not as far as I'm aware.
Right. And similarly, on the advisory group on economic recovery and the 8 policy packages for Scotland Green Recovery, any response to those from government?
Again, not as far as I'm aware.
Right. Okay.
I understand, though, that the climate change plan from April 2020, which was delayed as a result of COVID, it is going to be out before the end of this year, and that may respond to some of the submissions that have been made.
Okay. Now, I wanted to refer to you to a decision of mine, which you may be aware of. It's the Coolachy decision, and it's CD 11.49. And it's paragraphs, oh, sorry, I've just lost it, paragraphs 146 to 148 of that decision. Now,
Can the witness read?
oh, of course, yes.
No,
If you want to take a moment to read that, that's
I
fine.
can see the screen.
You might want to read the few paragraphs that go before that as well.
Could I have a hard copy of it? It would make my life slightly easier.
Yes,
That's okay, please.
I'm afraid mine scribbled all over.
Oh dear.
We'll get a clean one.
Thank you.
Thanks.
Was it in one of these? Sorry, Thursday. Thank you.
That's great. I'll just give you a few moments to read that.
Okay, yep.
I really just wanted to ask, but perhaps focusing on that last paragraph, 148, I took the view, I'd found that there was an emphasis on continuity of support for growth in onshore wind and continuity of protection in the environment in the Scottish Energy Strategy and onshore wind policy statement. And as I say, I took the view that neither the renewable energy targets or anything else in the Scottish Energy Strategy or onshore wind policy statement alter the balance of a planning decision further in favour of onshore wind development than the support already accorded to such development when it is in the right place. Now, I certainly won't take it amiss if you just say I was wrong, but I was just looking for your response to that.
I think in considering the balance, you have to look at each application on its own merits, and I think you have to consider in the case of Gour where you find that balance lies in your reporting to ministers. And in the case of Gour, I believe that there is significant policy support for it in terms of the renewable energy and onshore wind policy.
That's fine, but that doesn't really answer my question, which is it's really about how those documents are interpreted and whether there is in fact increased support. And I took the view that there was already strong support for onshore wind development, but do those documents represent increased support on top of that and concomitant, and perhaps I think as was suggested to me, a concomitant reduction in environmental protection. Well, maybe that's not fair. I don't think that was suggested to me. But if there's increased support for onshore wind, does that mean that there's a concomitant reduced level of environmental protection? So that's two questions, I think.
I think those documents do give very strong policy support for renewable energy and for onshore wind as part of that. And I think that real weight must be attached to them in the decision-making process, but not completely at the expense of environmental considerations. And I think that's where the balance has to be struck. I note that the decision date is 2018 of this, so we're two and a bit years on from that, and I think it's becoming increasingly clear that there are big targets and challenging targets, and if we're to get there, we've really got to keep going.
Mm-hmm. Okay. I suppose related to that, you'd referred to onshore wind as an important part of the renewable mix. Is there any policy or guidance that directs us to how important in future from here the contribution of onshore wind is required to be by government policy?
There are references in the onshore wind policy statement to it being vital and a crucial part. Now, those were at the end of 2017, but I believe that they remain crucial and vital.
Okay. Now, I wanted to ask you a question about what I think are maybe different approaches taken by Mr. Welsh and Mr. Denny. I'm afraid it's something I'm puzzling over simply because I think we probably need to deal with it in the report. Now, if I can just show you, take you to, it's Mr. Welsh's report at paragraph 220. It's essentially a question about how we're to deal with landscape accommodation of onshore wind development. So it's CD 14.1 at paragraph 220. just give you a moment to look at that before.
Yes.
Right. So Mr. Welsh is making a judgment of the proposed development's acceptability, and he says at paragraph 220 that this means, in landscape and visual terms, slightly foreshortening it, the professional judgment by experienced landscape architects of the ability of the landscape or visual receptor to accommodate the proposed development. That's what acceptability is. That's what it means, as I understand. So he's commenting on in terms of acceptability, he's commenting on the capacity of the landscape to accept proposed development. So I understand that as there being a certain capacity innate in the landscape to accommodate things, to accommodate onshore wind development. Perhaps I'm wrong in that.
I think what Mr. Welsh is doing here is considering whether or not in landscape terms he thinks the development is acceptable. I know that some landscape architects don't take that step of acceptability. They talk about the significant effects and that kind of thing. But Mr. Welsh, I think, consistently over a number of years has given a view on whether or not in landscape terms he thinks it's acceptable. And I think he's doing that in the round. So he's thinking about all the landscape issues and things, and he's thinking about what his view on that is, and it's a professional judgment.
Yeah. Yes, no, indeed. I just wanted to have a look. I don't know how far this contrasts, and I'm sorry this is slightly sprung on you, so it's not. It's CD 15.1 and it's paragraph 5.19.
15.1.
Oh, you don't have a copy of that? No?
I don't have a hard copy of
All
Mr.
right.
Denny's report,
Yeah.
but I can read it on the screen.
Well, what I'll do is, while Smith is getting that, I'll just read it to you. And,
Okay.
So what he says, paragraph, and maybe it'll come up on the screen in a moment, is 519. It's not Clash Gour. It's CD 15.1. Yeah, that's the one. Right. So this is where Mr. Denny deals with the issue of capacity of the landscape. So he's saying, well, I'll leave you to read it.
I think Mr. Welsh is taking.
Sorry. Go ahead and say what you're going to say if you're just responding directly to that paragraph. But I do have three questions, which I can perhaps if I tell you that my three questions,
I'll try and answer them.
you can consider them as
Yes.
your, yeah. So my first question was whether Mr. Denny's saying the issue of capacity of the landscape to accommodate the overall number of operational, consented and proposed turbines is a matter of judgment for the decision maker as each scheme comes forward for determination. It's a decision which should take account of the wider benefits and harms of each proposal and be considered within the overall planning context for renewable energy. And I wondered if these two positions, so if Mr. Welsh's and Mr. Denny's positions are compatible, and if they're not, which we should prefer, and if it's Mr. Denny's position, then how are we to determine, as a matter of planning context, how much renewable energy the landscape can accommodate? Actually, I'm just thinking, I maybe haven't thought of something. So I'll give you a moment to think about those 3 points, but I'm just wondering if I've been completely fair in putting that to you.
So I think you're rather asking my witness to guess what was in the mind of Mr. Denny, which may not be entirely fair.
So just give me a moment. No, not that one. Ah, that's it. Ah, yes, sorry, scrolling back. Of course, this is in the context of overall combined cumulative effects. I'm sorry. I should maybe have thought about this a bit further. I don't think it's quite the same thing that Mr. Welsh and Mr. Denny were talking about.
I don't think it
yeah.
is.
No, sorry. I'll obviously just need to think about this a bit more. I'll take that back. Right. Right. Okay. Yes. And so, sorry, I'll just move on from that question. Now you're asked by Mr. Trinick in examination in chief about the potential for should an application be granted, the potential for its change by condition. So alteration of a development by condition should permission be granted. So for for instance, the removal of a grant of permission with subject to the removal of turbines, or something along those lines. And that's obviously been an issue in this inquiry in respect of there's actually a proposal from for alteration of one of the developments. Indeed. By condition should the original proposal not be accepted. So there's been a bit of discussion of that earlier in the process.
Just to be clear, my answer
Sure.
to Mr. Trinick would only apply to Clash Gour. I can't.
No, indeed. No, I wasn't going to ask you about any other developments. No. As I understood your answer, it was you were saying you would have to know what was proposed. Well, perhaps I better not try and characterise your answer. I'll go straight to the point I was going to make, which is Mr. Welsh had, in his evidence, as I understood it, regarded the proposed Clash Gour development as, in landscape and visual terms at least, as 3 separate extensions to the Berryburn development. And I'm asking this simply because I want to understand the scope of Minister's options. I'm certainly not saying this would be our recommendation, but I wanted to know if one of the sort of 3 wings of Clash Gour, if permission were granted subject to a condition, could it be granted subject to a condition? Sorry, I'll slightly. I think there's a planning judgment to be made as to whether a development granted subject to a condition, removing one of the wings of Clash Gour, say the south or the east, would that be in substance the same development as the original proposal, as proposed?
No, I don't think it would, because I think if you were to remove one of the limbs, if you like, or one of the clusters, you would need to look very carefully at what else that affected, how it interacts with some of the things like the habitat management plan and that kind of thing, and you would need to look at and understand the knock-on effects and ensure that there weren't unintended consequences.
Right. What might those be?
Well, if you're sort of from certain viewpoints, positions may change and things. You may not see some turbines in the context of other turbines from certain locations and things like that. You would also have to look at the approach to the habitat management. What may or may not still be required. The access management plan, the forest plan, how those all may be affected. I mean, I'm not saying they would or they wouldn't, but you'd need to understand how they may be affected.
Right. Okay. No, I think I understand that. Okay, good.
And looking at that, the bigger picture rather than just the detail of the removal of one bit, looking at the project as a whole and what does that mean.
Right. Okay. Great. Well, thanks very much. That's very helpful. Mr. Trinick.
Thanks, sir. Just a couple of points, if I may. Two points. You were asked questions by Mr. Brown about CD 520, and perhaps that could be brought up on the screen. And Helen, it's the last page of the annex. Second last paragraph of the whole document. That's the one. And Mr. Brown took you there, and he fairly acknowledged that onshore wind is referenced in that paragraph. What does the last sentence tell you of that paragraph?
That the acceleration of these projects, including onshore wind, should be a priority.
Thank you.
They are at the front.
I always hesitate before re-examining other reporters' questions, but my apologies, Mr. Seaton. Mr. Seaton took you to CD 1149, the Kalaki decision. He's treading on my private grief by doing so, but looking at paragraphs 146 to 148, would you go to your inquiry report, please? If we go to paragraph 432, on page 10, we can record the Climate Change Committee report, the Net Zero report as it's known, and the advice of the Scottish Government, which is recorded in 433. We can also record, I couldn't find it in your report, but it's in Mr. Bell's report at 2314, don't go there, where we discover that net zero has been set into law in the UK in June 2019. Set into law. If we go back to your report at 436, the Green Finance Strategy, was that published by, is it published at HM Treasury? Is that published by government? And it says what it says. You recorded what it says. At 4316, the Climate Change Committee Progress Report, Government 2020, dealing with COVID, time to act, etc. It says what it says. Go to 457 of your report, please. This June 2020 report from the Advisory Group on Economic Recovery, is that an advisory group to government, to Scottish Government?
Yes.
It says what it says, and then we have at the bottom of the page the climate emergency, and 463, the First Minister declared the climate emergency. Maybe just read 463 for us.
In May 2019, the Scottish Government declared a climate emergency, and in a speech to the Scottish Parliament, the Climate Change Secretary stated, "The Climate Change Committee has been stark in saying that the proposed new targets will require a fundamental change from the current piecemeal approach that focuses on specific actions in some sectors to an explicitly economy-wide approach. To deliver the transformational change that is required, we need structural changes across the board to our planning, procurement and financial policies, processes and assessments. And as I've already said, that is exactly what we will do.
And 464, please.
She went on to say that, subject to the passage of the planning bill at stage 3, the next national planning framework and review of the Scottish planning policy will include considerable focus on how the planning system can support our climate change goals.
What does all this tell you about any change of pace, any change of trajectory since SPP 2014?
It's being ramped up.
Would you say that ramping up is a matter of government approach and policy?
Yes.
Thank you.
Good. Thank you very much, Mr. Sedgwick. We'll move to Mr. Steele's witness next, but we'll need to, I think, take a break to allow to allow a changeover. Should we have 15 minutes?
Indeed, sir. If we could have at least 15 minutes to change over and get Mr. Bell ready.
At least 15 minutes. Would you prefer a wee bit longer?
Well, I think we would. A number of issues that have arisen I'd quite like to discuss with Mr. Bell.
Okay.
Perhaps 20 would be absolutely ideal.
20 would be fine. So 10 to 12.
Perfect. Thanks, sir.
Ms. Steele.
Thank you, sir. My next, indeed last witness is Mr. Bell. Mr. Bell, are you ready, settled and raring to go?
Yes, thank you.
Good. If you could just make sure you master that microphone, neither too close nor too far, bearing in mind you're being live broadcast as well. Mr. Bell, could we look please at your precognition? And we're going to take large parts of it as read, but could you, by way of introduction, read 111?
My name is David Campbell-Bell. I hold a first-class Bachelor of Science honours degree in Town and Country Planning from Heriot-Watt University and a Diploma in Urban Design from the University of Strathclyde. I'm a corporate member of the Royal Town Planning Institute and the Chartered Institute of Highways and Transportation.
Could you then go to 124 and read 124 and 125, please?
The onshore wind policy statement sets out the urgent need for onshore wind. The technology was already viewed and described as vital to the attainment of targets in 2017. This imperative has only increased since a climate emergency was declared by the Scottish First Minister in April 2019, and in line with the recommendations made by the Committee on Climate Change Net Zero publication in 2019. The policy statement also makes specific reference to the move towards larger and more powerful, i.e. higher capacity turbines, and that these by necessity will mean taller towers and blade tip heights. Notice was therefore given of market reality and evolving technological change and the benefits larger turbines can bring in terms of energy yield and consequent larger contribution to targets.
Could we then turn and read paragraphs 1 to 11, 12 and 13, please?
The considerable socio-economic benefits that would result from the proposal are now of particular importance, given the unprecedented current economic crisis and expected recession in Scotland and the wider UK. And in fact, it now is a recession. The letter from the Chief Planner, dated the 3rd of April of this year, is clear in stating planning has a crucial part to play within and beyond the immediate emergency, and makes reference to the planning system's critical role in our future economic and societal recovery. The importance of the economic benefits arising from the proposed development cannot be underestimated in today's circumstances. The Office of Budget Responsibility has set out clear warnings this year that unemployment in the UK is likely to rise beyond levels seen in the 1980s as the nation struggles to regain its pre-COVID-19 virus footing. I've also made reference in my inquiry report to the recent advice to the Scottish Government from their advisory group on economic recovery and from the Government's Climate Emergency Response Group. A key recommendation is that there is an economic and environmental imperative to seek to deliver projects that can contribute to the economic recovery and indeed which can make a positive response to the climate emergency. The proposed development can make a valuable contribution on both counts.
And turn, please, to your overall conclusions.
It has been demonstrated that both the original development and the alternative accord with local and national planning policy, and that there is a substantial need for this type of development in order that future targets in relation to the global heating crisis and renewable energy generation and greenhouse gas emission reductions can be met. It cannot be business as usual in a climate emergency context, and there needs to be a notable shift in the planning balance. Not to grapple with and embrace the clear new messages of net zero would be to fail to take what is happening so fast in public policy seriously. The renewable energy policy framework remains an extremely important consideration. It is, of course, not an overriding matter, but it is one that should attract very significant weight in the balance of factors in the determination of the application. Any suggestion that the climate emergency does not give rise to an urgent need for action, simply because as yet planning advice and guidance has not been amended, would, in my opinion, be misguided. It is wholly legitimate for the planning system to take into account updated and emerging issues as material considerations in arriving at a decision on a proposal. The applicant does not suggest that the factors to be considered and the basic approach should not follow SPP. Rather, it is the weight that one can attach that is altered by the new reality. The overall conclusion reached is that the development satisfies the terms of Schedule 9 of the 1989 Act, taking into account other policy considerations, including the relevant development plan policies. On this basis, it is respectfully recommended that Section 36 consent and deemed planning permission should be granted for the proposed development. It is considered that the original proposal was acceptable. However, the additional information offers an alternative proposed development which could be secured by condition in the event that the reporters are not persuaded as to the acceptability of the original proposal.
Yeah. Mr. Bell, I've got a few additional points, but can I just remind you to speak right into the microphone? You were dropping away from it there. So a few additional points, if we may. Can I ask about what weight you say should attach to the locational guidance that exists within the supplementary guidance, and how often have you seen such locational guidance?
I think in my experience throughout Scotland, it's an essential component of a supplementary guidance document is the spatial framework, and we have that here. And the documents are often linked to a capacity study, as is the case here. However, the supplementary guidance contains very location-specific spatial guidance that goes beyond the Group 1, 2, 3 zonings on wind farm extension areas and for the turbine typology that we're looking at. In my experience, it is very rare to get such specific locational guidance. But clearly it's going through its process with the committees in the Council at the moment. But, as I say, it's rare to get that, and in my view, both the proposals, the original and the alternative, accord with that spatial guidance for the reasons I've set out, and also for the reasons Mr Denny has set out in his evidence.
And what, from a planning perspective, what weight, if any, do you think should attach to that locational guidance?
Well, the supplementary guidance has fallen away. I think there's agreement with that. Its statutory status is gone. So from a planning technical point of view, there is clearly less weight to the supplementary guidance. However, the landscape capacity study holds good. It's technical guidance, and I think it would be fair to still afford that moderate weight in terms of the supplementary guidance and the related capacity study.
And you heard evidence, Mr Bell, that the capacity study was the culmination of, I think, about 20 years' work by a number of landscape architects. Does that reinforce you or otherwise in the view as to the weight that should attach to it?
Yes, I mean, I heard the exchange with Carol Anderson and the longevity of the large corpus of reports that there is there supporting this locational specific guidance. So I would say, taken together, that significant weight should be afforded to that clear direction for this part of Moray.
Now, related to that point, there has been a suggestion that we are either within or out with the line that has been drawn. Do you have any comment on that? Mr Bell, please.
Yes, I think firstly, as chartered planners, we like dealing with lines on maps because we usually know what policy applies within or out with. And I think there is a need to be clear on what the line on the map means here, put simply. We know the source is the capacity study, and generally speaking, these are helpful documents in identifying a strategic approach and overall guidance, and then a more detailed landscape and visual impact assessment follows at the project level. But we should not be treating the capacity study as if it was zoning areas for development in the same way, for example, as a housing allocation or whether one was within or out with the town centre for development management policy application. So it shouldn't be precise or prescriptive. And I think there was consensus amongst the landscape witnesses to that. And in fact, I heard Mr Steele say yesterday that the line was indicative. So I don't think...
is your position consistent with Mr Steele and Ms Anderson that the line is an indicative one and that this is strategic guidance?
Yes, that's very fair. And in this case, the proposals lie predominantly within the identified potential development area for extensions and repowering. And that is a matter that I think should be afforded significant weight. And as I say, it's rare to get that level of specification within a capacity study and related supplementary guidance documents. So from an SPP perspective, I would say, this is the right location. The question is it the right development? Our position is, yes, it is.
Well, on a related point to the line, questions arose as to a small number of turbines, whether it was 3, 4 or 5, I'm not absolutely certain, which were either on, touching or straddling the line. Do you have any comments to make in relation to those particular turbines, Mr Bell?
Yes,
it's a related point, obviously, to the last point.
Yes, I heard the exchange, particularly, I think it was the Mr Denny's evidence, and what I took from that was that, firstly in terms of landscape and visual considerations, that the removal of 5 turbines that was floated as I think just as a general proposition, turbines 5, 9, 14, 13 and 25, I think were referenced. that it was only at one viewpoint, viewpoint 18, Black Sports Bridge, where there would be a recalibration in the significance where that would potentially drop down from being a significant effect. But Mr Denny did make the point that there would potentially be other landscape and visual consequences, and he also referred to a reduction in benefits, and clearly that falls to me to consider in terms of that particular matter.
Well, great play was made of that particular viewpoint by the Council, but I think it's now accepted, or was accepted by Mr Steele yesterday, that at that viewpoint 18, only two hubs are visible if one looks at the montage. I don't think we need to look at that again. But if that is the case, Mr Bell, do you have any comment about the appropriateness of considering 4 or 5 turbines, even if that was a good approach?
I think that was in respect of the alternative proposed development, wasn't it?
Indeed it was, sir, yes.
Put simply, I think the planning balance falls clearly in favour of retaining those turbines, and I've got various reasons for that. I think, firstly, from a viewpoint perspective, the notch in the trees, when viewed from the parapet of the bridge, is not representative of that immediate area, insofar as there are various other activities going on that was explored in evidence, such as the Speyside Way, fishing, kayaking activity, and so on. So, in my view, the planning harm that would arise from that visibility would not justify the drop in benefits. And in that regard, I think there are particular comments in terms of the wind resource and viability that's important to refer to.
Well, we'll come on to the wind resource in a moment, but so far as the importance of the viewpoint is concerned, firstly, is it representative of the Speyside Way?
No.
Secondly, is it representative of people fishing, or the fishing hut that we can actually see on the right-hand side of the montage, and no doubt at the site visit at lower level? Is it in any way representative of the fishermen?
Not for those activities themselves, no.
And the width of the road and the configuration of the road, both north and south of this viewpoint, will have been seen and can be seen at a site inspection as to what might be the view taken from or by a driver or passenger. Is that so?
Yeah, I mean, it's very limited. It's very narrow footway. You really have to press against the parapet if there's vehicles coming for safety, and indeed, if you are in a vehicle, there's very limited forward visibility on approach to the bridge, and given it's so narrow, that is the concentration in terms of being in a vehicle.
Well, can I just ask you this then, Mr Bell? If one was driving a car across this rather narrow bridge going in a northerly direction, what do you think the prospects are of you catching a glimpse of the viewpoint that the Council have been asking about?
Well, a driver would be focused on the road ahead because of the limited forward visibility. Is a vehicle, for example, going to come over the bridge at the same time? And any passenger would probably be looking out the left-hand window going north, which is an unimpeded view over the Spey Valley.
Well, in any event, what importance is there in relation to these small number of turbines from the wind speed and capacity? Do you have any comment about that?
Yes, I do. I think Chapter 3 of the EIA report, this is volume dated February 2019, sets out the design approach, and a key consideration is the wind resource. I mean, this is a wind farm. It is not a sculpture park in the landscape. So catching the wind resource is a fundamental siting reason. Now, clearly there are various other design considerations that come into play. But having discussed the wind information with the Fred Olsen advisory and analytics team, it's quite clear to me that the turbines at the front edge of the scheme and those
Now,
that...
when you say the front edge, do you mean the southwest edge of the scheme? Just to be quite clear what you're talking about, Mr. Bell.
That's correct.
And can you give me the turbine numbers that you're talking about, for the avoidance of any doubt?
So from the evidence exchange, I heard it as turbines 5, 9, 14, 13 and 25. These would be the turbines with the highest capacity factors on the site, i.e. they would generate the most renewable energy from the scheme. And therefore, if one looks at the overall gigawatt hours output that would result from the project, just to give a comparison, the original development figure is in the order of 446 gigawatt hours. The alternative development reduces that to 294. This is per annum. And taking those 5 turbines out, we'd have a further drop to 242.
So just to take these figures again, the original OPD 446, the smaller scheme APD 294,
Yes.
and if we took the 5 turbines out, that would drop to 240 or 242 to be more accurate. Is that correct?
That's correct. That's correct. That's based on the turbine modelling that has been undertaken. So there are other factors. So related to that is viability. Now, it would clearly make the scheme more challenging to deliver because there are certain costs that remain the same. The grid cost remains the same. And in broadly other infrastructure costs. So the energy output falls, but the commercial return falls significantly.
So does it really come to this, Mr. Bell, that in relation to viewpoint 18, if that be the critical one, as Mr. Denny said it was, one might remove the view of 2 hubs, but one would drop disproportionately the generating capacity of the proposal. Is that correct?
Yes, that is right. And my conclusion from a planning perspective on that is that avoidance, if you like, of some level of planning harm would be demonstrably outweighed by the additional benefits overall.
Now, on a related point, there seemed to be suggestions made yesterday by Murray Council that all would be well if we moved the turbines in a generally, or moved certain of the turbines, not quite clear the position, in a slightly northerly direction into the slightly lower area of ground. Do you have any comment about that approach, Mr. Bell?
Yes, I think, certainly building on some of the points that Ms. Sidgwick talked about in terms of the various considerations that go into the design approach. Again, I would reference the reporters to Chapter 3 of the EIA report, that's Volume 2, Site Selection and Design Evolution, that references matters such as access, ecology, ornithology, hydrology, telecoms links, water courses, rights of way, and so on, and SSI presence. And in particular, when Figure 3.1 is looked at in the report, one can see the concentration of water courses that to the north. So there are various constraints that have given rise to the layout, but also in terms of fundamentally the wind resource.
Well, let me just ask you a little bit more about the wind resource, but towards the middle of the hatched area, does the wind resource increase or decrease, and what might be the practical effects if the suggestion that seemed to be getting made by Murray Council was that turbines should be located or relocated there?
Well, that is the area that has generally the lowest wind speed. So there are clear consequences for the level of output and the benefits that would result.
Well, what I'd like now to ask you more generally, what you make of the attempts that were made or suggested to attempt to redesign our wind farm yesterday at the hand of Murray Council. How long has it taken our mutual clients to get to the stage of these finalised designs and layouts, approximately?
Several years, it's clear from the documentation in preparing the
does a figure of about 10 years seem about right?
Yes, indeed.
Yeah. Do you know, in terms of approximation, how much it might have cost them to get to this stage of appropriate designs suitable to be discussed at an inquiry such as this?
I won't give exact figures, but substantial investment in development costs.
Are we in the six-figure region or seven-figure region?
Certainly a seven-figure region.
Yeah, exactly. Now, as things currently stand at the moment, there are no grants or subsidies available for onshore wind. Is that correct?
That is correct.
Yeah. Secondly, has there been declared to be a climate emergency?
Yes, there has.
Now, given that it was accepted very properly by my namesake, Mr. Steele, yesterday, that he had no knowledge whatever of the wind flows or the resources, what do you make of attempts by Murray Council to try to carry out some redesign of our wind farm by apparently moving or suggesting moving turbines in a northerly direction? What do you make of that, Mr. Bell, after all that we've done to get where we are?
Well, it's simply unreasonable to put forward an alternative design approach, just not putting aside the evidence in chief position, but on the hoof, so to speak, when it's clear from the documentation that there are numerous considerations that go into play through the iterative design process to arrive at a balanced solution that takes into account all relevant considerations.
Well, let me just ask you one final question on this to spare further embarrassment to the Council. How could you possibly try to design a wind farm when you've got no knowledge whatever of the wind resource?
It is a starting point. It is an essential element of information to understand, is this a resource where the technology can work.
Right. Let's turn away from that then. Shared ownership and community ownership, comments on that, please.
One of the other consequences of reducing one of those turbines, those turbine numbers, is it would simply reduce the amount of opportunity that there is for the shared ownership opportunity. So that is another consequence of reduction.
Noting all of that, Mr. Bell, and noting the questions that were asked earlier of Ms. Sidgwick, do you think in our case, when it's a relatively small number of turbines that might be involved, that notwithstanding your position on the merits, that it might or might not be possible to condition out a turbine or two if, for whatever reason, that was thought appropriate?
Yes, I think if that further step was needed, I think in this case the project would remain substantially the same, and that could be done if it was deemed necessary.
But do I understand your primary position to be that it is not necessary, would not be reasonable or proportionate in all the circumstances that we've outlined?
Yes, for the summary reasons I've just given.
Yeah. Climate emergency, Mr. Bell, and the new policy, what approach do you take to that? What evidence do you give us in relation to that, please?
I think my evidence sets out that in detail. The additional document that is new, that came in after my inquiry report and proof were complete, is the Programme for Government document, CD 15.39. It's been covered at length this morning already, But it's quite clear in this that the government's position is that the economic recovery is a new national mission in terms of employment creation. And they say it must be a green recovery. So it's not simply an objective, it is termed as a national mission. So I think that needs to be noted.
And what weight do you say should be attached to that, given the economic crisis, if not depression, in which this country has been plunged?
Well, I think as I've set out, I mean, in my career I've experienced the recession of the early 1990s, the early 2000s with the dot-com crash, and then the financial crisis, but this is by far more serious. And in terms of the town planner's response to economic recovery and regeneration, it will be critical. The government has made that clear through the Chief Planner letter this year. And I think for rural areas, in particular, renewable energy is a key sector that needs to be at the heart of the strategy going forward in terms of that national mission.
You talked about the Chief Planner's letter. Do you have any further comments on that at this stage, Mr Bell? That's CD 14.29.
Yes, just another new matter. This is the 4th of September Chief Planner letter. Just reinforcing the point that although there are proposed changes to SPP arising from the Gladman decision in the Court of Session, that it doesn't change the government's commitments to delivering renewable energy projects, and that relates to the presumption in favour of development that contributes to sustainable development. So just an important clarification point from the government that we need to take into account.
Well, drawing all of these points together, what weight do you think should attach to the fact of the economic crisis that's facing us on the one hand and the climate emergency on the other? What weight should attach to them in the decision-making in relation to Rothes 3?
It is very clear from the range of advisory documents that have come forward to government this year that green recovery and economic recovery go hand in hand. That is the clear, unambiguous message that has now been reflected in the programme for government. That is the signposting of policy direction. And it is clearly, in my view, material in terms of both of these matters. The global heating crisis and the economic crisis together must go to the matter of the weight that is attributed to benefits of a development.
Fine. Thank you, Mr Bell. No further questions at this stage. Thank you.
Mr Brown, are you content to start now?
Yes, thank you, sir. Mr Bell, good afternoon.
Good afternoon.
You've obviously had the benefit of listening to Ms Sidgwick's evidence earlier today, so perhaps it might not take as long to cover your cross-examination. If we were to look at the Scottish Energy Strategy, which is CD 611, are you happy? I'm quite happy to go to the relevant places in the document I looked at with Ms Sidgwick, but are you happy to agree that this document looks at a number of renewables, namely wave, tidal, solar and wind?
It does.
Yeah. And do you accept that it states that all renewables will have a role to play?
It does, but it goes much further in terms of onshore wind.
Yes. But would you also accept that it still recognises that there is a requirement for the right development in the right place?
Yes.
Yeah, and that it can be done and it has to be done in a way which is compatible, or should be compatible, with Scotland's magnificent landscape?
As a generality, yes, that's fair.
So landscape is still a relevant consideration under this strategy document?
Yes, of course.
Yeah. And if we were to read through the document in more detail, again, I'll not take you to it, but it covers onshore wind, it covers offshore wind, it covers island wind, wave and tidal energy, solar and photovoltaic panels, bioenergy, hydropower. So, sorry, would you like me to run through that list again? I see you're noting it down.
Yes, it does, but I think we need to recognise that this document was published at the same time as the onshore wind policy statement. So the government prioritised onshore wind in terms of policy statement publication. And it's, one point that was missed in the exchange this morning is that in terms of the document, in terms of strategic priorities, this is on page 69, it refers to the various technologies, but in particular onshore wind and offshore wind, and goes on to say with onshore wind that the priority is to implement the onshore wind policy statement, which underlines the continued importance of this established low-cost resource. Okay. Just to finish, what I would say is an important point in answering you is that I'm very involved in solar projects throughout the UK, but also tidal projects, and there is not the same language around the imperative and the vital contribution that these technologies could make to targets.
Okay. Well, fun enough, I was going to move on to look at the onshore wind policy statement, which is CD 610. Now, you said that the government treated onshore as the main source of renewable energy, hence the reason why we've got this policy statement. But does this policy statement not still recognise that the landscape has to be considered in connection with any development?
Yes, of course it does.
Yeah, and in particular, if we were to go to paragraph 24, 25 and 25, we see clearly there that in paragraph 24, the technology shift towards larger turbines may present challenges when identifying landscapes with the capacity to accommodate larger scale development, as not all will be suitable. Do you see that? So, although the government might be saying that it wants to focus on onshore wind farms, it is recognising that it might not be possible to do that in certain locations.
Yes, as a general point and as a specific point, this is a landscape in terms of the supplementary guidance that has been identified, reflecting this very point of this paragraph.
Yes, but when it comes to considering the landscape, I think you were happy to accept that we're talking about strategic guidance and every case has to be approached on its own merits on a case-by-case basis.
Yes.
Yeah. And in paragraph 25, there is recognition that the way in which wind turbine technology and design is evolving will require potentially the delivery of large wind turbines in landscapes which are judged to be capable of accommodating them without significant adverse effects. So again, that's recognising that the landscape consideration is still relevant.
Yes, it is.
Now, with regard to the programme for government, do you also accept that there is no specific reference to onshore wind in that document?
Yes, I do. But you know, what I don't accept is that that means that the government's approach is that onshore wind is therefore unimportant. And I think that if that is the council's approach, then it's entirely misguided by that proposition.
And is there anywhere in this document where the government considers the planning balance exercise which has to be carried out in relation to applications for permission for wind farms?
No, this is simply not the role of this document. This is simply the programme for the next session of Parliament. It's not going to go into planning policy.
And if I can take you to your report at page 17. From page 17 through to, sorry, I'll wait till that's brought up. From page 17 through to page 20, you look at 4 documents which we've touched upon already. The first is the Climate Change Committee response to Scottish Government on advice for a green recovery in May 2020. The second, on page 18, is the Scottish Renewables Evidence to the House of Commons, Scottish Affairs Committee inquiry into coronavirus in Scotland. The third is the report of the Advisory Group on Economic Recovery, June 2020. And the fourth is the report of the Climate Emergency Response Group to the Scottish Government. Now, would you also accept that these are advisory in nature and that none of them represents Scottish Government policy?
Yes, I think that's very fair. But what I would say is there can be no doubt about the message coming through consistently in all of these documents.
Yes, well, could I'll not take you to the documents other than CD 524, which is the report of the Advisory Group on Economic Recovery. Yes, thank you. And can we accept that this document arises in the context of the Scottish Government being keen to ascertain and develop ideas as to how the economy could be recovered?
Yes.
Yes. And when you were talking about the need to deal with the economy in light of the pandemic, you said that renewable is a key sector which needs to be at the heart of the strategy. And I think you went as far as suggesting that that would be appropriate for Murray. Now, when it comes to deciding the regional response to the need to develop the economy, is it not reasonable to think that different regions will present their own opportunities and they will not be uniform across Scotland?
Within a national framework, I think it's, yes, reasonable, depending on the particular sector opportunities that local authorities have. And I would expect that to come through to a large extent in planning policy and guidance and in decision making and in economic strategies that may be drawn up potentially on a local basis.
Yes.
But not departing from the national framework.
No, we can't depart from the national framework. I'm not suggesting that, but what I am saying to you is that, and I think you've answered the point, that you would accept that regional bodies may develop their own strategy for recovery according to the resources which they have locally. Would that be a way to put it?
Yes, I don't think we've seen any yet.
Yes. But for all you know, the Council could be working on this in the background.
Well, we'll hear from that from Mr Templeton shortly, I think.
And if we think about Murray, is obviously part of the whisky. There's the whisky trail within Murray, there's the natural beauty of Murray, there's tourism, and there's recreation. Would these not be sectors which Murray could explore with a view to developing plans as part of the economic recovery package?
Well, I would be, they could do. I would be very disappointed if what I might call a vanilla approach to dealing with this economic crisis was simply to rest on landscape and whisky. I think I was quite taken aback when I did see the Murray economic strategy that I think was drafted a couple of years ago that doesn't mention renewables or really climate change at all, despite what we see in SPP about the drive to achieve a low-carbon economy. And whilst it's admirable to build on the strengths of food and drink in Murray and landscapes, there is an active energy sector as part of the economy with a supply chain that is active. And my own opinion would be that it would be remiss not to advance the sector of the economy that's clearly got hundreds of millions of pounds of investment ready to go. If one was to take Gour and Rothes 3, that is the figure for Murray.
But as you've said there, that's your opinion.
Indeed. Well, I'm giving my professional opinion to this inquiry.
Yes, indeed.
You've asked me about whether it would be valid to devise an economic strategy based on whisky. What I would say is that if one goes to the Macallan Visitor Centre, where there's been many millions invested, one gets a view of Hill of Towie. And I think what's been demonstrated is that that important sector of the economy can go hand in hand with an expanding renewable sector without undue effect on the tourism economy, which we've heard from other witnesses on.
Mr. Bell, do you accept as a principle that there is a limit to just how, or there may come a limit as to how many wind farm developments an area can accommodate?
Yes, I think that is fair. A judgment has to be taken at some point. But here we're dealing with a position where the Council has identified where additional development should go.
Yes, and I think we've had that discussion that you accepted that it's a strategic document and each case has to be determined on its own merits.
Indeed, yes.
Now, if we go back to having a look, please, at this document towards a robust, resilient, well-being economy for Scotland. And could I ask you to look at paragraph 511, which
Sorry, could you just give me the CD reference?
CD reference number is 524. And I'm proposing to go to paragraph 511, which is on electronic page 49.
Yes, I see that, thanks.
Yes, and paragraph 11 here talks about the prioritisation and delivery of green investments. So we can take it that the document has identified the green investment area as a potential for growth. But when we look through, if we were to go to the next page, and if you could continue to scroll down, please. Sorry, if you can just come back a bit. Thank you. Sorry, it's that paragraph just in the bottom left, Helen. I'm trying to see in full if I could. Thanks. Now, it does say, in fairness here, that there is also now an opportunity for Scotland to lever some of its natural advantages. The almost limitless quantities of renewable energy potential from wind, wave and tidal power can be used to generate electricity surpluses. So, again, we see from that, do we note that although it refers to wind, it's also referring to wave and tidal opportunities?
Yes.
And it then continues by saying that there's the potential to generate green hydrogen to use in the heat and transport sectors. Do you see that?
Yes, I do.
And it goes on to say that the geology of the North Sea in combination with the pre-existing pipeline infrastructure leaves Scotland almost uniquely placed to become a centre for the transport and storage of carbon captured from combustion processes, etc. Do you see that? So, again, would you accept that although there is reference to wind, it is a reference within a context of other opportunities which might exist? Do you accept that?
Yes, I do. I think the green recovery will potentially accelerate various technologies, including particularly how the government deals with decarbonising heat, space heating in buildings. And also, interestingly, hydrogen there. Now, wind farms play a role in hydrogen because there are various projects at the moment being examined which look at the generation of hydrogen from wind. So I did note in the draft regional strategy that a hydrogen corridor has been identified running down through the Spey Valley, which could indeed take advantage of electrolysis opportunities to provide green fuel to address the big deficit in decarbonising transport. Yeah. Well, so I would just suggest that based on that, there is a great opportunity for Murray to drive that forward.
Well, if we were to look at the previous page, having mentioned decarbonisation, sorry, if you can just get me the last paragraph, Helen, in that. We see in the paragraph in the bottom left reference to building on the work of the Infrastructure Commission for Scotland and the Just Transition Commission. They should cover detailed plans for green transport infrastructure, carbon capture and storage, energy generation and storage, hydrogen, heat decarbonation, land use, and so on. So again, when it comes to considering the green recovery, this is thinking about it in the broadest of terms. Would you agree with that?
I absolutely do agree with that,
yeah.
But it's not at the expense of onshore wind. They all have a role in terms of the various aspects of moving to a net zero economy, whether that's, as you highlight, transportation, decarbonising buildings, as well as generation. The advice to government is that energy demand will double by 2050, and the CCC has said that there may be a need to quadruple the supply to meet the various aspects of decarbonising transport and buildings, as well as what they're talking about is deep electrification, where all aspects of society will move from fossil fuel to deep electrification, and that will mean generation of various types of technologies.
But although this document may touch upon the green initiatives taken at their widest, do you accept that it says nothing about how any schemes for renewable energy production are to be consented in planning terms?
It's not the role of that document to do that. I mean, the government is reviewing NPF4 at the present time.
Yes,
we should get a position statement within weeks.
Yes, and we don't have that yet.
So, the answer to your question would be, I think it will be in that document in terms of what that means for planning policy. This document you're taking me to doesn't, I agree with you, refer to planning policy aspects.
Yeah, and if we were to, this is obviously a lengthy document. We've got 77 pages of it. We can't spend all day going back or going through all of it, but could I take you to electronic page number 2, please? And if you could scroll down, please, Helen. Sorry, if you can just come back to the section 5 here. Thank you. And section 5 deals with recommendations, and we looked there at 511, which was the prioritisation and delivery of green investments. But then it goes on and it talks about investment in natural capital, tourism and hospitality, and so on. So would you accept that although there may be reference to green investments, it's actually part of a much wider package of suggestions which should be considered.
Yes, absolutely.
Yeah, and we see there in particular there's tourism and hospitality, which may be a sector which, for example, Murray would be interested in given its location.
Yes, I have no doubt that there will be attention put to that. I mean, the government's not saying that this will be a tourism and aviation-led recovery. It's saying this will be a green recovery in its various aspects. But it is still recognising that there will be other sectors which will play a role in the recovery. It's not all on green investments. Is that correct? It's not all on green investments, but if you read all these documents together, it's quite clear what the consistent message is. It's a green recovery, but of course there will be other aspects in sectors that quite clearly it is covering as well, and it's only to be expected that in terms of digital infrastructure, the creative sector, there will be opportunities in those sectors to play their parts. And is it said anywhere in any of these documents about the green recovery that the green recovery should be at the expense of the landscape? No. And I take it you would also accept that, looking at SPP paragraph 170, that when sites are selected for projects, they should be selected such that they're available in perpetuity? Yes. So would you also accept that there is a risk here that for what is undoubtedly a painful period, but for the painful period, which will hopefully be short-lived, we could be sacrificing the landscape in perpetuity? I don't think that. I don't agree with the premise for that proposition that the development would be such that it would sacrifice the landscape. I think perpetuity is an important point because our targets at the present time go out to 2050, and beyond that, we don't simply dismantle generating assets at 2050. The low-carbon economy and society needs to be sustained going forward until other technologies will potentially come along. But clearly, the development, if it is consented, needs to be deemed acceptable, and if that is the case, then there's deemed to be an acceptable relationship with the landscape. Yes, and that's the question which brings us to this inquiry, of course. Now, if I could take you to the Melenderdale letter from the reporter, which you reference at 2522 of your report on page 22, and it is CD reference number 11.7. And if we could just scroll through to paragraph 80, please, Helen. And you refer to paragraph 80 in your report, where the report is covering SPP and NPF3, saying that they are reflective of the legislative and policy context in relation to renewable energy and climate change. However, as the applicants point out, the context has changed in the meantime. And then going on to paragraph 83, you've not covered this, but as you know, Ms Sidgwick and I discussed it earlier. But ultimately, do you accept that even with giving greater weight to the contribution which could be made to the requirement for energy from renewable resources, that at paragraph 84, what the reporter said was that the benefits still have to be weighed in the overall planning balance? Yes, I agree. Yeah. And you also accept that ultimately, when that planning balance was applied to this particular case, it came down in favour of refusing the consent? Yes. And that was because of the impact the proposal had on the landscape? Yes, that is correct. Sorry, if I may just have a moment.
have no further questions. Thank you.
Thank you.
Thank you, Mr. Brown. Maybe that Mrs. Black has some questions? Nope. I do have a couple. Just in relation to, I'm sorry, you were asking questions about the 5 specific turbines, 5, 9, 13, 14 and 25. And you gave some answers which I think cover a couple of points I wanted to bring up with you. But you also gave some figures about generation from the original proposed development, the alternative proposed development, and the alternative proposed development less those 5 specific turbines. Am I right? Is it less those 5 specific turbines?
In terms of the drop from the APD, which is currently at 294 gigawatts, it would go down to 242.
242, you're right. Okay. I don't want to put you on the spot on this, but it's perhaps it might be worth just checking those figures, because I mean, it may well be that I'm miscalculating, but I understand it's 23 developments. 23 turbines in the alternative proposed development. 5 turbines are about 21% of that. 52 gigawatt hours is about 17% of 294, I think. So I mean, it seems to me that those, I mean, if those figures are correct, then those turbines generate slightly less rather than slightly more. But I wonder if you could just check that, and I'm happy for you to get back to me on that.
It may be that, particularly on that, just to produce a short note or table setting that out for clarity.
I think that'll be fine. Yeah.
Okay.
There was now I asked. I was going to ask Sidgwick about Brian Denny's report at paragraph 519. I've reviewed what I thought about that, but there at 519 he's considering the question of combined cumulative effect of development. Perhaps we can just bring that up and then we can take a look at it. Sorry? Sorry, yes, it's CD 15.1, paragraph 519. And I think I got your answer on this, but I just want to make sure it's all tied together. Yeah, that's the one. So he's saying the issue of the capacity of the landscape to accommodate the overall number of operational, consented and proposed turbines is a matter of judgment for the decision maker as each scheme comes forward to determination, and it's a decision which should take account of the wider benefits and harms and be considered within the overall planning context for renewable energy. So, as I understand it, he's saying it's, ultimately the capacity of landscape is not an issue for landscape architects. It's an issue for policymakers and decision makers. Do you think that's correct?
Yes, I think there's two things at play. There would be a landscape architect's view on what is a workable scheme that fits with the landscape in line with guidance and taking into account design, proportion, scale, and so on, and landscape character. I think what this is driving at is that next stage judgment, the planning judgment that you and Ms. Black will take, and in due course the ministers taking into account the benefits and the overall planning harm, if it's put that way, that might result from a proposal.
Right. Okay. So Okay, so how, as a decision maker, do you reach a view on landscape capacity?
That would be, I think, as it was put earlier, an in-the-round judgment of the development proposal and the effects it has. And that would not just be landscape and visual, but it would be all the other aspects of development with the benefits taken into account on one side of the scales. So it's a classic planning judgment, if one puts it that way, that is often seen in case law, that requires consideration of the effects of the development and taking into account all relevant considerations.
I'm just not sure if that solves my problem, because I suppose, broadly speaking, there's a view put forward, certainly by objectors, that there's simply too much development, too much wind farm development, and there's a balance to be, and you're taking the approach that there's a balance to be struck, and of course there's a balance to be struck. But the question here, Ms. Denny, relies on an assessment of landscape capacity depending on the wider planning context and the benefits and harms. I mean, it's that particular issue of landscape capacity. Sorry, am I getting it wrong?
I think that's the distinction I'm drawing between the landscape judgment. Is this a workable scheme that can go forward as an application for development? So whether it's a 3-turbine scheme or a 29-turbine scheme, there will be advice from a landscape architect on what fits with, if I can put it, the broad capacity of the landscape in this area, taking into account landscape character and sensitivity considerations. What height of turbine will we put forward? What works in the landscape? And Mr. Denny has come to a judgment on that. I read this as him simply signposting that ultimately the capacity, or put another way, is this an acceptable development? So the acceptability will be judged taking account of the wider benefits and harms of each proposal in the overall planning balance. I think, if I could rephrase it, that's how I would rephrase that. And I think the crux is the issue of capacity. I think for capacity, read acceptability. I think that's an easier way to deal with it. And that allows a decision maker to say, well, look, yes, we look at the development plan, we look at the supplementary guidance, capacity study. You know, is that pointing to us? Does that say this is an area where there's no capacity for development? No, it's not. It's saying there is. This is where development should go. So broadly, it's the right location. Is it then the right development? And that's when we get into the detail. So I think there's two different points in your question that need to be drawn out. One is the technical landscape view, and the other one that I think Mr. Denny's pointing to is that wider planning judgment.
I put my own decision in Coolachy to Alison Sidgwick, so I think I should, in fairness, I should put it to you too. So that's. I don't. Do you need to have a look at the document, or we better put it up so you can have a read of it?
If there's a particular paragraph, just to show me on the screen.
Yes. So it was CD 11.49, and it was particularly paragraphs 146 to 148. So you might want to have a look at the paragraphs that precede that too, I think. And I think the particular point I wanted to ask you about was the one I make in in paragraph 148, but we'll just wait till it gets up. So I had reached the conclusion there that the new renewable energy targets, that neither the new renewable energy targets or anything else in the Scottish Energy Strategy or onshore wind policy statement alter the balance of a planning decision further in favour of onshore wind development than the support already accorded such development when it's in the right place. I'm I was looking for a broad response to that, whether it's correct, whether it's out of date, whether it's well, how does it accord with your view?
I think the way I would approach that is to recognise that SPP is dated 2014, so largely the provisions of it and NPF3 were drafted in 2012, 2013. And as Ms Sidgwick highlighted, the targets are of their time. And your colleague in Millerndale flagged that up as well, that things have moved on. And we know that onshore wind was deemed as an urgent. There was an urgency around it, and if we look at the language in the onshore wind policy statement in 2017, that was the case. So what I've said is that in my precognition is that the situation is, one might say, more urgent and graver now than it was back then. We've had the Committee on Climate Change report, we've had the declared climate emergency, we've had a global pandemic, and the signposting to a green recovery. So if one takes the view that there always has been strong support for onshore wind, and we haven't had yet NPF4 saying anything different to what's in SPP, I think the way to deal with it would be, as in the Millerndale decision, to say, yes, SPP still gives us that framework and that strong support, and that's also reflected in NPF3. But there are clearly new material matters that have come into play that can be considered, and that goes to the weight to be given to the benefits of a development. So, and that is how it was broadly articulated in Millerndale, which I've relied on as well. So I think until we get the NPF4 position statement that might give a new direction of travel for technologies or other planning policy aspects, that is what is available to decision makers, is to look at these new matters that have arisen and say, are they material matters to take into account? I would say yes, they are. And what does that indicate for the weight to go to the benefits of a development? So,
I suppose, and it kind of goes back to the previous point. If more weight is given to the benefits of development, what does that mean for the question of putting development in the right place? What does that mean for the right places? Are there more right places if there's more weight on the benefits?
I think well, there may be, depending on the specific circumstances, but certainly in this case, where we're dealing with what can be regarded as Group 3, adding on to that the layer of the supplementary guidance and the capacity study, I would say there should be a confidence and assurance that this is the right place, subject to the specific development. So if that box can be ticked, if you like, of that aspect of SPP, the question then is the detail of the development and the weight to the benefits in today's circumstances.
Oh, I'd also asked about cumulative development and about Meikle Hill. Is there? Sorry, I'll maybe try and round this up in one question. No, I'll make it two. Meikle Hill. Is there any question about Meikle Hill, to your knowledge, about Meikle Hill not going ahead or not going ahead?
I would be very surprised if that can go ahead at that height of
If it could go ahead at that height, or it couldn't go ahead?
I would be very surprised if it did go ahead at that height.
Right. Why is that?
I believe it's consented at 126.5 metres. Yeah. So I'm dealing with a number of what I call stranded assets at the moment, which are schemes that were consented, but given turbine technology has moved on, there's much more limited availability, and it's challenging to achieve viability. So I've got several new applications going in to increase the tip height to ensure that there can be a greater yield in return to make it viable to proceed. So I don't know the details of that case, but my opinion would be I think it would be unlikely at that height without either a tip height increase or coming in with a slightly differently configured scheme to go higher.
I suppose I should ask further to that, is there any change in the way that we should consider it, or that ministers should consider it, to consider that consent in terms of the cumulative effects of the proposed development?
I think you can only go on the information you have, rather than speculate. But you know, it is clear in the onshore wind policy statement that the government gives notice that turbines will need to be taller because of the challenge of route to market, and that is why the base has now opened up the onshore wind CFD that was mentioned earlier, which will still be very challenging to achieve for developments to qualify through that. But I think you can only go with what you've got. But that would be relevant information that's in the government document, highlighting that not every development that's consented will proceed. And they recognise that there will be schemes that are challenging economically, are not viable, and will not proceed unless they are altered.
Okay. Is there any other update that might be needed to be given on applications or consents that are relevant to cumulative effects for the proposed development?
Yes, I'm duty-bound to let you know I am involved in the Cairndui project, further to the west, just providing some policy advice on that, and it's currently in scoping with the Scottish Government. It's on the website, so it's public document. It's consented at 110 metres to tip, so it's not viable at that height. The proposal when scoping is to increase it to 149.9. There's no scoping response yet, but anticipation is that the application may go in this year.
Okay. Right.
Section 36.
Good. Good. Thank you very much. Mr. Steele for re-examination.
Thank you, sir. Just a couple of matters, Mr. Bell. In relation to Meikle Hill, the turbine heights are 126.5. Is that correct? We've got a document lodged to that effect.
Yes.
Yeah. Now, do you know whether turbines are made still available to such a height with the turbine indicated as Siemens? Do you know whether that's still a technical possibility or not? Never mind viability.
There's very limited availability in the market at that height.
Yeah. So, although one can never be certain about anything, what do you say are the prospects of Meikle Hill as consented proceeding?
Well, just drawing on my experience and perhaps advising on 25, 30 projects at the moment, and none are at that height.
Yeah.
Any at that height need to be reworked to make them viable.
Yeah. Thank you. Now, just one other matter, if I may, asked of you by Mr. Seaton, and it relates to Mr. Denny in his proof at 5 at 19 at CD 15.1, 519. If we could just take it a sentence at a time, Mr. Bell. So far as the first sentence is concerned, do you say that is an accurate or inaccurate summation of the position?
It's an accurate summary.
Yeah. And so far as the second sentence is concerned, is it also accurate to suggest that any benefits and any harms have to be weighed in the overall balance?
Yes.
So is there anything in 519 that is other than precise and accurate?
Yes, when it's read in that context of the planning balance, that is right.
In relation to 519, we know by way of background that there has been a landscape capacity study which has culminated 20 years of work, many different or several different landscape architects who have ultimately identified the area of Rothes 3 as suitable for wind farm development. Now, if that is right, what weight, if any, do you say should attach to that in the weighing in the balance, the decision-making as identified correctly by Mr. Denny at 519?
I think, as I highlighted, there's that large body of evidence that points to this location. It's not ambiguous, it's not on balance, it's very clear direction that this is the location in Murray where there is that scope.
So, Mr. Denny, the landscape architect, thinks it has capacity, is that correct?
Yes.
The council themselves seem to think it's got capacity, is that correct?
Yes.
Yeah. Carol Anderson, in her report, thought it had capacity, is that correct?
Yes.
Yeah. And it's also consistent with two earlier landscape capacity studies, one by Turnbull Jeffrey and another one of a partnership between Miss Anderson and another whose name I've forgotten. Taking all of that together, what does that say to you about the appropriateness of this site for further wind farm development?
Well, I would place significant weight on that planning history, if you like, that leads to that spatial conclusion in the guidance that we know has just been through committee as remains a material consideration in the interim.
Thank you, Mr. Bell. No further questions, sir. And we will revert to you, sir, on the question. There's clearly an error on the generating figures, for which I apologise, and we'll come back to you as soon as we reasonably can on that.
As long as it's not an error in my calculations, that's fine. Yes.
No, sir. On one view, I prefer it was. It's clearly an error at our end.
Good. Well, it's 1:15 now, so I think we'll take a break for lunch. Is 45 minutes sufficient for lunch? Or yep. Okay. So if we come back at 2 o'clock, but just before we do, there's been mention of a couple of documents that are forthcoming. One is fairly shortly. One is this position statement on NPF 4, and the other is the revised version, which I think is early next year. The revised version of the supplementary guidance relating, not the one in prospect on 21st October, the interim version, but the updated version to become statutory supplementary guidance. I wonder aloud how we deal with that. Is it sufficient if people want to make comment on that, if we allow written submissions at such time as those documents come in, if that's required, if people desire to do that?
I don't think it's any alternative.
I would agree, sir.
I would also agree, sir.
Good. Okay. So we'll break for lunch until...
So before you do...
sorry, yes, of course.
Just thinking about this afternoon's programme, we're getting on very well. I don't know how long Mr Templeton will be in chief.
I would have thought an hour at most.
So we're going to have a long time this afternoon to use, and I really would come back to the question of programme and say that we ought to make make progress with cross-examination and not waste the time. I really would hope that we can do that and we won't get opposition to that.
Maybe I could just intervene at that point, sir, to say that I'll not be opposing that. I understand the sense of making progress this afternoon, so I'm quite content that
Grateful.
Mr Templeton may have to go out overnight in Purda.
Good. Well, I'm very pleased that we do that too. Mr. Brown.
Thank you, sir. Mr Templeton, just before I start, if you've been watching these proceedings, you may have noted that a little bit of doubt has crept into your surname and what it actually is. So, for the avoidance of doubt and to avoid any embarrassment anywhere in the room, I'm just simply going to confirm it's Templeton.
That's correct, Mr.
Yes.
Brown. It's Templeton.
Thank you. Now, could I ask you to have before you your first recognition, which you prepared? And starting at 1.1, could I ask you please to read your recognition?
My name is Gary Templeton, and I'm the Strategic Planning and Development Manager for Moray Council. Can everybody hear me? Sorry, I should have asked.
Yes, it's just fine.
Sorry, possibly too loud. And I've worked in strategic and local planning policy in local government for 31 years. I'm a member of the Royal Town Planning Institute. My planning experience is in strategic and local planning policy and project implementation with a focus on housing, environmental and wind energy policy. My detailed assessment of the policy issues regarding both Gour and Rothes 3 is set out in my inquiry report. The Moray Council's objections. The Moray Council's objections to the proposals at Gour and Rothes 3 are set out in the reports in the Council's Planning and Regulatory Services Committee reports and the references there. The proposals were considered contrary to the following policies of the Moray Local Development Plan 2015. Gour, PP1 Sustainable Economic Growth, ED7 Business Proposals, ER1 Renewable Energy Proposals, E7 Areas of Great Landscape Value and Impacts upon the Wider Landscape, and IMP1 Developer Requirements, and the Moray Onshore Wind Energy Policy Guidance, referred to as the Guidance, and the Moray Wind Energy Landscape Capacity Study 2017, the Capacity Study. And in terms of Rothes 3, PP1 Sustainable Economic Growth, T2 Provision of Access, ED7 Business Proposals, ER1 Renewable Energy Proposals, E7 Areas of Great Landscape Value and Impacts upon the Wider Landscape, IMP1 Developer Requirements, IMP2 Development Impact Assessments, and the Guidance and the Capacity Study. The Local Development Plan. At the time of the Council considering the proposals, the statutory Local Development Plan was the Moray Local Development Plan 2015, which included a range of statutory supplementary guidance in support of its policies. This included the guidance, which was statutory supplementary guidance, with the Capacity Study forming a technical appendix to the guidance. The MLDP 2020 replaced MLDP 2015 on the 27th of July 2020, ensuring the Council met the 5-year replacement target. The applicants have challenged the status of the guidance, and the Council has subsequently discussed this further with the Scottish Government. The Council accepts that it needs to reconsult on the guidance and submit it once again to the Scottish Government in order for the guidance to be statutory and form part of the MLDP 2020. That process is underway, and it's anticipated that consultation will take place during September and October, with the guidance submitted to the Scottish Government in November-December 2020. However, at the current time, the guidance and the capacity study are nonetheless material considerations in the decision-making process. The National and Local Policy Framework. The applicants' inquiry reports provide comprehensive context to the national approach to meeting renewable energy targets. The Council fully supports the Scottish Government's ambition to address climate change, and as part of this approach, they need to meet the ambitious targets for renewable energy generation. This support is evidenced through the Council's draft climate change strategy, anticipated to be made available later in 2020. The policies of the MLDP 2020, the operational and consented wind farms, and the many other strategies and actions being progressed in Moray. However, the Scottish Government and Moray Council approach is based upon taking action across a wide range of subject matters, including energy, transportation, woodlands, biodiversity, reducing waste, reuse of land, and is not an all our eggs in one basket approach. This approach reflects that further opportunities for large-scale wind farms in Moray are very limited, and action is required across the board. In terms of renewable energy generation, Moray already has operational and consented capacity for over 700 megawatts, and the continual pressure for wind farm development has resulted in significant concerns regarding the landscape, visual and cumulative impacts of developments such as Gour and Rothes 3, which are not appropriately located or of an appropriate scale for the landscape, as evidenced in inquiry reports by Carol Anderson and Mark Steele. The wide range of actions taken to address climate change and meet renewable energy generation targets nationally and locally is not reflected in the applicants' inquiry reports, which focus upon the contribution onshore wind farms can continue to make, with limited reference to other renewable technologies, including offshore. The Council has planned positively for wind energy as required by Scottish planning policy. The applicants appear to imply that the Council has taken a negative and overly restrictive stance to planning for onshore wind energy. This is not the case. The Council's approach reflects the need for planning balance, and the number of wind farm projects consented by Moray Council reflects the positive approach taken. In the early 2000s, Moray Council consented the largest wind farms in Scotland at Rothes and Paul's Hill, Scotland's third and fourth wind farms, and since then has planned positively for wind energy development of the right scale in the right location. Although both applicants acknowledge that there will be significant landscape and visual effects, neither adequately addresses the principle in SPP that planning should direct the right development to the right place. Paragraph 161 of SPP requires planning authorities to identify areas that are most likely to be appropriate for onshore wind farms and to set out criteria that will be considered in deciding all applications. This is a broad brush approach which results in 38.7% of the MLDP area being identified as most likely to be appropriate for wind energy, subject to detailed consideration. While some turbines in both locations lie within Group 3, areas with potential for wind farm development, others do not and lie within Group 2, areas of significant protection. Paragraph 162 of SPP requires planning authorities to identify areas where there is strategic capacity for wind farms and areas with the greatest potential for wind development. In terms of the large typology, 80 metres to 130 metres to blade tip, some turbines within both proposals are located within areas identified as areas of greatest potential and within areas identified as having potential in terms of extensions or repowering. However, others are not located within these areas. SPP is quite clear in stating that Group 3 area wind farms are likely to be acceptable, subject to detailed consideration against identified policy criteria. Paragraph 169 of SPP sets out a range of criteria which are likely to be applicable when considering wind farm proposals. including landscape and visual impacts and cumulative impacts. Planning authorities should be clear about likely cumulative impacts arising from all of the considerations below, recognising that in some areas the cumulative impact of existing and consented energy development may limit the capacity for further development. This issue is clearly identified as a significant issue to be considered within the strategy set out in the guidance. The applicants were advised at an early stage of planning and developing their proposals of the Council's concerns regarding scale, extent and siting, and while some changes have been made, fundamental concerns have not been addressed as they suggest. The applicants have different views on which are the most relevant and applicable policies in MLDP 2020, and those views also differ from the Council's. In the Council's opinion, the relevant new updated policies are DP9, renewable energy, EP3, special landscape areas and landscape character, PP2, sustainable economic growth, DP1, development principles, DP5, business and industry, as well as the guidance and the capacity study, which are material considerations. In terms of the guidance and the capacity study, the information within them and their interpretation by officers to applicants has been clearly articulated. Following the policy framework directs the right development to the right place. The planning balance. The principle of the right development in the right place, referred to in SPP, reflects the need for the planning balance to be met. Development should not be at any cost. This is reflected in the policies of the MLDP 2020 and the guidance. The actions we need to take to address climate change, including generating energy from renewable energy sources, must always be balanced against full consideration of their impacts. This planning balance is not reflected in the applicant's inquiry reports. Policy DP9 reflects a planning balance with a range of assessment criteria, including consideration of the benefits of the proposals, being considered along with environmental and other effects. The range of criteria set out in SPP paragraph 169 for development management purposes is reflected in this policy. Particularly important and relevant criteria within the policy are B2. In terms of detailed consideration, the proposals will be determined through site-specific consideration of the following, on which further guidance will be set out in supplementary guidance and as informed by the landscape capacity study. The landscape is capable of accommodating the development without unacceptable significant adverse impact on landscape character or visual amenity. The proposal is appropriate to the scale and character of its setting, respects the main features of the site and the wider environment, and addresses the potential for mitigation. Unacceptable significant impact from 2 or more wind energy developments and the potential for mitigation is addressed. And in terms of extensions, consideration of how the extension impacts on the existing wind farms setting and the ability to sit in the landscape on its own. While recognising the benefits of the proposal, due to the unacceptable landscape and visual effects identified by the Council's appointed landscape advisor, the proposals are considered contrary to Policy DP9. Policy EP3 aims to safeguard the newly designated suite of special landscape areas, and while the wording and criteria within the first part of the policy refers to proposals within these areas, the second part of the policy refers to landscape character, and along with the criteria in policies DP1 and DP9 regarding landscape and visual impacts and safeguarding the natural environment, the proposals are considered to be contrary to this policy due to the unacceptable effects of the proposed developments on special landscape areas as detailed in the reports by the Council's appointed landscape advisors. Policy PP2, Sustainable Economic Growth, again reflects the planning balance and offers support to proposals supporting the Murray Economic Strategy to deliver sustainable economic growth. The continued development of the onshore renewable energy sector is not a priority in the strategy, as there are very limited opportunities for further large-scale wind energy developments to be accommodated in the landscape. And given the unacceptable impacts, the proposals are considered contrary to this policy, as the quality of the natural environment has not been safeguarded. DP1 is a catch-all policy which includes requirements on scale, density and character of development, integration in the landscape and transportation matters, which are all relevant to these proposals. And due to the unacceptable landscape and visual impacts, including upon the Spey Valley SLA, the proposals are considered contrary to this policy. It is noted that Rothes 3 was also contrary to the transportation elements of this policy. However, this has now been addressed through conditions acceptable to all parties. DP5, Business and Industry, provides support to rural businesses where there is a locational need, and the proposal is in accordance with all other relevant policies. As the proposals are considered to be contrary to a number of other policies and not compliant with the SPP spatial framework or the areas of greatest potential spatial framework, they are considered contrary to this policy. Conclusion. Moray Council fully supports the Scottish Government's ambition to address climate change and recognises the role that renewable energy generation has to contribute to that ambition. Moray already accommodates a substantial number of large-scale wind farms and turbines and has clearly set out in the guidance that there are very limited opportunities for further large-scale wind energy development to be accommodated. The strategy within the guidance also recognises that Moray has a very high quality and diverse natural and built environment which must be safeguarded from inappropriate development. The proposals are not compliant with either the spatial framework prepared under SPP paragraph 161 or the more detailed framework prepared under SPP paragraph 162. The guidance and capacity study are material considerations. The proposals are considered to be contrary to the detailed assessment criteria of Policy DP9 of MLDP 2020, with the wide-ranging and balanced criteria of this policy representing the planning balance, taking account of the benefits of the proposals and assessing the impacts. The proposals are also contrary to policies EP3, PP2, DP1 and DP5 of the MLDP 2020, Scottish Planning Policy and National Planning Framework 3, and do not represent the right development in the right place, a key policy principle in SPP. There are no material considerations which indicate that either of the developments should nonetheless be approved.
Thank you very much. Now, you have also prepared a supplementary recognition, and again, can I ask you to have that before you? And it's quite short, so rather than take bits selectively, could you just read from paragraph 1.3 for me, please?
As explained in paragraph 3.3 of my recognition, the Council accepts that it needs to reconsult on some of its suite of former supplementary guidance, including the Moray Council onshore wind energy guidance, and submit it once again to the Scottish Government in order for it to be statutory and form part of MLDP 2020. The Council will work through this process to update, consult upon and adopt the new statutory supplementary guidance in due course. Meantime, the Council accepts that the guidance has fallen and is no longer statutory supplementary guidance. Since preparing my recognition, the Council has taken legal advice which has recommended that although there is an argument that the former supplementary guidance has continuing status of non-statutory guidance, for the avoidance of doubt, the Council should formally adopt part of its suite of former supplementary guidance as non-statutory supplementary guidance. This suite includes the guidance. In accordance with this advice, I've recommended in the committee report that the Planning and Regulatory Services Committee delegate authority to the Head of Economic Growth and Development to amend and then adopt some of the suite of former guidance, including the guidance such that it will clarify its status as non-statutory guidance. This recommendation is intended to provide clarity and assist parties with wind farm development going forward as an interim position until a more fundamental review of supplementary guidance, including the relevant consultation and adoption procedures, can be undertaken in due course with a view to adopting new statutory supplementary guidance. To be clear, the recommendation is to seek delegated authority to make minor changes to guidance, and no substantive amendments are proposed or indeed would be permitted under the delegated authority requested. The guidance. It is appreciated that the inquiry process is ongoing and that the inquiry will wish to consider the guidance and take cognizance of the potential updates to this. As explained in the final column of the third row of the table at paragraph 4.1 on page 2 of the committee report, authority is being sought to make only minor changes to the guidance. The updated guidance, which will be used as non-statutory supplementary guidance as an interim measure, will not differ substantially from the guidance currently before the inquiry. I set out the minor changes I have in mind below. For the avoidance of doubt, the following proposals reflect my intentions and do not represent the final view of the Council, which is of course subject to the determination of the Planning and Regulatory Services Committee. I should note that the anticipated adoption date of 21st of September 2020 may need to change given other commitments and priorities. It will inevitably change if the Planning and Regulatory Services Committee decides it would prefer to see a draft of the updated guidance and then approve it rather than proceed with my proposal. Updating the cover page. I intend to update the cover page of the updated guidance. This proposal is purely cosmetic. Updating policy references. I intend to update the policy references in the updated guidance to ensure these refer to MLDP 2020 rather than the superseded MLDP 2015. I also intend to add cross-references in the updated guidance to new policies in MLDP 2020, such as EP2 biodiversity. Ensure consistent references with the landscape capacity study. I intend to ensure consistent references in the updated guidance to the landscape capacity study. I intend to amend the references to extensions and repowering in the updated guidance to references to scope for large, very large turbines, including appropriate cross-references to the detailed text in the landscape capacity study in this regard. I intend to add text to clarify that the hatched areas to be identified in the updated guidance as scope for large, very large turbines have not been subject to the constraints listed in the table on page 12 of the guidance. Include special framework following SPP 161. I intend to include the special framework from MLDP 2020 following SPP paragraph 161 in the updated guidance. I anticipate this will involve the following. The mapping is to be updated to reflect the new special landscape areas and other designations, such as rural community boundaries contained within the MLDP 2020. Map 1 is to be split into two maps, one showing the area of greatest potential, currently shaded pink, and the other showing the area for extension and repowering, which, as discussed above, may be relabelled the area of scope for large, very large turbines to provide consistency with the landscape capacity study, which is currently cross-hatched magenta. For the avoidance of doubt, I have no intention of changing the boundaries of these areas in the updated guidance from those currently shown in the guidance. There may be some minor changes which are required as a result of the mapping exercise referred to in the bullet point above. At the time of preparing this supplementary precognition, my colleague who draws up the maps is on annual leave, but I do not anticipate that such minor changes as may be required will impact upon the applicant's development sites. I should be able to confirm the position before the policy sessions of the inquiry begin on 16th of September 2020. I understand the applicants raised particular queries at the inquiry session on Wednesday 9th September regarding what was intended by way of an update to page 12, page 20 and map 1 of the guidance. I have addressed my intentions regarding map 1 above. In relation to page 12, I intend to confirm in the updated guidance that the base layer will be the spatial framework from MLDP 2020 following SPP paragraph 161 and will include data updates such as settlement and rural grouping boundaries. In relation to page 20, I intend to add to the updated guidance a heading Scope for Large, Very Large Turbines to provide consistency with the landscape capacity study, including appropriate cross-references to the detailed text in the landscape capacity study. In this regard, I also intend to amend text to ensure consistency with the terms of MLDP 2020 policy DP9. Conclusion. I've set out my intentions regarding the updated guidance in the supplementary precognition. My intentions do not represent the final view of the Council, which is of course subject to determination of the Planning and Regulatory Services Committee. My recommendation to that committee is to seek delegated authority to make only minor changes to guidance, and no substantive amendments are proposed or indeed would be permitted under the delegated authority requested. As explained above, the updated guidance is an interim measure and may of course change during the course of preparing the replacement statutory guidance, which is to be linked to the local development plan.
Thank you. I just have a few points to follow up with you on the supplementary precognition which you have just read. The first point is a minor point, but in paragraph 2.6 in the first bullet point, I think I picked you up correctly when you changed the word strategic in strategic landscape areas for special landscape areas. Is that correct?
That's correct. Sorry, I didn't realise I'd done that, but it should read special.
Yeah, thank you. Now, could you tell us, please, what happened at the committee meeting yesterday?
The committee agreed the recommendations. I moved, because of other workload commitments, that the 21st of September wouldn't be achievable for the non-statutory guidance to be in place. So the committee agreed that that would be adopted on the 21st of October.
And authority has been delegated as anticipated?
It has indeed,
for
yes.
that purpose. And if I could take you back to paragraph 2.6, please, and the second bullet point, when you were dealing with the splitting of map 1, and then you go on in the middle of that paragraph to say you've no intention of changing the boundaries of the areas in the updated guidance from those currently shown on the guidance. There may be some minor changes, and then you went on to explain that you would need to speak to your colleague who draws up the maps on his return from annual leave. Has that now been done?
No, the maps haven't been split as such. I think that's to simplify that whole paragraph 2.6. For the avoidance of any doubt and hopefully to allay any fears from the applicants, we simply won't be changing the digitised areas, if you like, of the red or the hatched areas. All we're simply going to do is take the hatched areas off and show them in a separate plan, which they actually appear within the guidance on a separate plan at the moment, with some labelling. We're not going to apply the special landscape areas to the mapping at this point, but we will refer in the text to say that there are special landscape areas that have been designated.
Okay, thank you. You can put those recognitions aside now. And I now turn to some more general questions for you. First of all, can I ask, in general terms, what is Murray's attitude to climate change?
I think Murray Council is very committed towards climate change. It has been for a long time, and that's obviously declared an emergency, climate change emergency last year, in the summer of last year, and has moved forward with a climate change strategy, which was going to get reported to Council earlier this year, but unfortunately that was delayed due to COVID and lockdown.
Now, could I maybe just ask you to stop there, and could I ask to have CD 1435 brought up? And you talked about the climate change strategy. Is this the document?
That's correct.
Yes.
That was approved in early September by the Council for consultation, which runs until the end of October.
Now, it's a long document, so I don't propose to take you through it blow by blow, but in general terms, what does it cover?
It sets out the Council's commitment to be carbon neutral by 2030 and to also work with stakeholders and partners and encourage their change in behaviour and a series of projects. I think there are 57 actions identified, a whole range of different fronts, such as energy efficiency, travel behaviour, carbon reduction, reducing waste, small-scale renewable energy in buildings, increasing recycling and so on. I think, sorry, I was going to add something else, but I won't.
Okay, could I maybe just ask you to slow down a little, because I'm conscious there are many people in the room making notes.
My apologies.
So that would be very helpful, I'm sure. Now, if it was put to you that the Council has taken an overly negative and restrictive stance to onshore wind farm developments, what would you say in response to that?
I think I would say quite the contrary. I think going back to the early, late 1990s and the early 2000s, since then we've been taking a very positive and planned approach towards wind energy development. We consented, I think, as I said in my precognition, the third and fourth wind farms in Scotland, the largest at that time, and we've continued to endeavour to seek the right development in the right place by providing a level of detail through spatial frameworks to guide communities, to guide wind energy developers, landowners as to what we think is the appropriate scale and appropriate locations. I think we're now at a bit of a crossroads, possibly a tipping point, in terms of the scale of development that we've seen. and we're having continued pressure. I think that resulted in the strategy that we've written into the guidance, which is largely reflective of the landscape capacity study in terms of there being fairly limited, or in fact very limited scope for further large-scale turbines. But there is scope. We've identified scope and opportunities. So I think it's a fairly, well, I'd like to think it's a positive and planned approach that we've taken.
You mentioned having consented to wind farm developments in the past. Could I ask you please to have a look at this? It's your capacity study, which is CD 561. And if you could, Helen, please go to page 11. And if you could just scroll up so we can see that table, thank you. Now, with reference to this table, would it be possible for you to say which of these developments the Council consented to?
Yes, in terms of large scale, if I just pick them out, yes. In terms of large scale wind farms, Rothes, Paul's Hill, Berryburn, Rothes 2, Altmore, Kellis and Meikle Hill.
Okay. Thank you. Now, in terms of national policies, you referred in your inquiry report at paragraph 3.3 to the programme for Scotland. And of course we now have the next edition of that programme, which came out just as the inquiry started. Have you had an opportunity to consider that document?
Yes, I have, yes.
Yeah, and what effect does it have on what you'd said in your report when you covered last year's programme?
I think it continues on from the theme. Just to be clear, that I think Mr Bell said this morning, and he's referred to, I think he used the word misguided. That wasn't my intention at all in any way to say that onshore wind is not important. I think what I was trying to say is that it's part of the picture, and that picture has probably moved on and developed, as I think most people have been saying. There's now a range of different technologies, a range of different actions across a whole raft of fronts and subject matters, if you like, to try and tackle climate change. And I think that's the point I was trying to make. The onshore wind is part of that picture, but there are many other parts of that picture.
Okay, and you were obviously in the room this morning when there was discussion about the Scottish Energy Strategy, which is CD 611. What comment, if any, would you like to make on the document, having heard the discussion this morning?
I think I would just draw reference to paragraph section 3.8, paragraph 384, I think it is, and 385, which are referenced in my report. Sorry, I think I was saying a red herring. I was referring to my report, paragraph 384 and 385, which refer to the sort of the balance, if you like, that in terms of onshore wind, the strategy states that the Scottish Government will push for UK-wide policy support for onshore wind and take action to prioritise and deliver a route to market. And it continues on, the strategy reflects the approach in SPP aiming to support development in the right places, and increasingly the extension and replacement of existing sites with new and larger turbines, all based on an appropriate case-by-case assessment of their effects and impacts. The strategy also states that the relevant planning and consenting processes will remain vitally important. So really I think it's just adding that planning balance, taking us back to the importance of the case-by-case assessment and the importance of the planning process. Excuse me.
Okay.
And finally, it just again reiterates the SPP approach of the right development in the right place being achieved.
Okay, and you also heard discussion this morning about the Scottish onshore wind policy statement. What, if anything, would you like to add to that discussion?
Again, I've kind of referred this again as perhaps maybe just bringing the planning balance in paragraph 362 of my report. Chapter 5 of the policy statement is titled Protection for Residents and the Environment, and recognises that developments can and must strike the right balance between utilising Scotland's significant renewable energy resources whilst protecting our finest scenic landscapes and natural heritage.
Okay, thank you. Now, I would like you to take you to what was the statutory guidance, which is CD 5.5. And Helen, if we could go to page 13, please. 13. Oh, sorry. If you could maybe scroll further. Yeah, you can keep scrolling, please. Oh, no. I think it occurs to me, is there not an issue with... I'm looking for map 1. Sorry, if I can just have a moment, I'll try to find out page number.
It's page 13, if that helps, on the paper copy, but I think it might be a separate PDF.
I have map 1 in my PDF.
Can I say thank you very much for the assistance with having that brought up? Thank you. Now, this is map 1 in the guidance as was. Could you explain, please, how map 1 came to be drawn in this way? And what I would particularly like you to do is talk about the area shaded pink, which is the area of greatest potential, and the hatched magenta area which was overlaid on the plan. Thanks.
Yes, this is our interpretation of paragraph 162 of SPP. So, as I mentioned in my precognition, paragraph 161 of SPP asks us to identify areas of potential, and that results in a fairly broad brush spatial framework which identifies just over 38% of Moray as appropriate for or in areas of potential for wind farm. And that doesn't specify any or make any differentiation between wind turbines, essentially of 35 metres and 150 metres. So it's a fairly broad brush. So, as I said a moment ago, to try and inform developers, landowners, communities of where we think there are areas of scope, and further refine that. We've identified these areas of greatest potential. Very importantly, we've defined areas of potential, and we've tried to say that these are areas with the greatest scope for further investigating the feasibility of developing wind farms. And these have been identified in policy guidance maps by removing additional constraints from the spatial framework map. So we've taken the broad brush spatial framework map, and we've identified further constraints and essentially done a sieving exercise to identify the red areas as areas of greatest potential. Just stress again, that doesn't mean there should be a presumption of getting planning consent. There are areas where the criteria of SPP paragraph 169 and the criteria set out in policy DP9 and other policies of the local development plan, and very importantly the guidance in the strategic level guidance in the landscape capacity study, have to be considered and applied within these areas. The hatched areas are lifted directly from the landscape capacity study. These are areas identified as having scope for very large or very large turbines, if I remember correctly, and these have been applied to this plan. Those hatched areas do appear in a separate plan. When we were talking earlier about Moray Council's approach to wind energy, one significant change, and something I should have mentioned a moment ago, is that previously our guidance looked at turbines, I think, up to 130 metres. Taking on board the direction of travel for larger turbines, that was something we were quite keen to try and build into the updated guidance, and that was a specific part of the remit to Carol Anderson in preparing the landscape capacity study, to look at larger turbines with a view to potential extensions, with a view to repowering. So I think that was a positive step.
Okay, thank you. Now, you obviously have a capacity study which we looked at earlier. What is your understanding of the purpose of a capacity study?
The capacity study is intended to set strategic level guidance. Okay,
and how did the Council apply the capacity study when assessing both of the applications which are before the inquiry?
As I say, the guidance sets very high-level strategic guidance, identifies that there is some limited scope, and that was used alongside commissioning our landscape advisor to give us more detailed advice. We studied the details of the proposal with planning officers and other consultees, and in considering all the aspects, the merits, the benefits, the potential impacts of the proposal, the conclusion of the planning authority was that this was not the right development in the right place.
Okay. Well, could I ask to have CD 5.6.1 brought up? And it should be electronic page 74. Yes, and if you could scroll so we can see the bottom of the page, that would be very helpful. Thank you. Now, you mentioned guidance for development there. We've looked at this before. This is the guidance in relation to LCT 10 at this paragraph. Is that correct?
Yes, correct. Sorry, yes.
Yeah, and it starts by saying that some limited scope has been identified.
That's correct.
And what were those words intended to signify?
Yeah, I think exactly as it says in the tin, essentially, there are some limited scope that needs to be further investigated on a case-by-case basis with the details of the proposal.
Okay, thank you. And Helen, if you could turn to electronic page 79, that would be helpful. Yeah, thank you. Again, we have paragraph 17.3 here, and this is the guidance in relation to LCT 11.
That's correct.
And on this occasion it says there's some very limited scope.
That's correct.
Which is contrasts with 16.3, which said there was limited scope, or some limited scope.
Yes.
Now, in the course of the inquiry, we've heard about the landmark hills, and could I ask you, Helen, to go to page 7, page 96, please. Thank you very much. And we're looking there at paragraph 21.3.1. What is the role of the landmark hills?
I think they're defined quite well within that paragraph. I think the second part of it, perhaps starting, the majority of these hills are both highly visible and easily recognisable landmarks, with many forming the immediate backdrop to settlements, small-scale valleys and the coast. Some of these hills form visual buffers to less prominent upland areas and are important in visually containing operational wind farm development from more settled valleys. These landmark hills are highly sensitive to wind turbine development, sited on or near them, as this would be visually prominent in views from roads and settlement within adjacent well-settled landscapes. I think it's quite a good definition there.
And when there's reference to a hill, what is meant by the hill?
It's intended to be the entirety of the hill, so that's the lower slopes. It's not simply the peak of the hill, it's the entire hill.
Okay, thank you. Now, in the course of the inquiry, and indeed in your report and recognition, you referred to the Murray Economic Strategy. What is that?
The Murray Economic Strategy is essentially the long-term strategy set by the Murray Economic Partnership to deliver long-term sustainable economic growth in Murray.
And you've mentioned the Murray Economic Partnership there. What is that?
It's a partnership that was formed out of the Murray Task Force, which was set up when there was concern about the military reviews ongoing, and it was set up to diversify and expand the Murray economy. The partnership's made up of Murray Council, UHI, Highlands and Islands Enterprise, Skills Development Scotland, private business and various other partners.
Could you say a bit more about the aims of the organisation and the sectors it sees as growth for Murray?
As I said, the aims are very much about long-term sustainable growth. For Murray, there's talent attraction aspects, skills development and such like. The key sectors are around aerospace and defence, food and drink, life sciences, creative industries and tourism, and a key part of the actions for the coming 10 to 15 years are delivery of the Murray Growth Deal, which includes eight different projects with a value of £100 million, with £65 million of that coming from the governments, UK and Scottish governments.
And what sort of projects is that working on at the moment?
Quite a wide range of projects, aerospace, digital health, one on cultural heritage, which aims to attract up to 80,000 tourists and visitors into Murray. That involves creating a new visitor attraction in Elgin, which will then signpost. It's based around whisky heritage, food and drink, but the intention is to signpost all of Murray's attractions from that new venue.
Okay, thank you. And there was discussion this morning about the response to the COVID pandemic. In what way can you help us? Can you tell us what steps are underway to deal with that at a local level in Murray?
There's a report, a recovery plan, I understand, is going to be reported to the Economic Partnership on, I think it's the 30th of September, and then it will be reported to Council on the 6th of October. There's been a range of stakeholder engagement, various webinars and such like, to look at what we can do. I can't say too much about it, mainly because I don't know the detail of what's going to be in there, other than some general discussion points. I know that obviously things like town centre recovery, will be in there. We'll be looking at the green recovery aspects, small-scale renewables, these sort of things. We'll be looking at advancing the Murray Growth Deal projects to try and deliver those benefits as quickly as we can.
Okay, thank you. And just one final point. With regard to the indicative regional spatial strategy, which is CD 1437. And 1437 is a report to the committee for yesterday's meeting regarding the indicative regional spatial strategy. And just for completeness, could you please update us on what happened in that aspect at the meeting yesterday?
The report was agreed, and agreement for the indicative spatial strategy to be submitted to the Scottish Government before the deadline of the 18th of September, subject to a couple of typos of mine being corrected.
Okay, thank you. I have no further questions for you, Mr Templeton, but if you just wait there, I'm sure there will be other questions. And sir, if I could just have 2 minutes to speak to Mr Templeton first, before we start the cross, that would be helpful.
Yes, of
Thank
course. Should we take a 10-minute break just for everyone to get organised? Mr Nick, yeah? Okay, till 2 o'clock.
Thank you, sir.
Mr Trinick.
Thank you, sir. Good afternoon, Mr Templeton.
Good afternoon, Mr Trinick.
Can you see me all right? That screen's a little bit in the way, isn't it?
I'm okay, but do you want me to move it? Or?
Well, it might just be moved a bit that away, I think, and then we'll be able to gaze at each other that way. Just a bit. Does it interrupt Mr. Steele's view? Can you see the witness? He's asleep.
Well, I can see him now, but that's because he's standing up in front of the screen. But I need to see where he sits down. I can move it later. I'll not be on until tomorrow, I'm sure.
That's fine. Thank you very much. I want to start with LDP policies. So if you go to your inquiry report at paragraph 313 initially, where you, on page 15, where you talk about 2015 LDP policies, I've assumed that what you're doing here is saying to the reporter, look, this is why we did object to it, even though those policies no longer have any effect. Is that right?
That's correct, yeah.
So we needn't trouble ourselves with the policies in current circumstances?
Yes, agreed, yeah.
Good. If you go to 324, please, on page 22. I want to start with policy EP3. And for that, we go to, Helen, if you could bring up CD53 at page 74. Now, EP3 starts. It concerns special landscape areas and also as a second part on landscape character. In your inquiry report, you focused on the SLA advice, and I want to go through very briefly the wording of the policy. Development proposals within SLAs. So, and there's nothing else within the policy that tells me that it applies to any proposed development other than within SLAs. Would you agree?
In terms of the first part of the policy, I would agree. I think the point we're trying to make, Mr Trinick, is that the second part of the policy talks about landscape character. And when you consider the plan as a whole, as it sets out at the start of the plan, all the policies should be read, including the vision, strategy and such like. And that includes looking at policy DP1, And
No, don't start going off on one. Stick to EP3, would you?
Well, I have to, sorry, because it has to be read as a whole.
I've got that point. I know that it has to be read as a whole. I want to take the... Will be a long time if we get the same answer to every question. Yes, let's tick the box. The plan has to be read as a whole. We don't need to say it again. I want to take you to EP3, please, and just focus on that policy. In your inquiry report at 324.1 onwards, you address EP3 solely, explicitly solely in the context of the SLA. That's what you do in 324.1 to 324.4. That's a statement. It doesn't need to be a question. That's clear. Insofar as your evidence relates to EP3 and the SLA, would you agree that the policy only applies to development within SLAs and not outside, but may be impacting on SLAs? I just want a clear answer to that point.
I'm not sure if you're going to get it, Mr. Trinick, because the second part of the policy refers to landscape character, which is the answer I was trying to give you a moment ago.
Yeah, look, you will gather that if I've got a point I want to get to, I will get there. So we're going to get there. The SLA advice within EP3 applies to development proposals within SLAs, doesn't it?
The first part of the policy, yes.
Thank you. If we go to 324 in your inquiry, sorry, bear with me a moment. I'm going to PP2 now, which you cover at paragraph 325 in your inquiry report. I think we can agree that this policy is not a development management policy. It simply says development proposals which support the Murray economic strategy to deliver sustainable economic growth will be supported. That doesn't mean to say that development proposals which might not, and we're not saying ours doesn't, support this strategy will not be supported. It simply is a statement of support, isn't it?
Yes, it is, yes.
Thank you. So in development management terms, if the reporters want to look at policies in the plan which advise, should we say, on a criteria basis about a proposed development, PP2 isn't one. It's simply a statement of support for something.
Well, you could read it the other way, Mr. Trinick, as well, is that the tests within that policy have not been met by this proposal, and that's the point we're making.
Well, I think the reporters have my point. I can gather I'm going to have to make my points and move on here. You've agreed it's a policy of support for certain types of development, if supported by the strategy, but I think we've agreed there are no development management tests within that policy which relate to developments not supported by the strategy. You can't read it that way, can you?
But you could read it that I think we could agree to disagree on this one.
That's fine. I have a feeling that may be the case again. 326, DP1, which you'll find at page 35 of the plan, and your 326, which is at page 23 of your inquiry report. You called it a catch-all policy. Indeed it is. But it seems to me clear from the wording of the policy that it is entirely aimed at new buildings. If you look at the headings of the policy, design, lots of paragraphs there, all about buildings. Go over the page, transportation, advice solely in relation to new building development, paragraph 3, water pollution. It's all about new building. You can always strain a point and say that any policy in the plan applies to something, but are you really saying there's a useful policy for wind energy development?
I think what we're saying is it's a catch-all policy, Mr. Trinick. It replaced policy IMP1 of the 2015 plan. There are references in there about landscape integration, landscape impact, etc. that applies to all developments. That's all we're saying.
Yeah, but you've claimed that we are in breach of DP1. I suggest that it's such a general catch-all policy, and it's so clearly on all its wording, all of it applies to new building, that it's stretching a point too far to try and apply it to wind energy development.
I think in the first line it says it applies to all development.
Yeah, look, that's the sort of reply which is a stonewall reply. Try and help the reporters here rather than giving a stonewall reply. Do you really say this helps the reporters in evaluating a wind energy development? Try and help the reporters a bit more.
Well, Mr. Trinick, I am trying to help the reporters. I'm treating this as we would with any other proposal. So if this was a planning application for whatever it might be, we'd be applying this policy. So I'm trying to be consistent in the advice we give and the interpretation that we give.
All right, I have your answer. DP5, which you deal with in 327 on page 24 of your inquiry report. And Helen, you'll find DP5 on, you found it? No, you haven't. It's on page 55. Have you got the policy in front of you?
I have, yes.
I have, okay. Are you claiming that DP5 is relevant because Gour is some form of farm diversification proposal or some type of rural business? It seems an extraordinary claim.
Again, I'm just trying to be consistent, Mr. Trinick. We've applied this policy to other wind farm developments. That's why we've referred to it here in terms of the first paragraph, the last part of that, the locational need for the site and the proposal in accordance with all other relevant policies and so on. So we're just being consistent.
Yeah, but being consistent doesn't make you right, does it? I'm asking you at this inquiry for this proposal if you really feel that a policy which advises quite clearly on business parks, areas of mixed use, industrial estates, references to Class 2, Class 3, Class 11 use, has any application, any useful application to a proposed wind farm. Don't just tell me you're being consistent. Give an answer to the question.
Well, I think given the economic benefits that we've heard from the applicants or the supposed economic benefits and so on, we were treating this as some form of new business enterprise, if you like, or development within the countryside.
I see.
The weight to be given, I accept, is not a primary policy in determining a wind farm application.
All right.
But I'm sorry to say it, but if we were reporting to our planning committee on this with a recommendation, we would be referring to the policy while accepting it's not the primary policy.
All right. I couldn't help noticing that you said supposed economic benefits. Having said economic benefits, you said supposed. You don't bring any evidence to challenge the economic benefits of this development, do you?
No, I'm just saying that I don't think we were, wasn't party to that discussion, so perhaps it was clumsy wording on my part there.
All right, well, that's generous of you. Thank you very much. 328 of your inquiry report, the Murray Woodland and Forestry Strategy. This is one of those supplementary guidance documents that fell with the old plan. I understand the intention is to revive it as non-statutory guidance.
That's correct.
With effect from 1st of October, I think, in that
correct,
case.
Yes.
All right. To go to 328.4, would you? Because you note there that as well as the significant tree felling associated with Gour, the southern cluster of turbines are located within an area identified as potentially sensitive. It's tantalising because you don't see any more. So let's see where it goes. Would you go to CD 58, please, which is the forestry strategy? If you go to the maps at the back, there's one map at the back, which actually reproduces your Appendix 4, but you can look at it in whichever place you want. And on that map, we note the caption potentially sensitive, and actually I should have looked at your Appendix 4 because that also has the southern Clash-Gour turbines endorsed on the plan, so we can see there's overlap between the hatched area and the southern group. Do you know why this is a potentially sensitive area? Because you don't tell us in your evidence.
I think it's something to do with peat. I think it has to be subject to more detailed survey as to whether that would be suitable for woodland planting.
Okay, well, if you go to the next page, Colin, after that, page 19, we do have an appendix which tells us in the right column, you see it's actually hatching, potential with sensitivities. It does indeed relate to carbon-rich soils and possible carbon-rich soils. Each site will be assessed on a case-by-case basis following site soil survey. Now, if we go to your Appendix 2, to your inquiry report, that is, and thank you for producing these plans. They're really quite useful, endorsing some information on a baseline. Sorry, Appendix 1 I meant, not Appendix 2. We can see that in the SPP-based spatial framework, which is the pink, we can see eastern group, northern group, substantially within the pink area. The southern group there's lots of turbines outside it. I think that is because of carbon-rich soils. You would agree?
Yes, I would agree.
Not to do with community separation, because we can see the circles where that's concerned.
Correct.
And so we can see that the potentially sensitive note in Appendix 1 to CD58 relates to the CO2 soils we see mapped by their absence, mapped on your Appendix 1. That's right, isn't it?
Correct.
Yeah. And we know there's no objection to this development from SEPA.
That's right.
Or from the Forestry Land Scotland.
That's right.
So in terms of the issues which are before this inquiry, which are landscape and visual issues, the southern group is effectively Group 3.
Well, some of the turbines are Group 3. Not all of the turbines are Group 3 in terms of that framework before you.
No, but in terms of the issues before the inquiry, there are no carbon soils issues before this inquiry. You know that?
Yes, I'm aware of that, Mr. Trinick. I'm just referring to the map in front of me. You're asking me what tier is it? I'm referring to that map.
Fair reply. Okay, let me take it one stage further. I don't want to have to get out of inquiry decisions, but you may be aware that there are inquiry reports where reporters have specifically found that in cases such as this, where an area is not Group 3 solely by relation to carbon-rich soils, and where there are no objections based on carbon-rich soils, those reporters have treated the area as Group 3. You see where I'm going?
Yes, I accept that, yes.
That's fine. Thank you. I was going to ask you some thunderingly good questions on your general approach to other national documents. If we go to section 3.3 of your evidence, the national local policy context. But, you know, having heard what you said in chief, having heard what Alison Sidgwick said under cross-examination and Mr. Bell, I think we're at the point where I can submit knowing where we're apart, save for 1 or 2 points, so we can cut out some examination here. I'll take you through to 3.1 first of all, on page 8, and ask you to get out SPP, which is CD51. Bear with me. Now, what you say in 3.1 is the key principle, second last line, the key principle to direct the right development to the right place. I know it says, it uses that phrase within SPP 1, but if you go to paragraph 1 of SPP, we all know what it says. I'm just drawing attention to the introduction. And again, we have the reference to increasing sustainable economic growth there from the start. If we go to paragraph 9, we can see that the purpose of creating a more successful country with opportunities for all of Scotland to flourish through increasing sustainable economic growth is set out in the government economic strategy. The aim is to ensure the entire public sector is fully aligned to define the purpose. If we then go to the outcomes, which we started just under paragraph 13, I know you're familiar with them, so we can just note them in passing. I don't need to rehearse them. And then go to paragraph 24, where we see the Scottish Government's central purpose is to focus government and public services on creating a more successful country, again, sustainable economic growth. And 28, the planning system should support economically, environmentally and socially sustainable places by enabling development that balances costs and benefits of proposal over the longer term. And then we have the statement, the right development in the right place. What I think I've rehearsed here is the core of the purpose and intent and approach of the SPP. It doesn't boil down to one key principle about the right development in the right place, does it?
I'd agree with you, Mr. Trinick. I think what we were trying to say was that there is a key principle in there. Perhaps I haven't worded that as I should have, and I'll accept that. But there is a key principle of the right development in the right place.
Okay. The piece of cross-examination I think we're going to be able to leave out boils down to a point which I'll synthesize into one proposition. I think we might be able to cut to the chase there. I don't think we're going to quarrel if we can agree the following, that in terms of onshore wind, there's no support for onshore wind in national renewable and planning policy is not diminished. I'll put the whole proposition and you'll see what you think of it. It's not diminished. Indeed, support has increased as a result of net zero and the climate emergency. However, onshore wind is but one part of a mix of measures designed to address climate change. We don't say it's any more important than any other measure. It's one of the measures to combat climate change. And yes, at a planning level, we have to achieve the right development in the right place. Are we together?
Yes, I think we are, Mr. Trinick. We agree on that.
Excellent. That does cut out quite a bit. If we go to paragraph 343 of your inquiry report, there's an intriguing comment you made on the last line of page 10, having recorded nature-based solutions, including tree planting and peatland restoration, helps to lock in carbon and protect us from the impacts of global warming. This again gives cause to consider whether large-scale wind farms are the best long-term land use solution on the Murray Moorlands, and to consider the resultant effects on the Murray tourism industry. Well, we know you don't give tourism evidence, but what are you saying there's some policy support for preferring tree planting and peatland restoration to onshore wind?
I think what I'm alluding to there is some of the discussions that was coming out through the indicative regional spatial strategy, which we haven't said much about, but there are proposals in there about better peat management, about native woodland expansion and such like. And again, it's maybe back to your previous point about there are actions on many fronts being taken.
Mm-hmm. Well, Glashgar has rather anticipated the RSS, hasn't it? Because I'm sure you're familiar with the fact of, not the content of necessarily, but the fact of the habitat management plan for peat restoration that's been proposed.
Yes.
And the forest plan that's been proposed to give a better diversity of species and age.
Yes.
Here is an example, isn't it, of onshore wind. And never mind the acceptability of the onshore wind bit. I know you don't agree with that, but if it is acceptable, here is a good example of onshore wind, peatland restoration and forest management going hand in hand. Would you agree?
Well, I think our argument is still going to come back to it's not the right development in the right place, but I note what you're saying.
Yeah, that's fair. We can move off that general area now. I want to get on to SPP. I want to start with one. Let's go to it. SPP 170, which is on paper page 41, if that's what you have. Areas identified wind farms should be suitable for use in perpetuity. Let's just stick with that phrase. What do you think that means?
I think they should be designed to be a longer-term feature.
Yeah, I would say what it means is that when you're planning for a wind farm, you don't plan for it as if it's a temporary feature. You plan for it as if it's going to be permanently there.
Yes.
We're in agreement.
Yes.
And that's all it means. It doesn't mean that the potential reversibility of the wind farm development may not separately be a material consideration.
No, I think it's saying that it should be designed in such a manner that it can be there in the longer term. Yeah,
that's fair. Go to 310.6, please, in your inquiry report. And also get out SPP 196. You've quoted from 196, as it requires that, in this case, locally designated areas should be identified and afforded the appropriate level of protection development plans. It'd be fair to ask the reporters to note the last sentence of 196, wouldn't it? The level of protection given to local designation should not be as high as that given to international or local. To give a complete picture.
I think that's fair.
Yeah. 310.3, please. No, sorry, 310.4. This is where you tell us about SPP 162, where we may not reach such happy agreement as we have so far. Let's see how far we get. How about SPP 161? Let's just rehearse those three paragraphs so we have them firmly in our minds. Planning authorities should set out in the development plan a spatial framework identifying those areas likely to be most appropriate for onshore wind farms as a guide for developers and communities, following the approach set out in Table 1. And to cut to the chase at the end of that sentence, Table 1 leads to the sort of map we see at your inquiry report Appendix 1 for Murray.
That's correct, yes.
Yeah. And now reproduced in the Local Development Plan 2020.
Correct.
Yeah, that's fine. The development plan should indicate the minimum scale of onshore development that spatial framework is intended to apply to. Well, I think I can't remember where you do that, but you do that, don't you?
I think we state, carried forward from the MLDP 2015, that I think it's 35 metres and above.
Yeah, that's fine. And then we have some development management advice, or at least advice on development management in the last sentence. SPP 162, and I'll abbreviate so it's directly relevant, local planning authorities working together where required, should identify where there is strategic capacity for wind farms and areas with the greatest potential for wind energy development, considering cross-border constraints and opportunities. And then 163, the approach to a spatial framework preparation set out in the SPP should be followed in order to deliver consistency nationally, and additional constraints should not be applied at this stage. And then it goes on to talk about development management process. Now, SPP 162, I suggest, means no more than Murray should identify where there is strategic capacity for wind farms and areas to greatest potential. Means no more than that, does it?
Well, that's what we think we've done. We've identified areas of greatest potential for wind development.
We'll come to what you've done later, but you agree that's what it means. That's what you do, as rehearsed.
Well, yeah, I think we also have to agree that that's different to 161.
We'll come to that. I'm taking it stage by stage. Do you know what is meant by strategic capacity in 162?
Well, we think it's a finer grain than 161 has asked for. 161 has asked for areas of potential, if I remember correctly, and 162 is asking us to identify areas of greatest potential.
You don't think that the words strategic capacity in SPP 162 relate to the words minimum scale in 161? In other words, you're identifying capacity for development above the minimum scale identified under SPP 161.
I'm not sure, Mr. Trinick. Maybe it's a question for the Scottish Government in terms of what's actually meant by that.
Well, good luck with that. Has there been any joint working with Highland Council on the SG?
On our SG, we consulted Highland Council, as we would with everybody and adjoining neighbours. I don't think they responded to us. That sort of joint working is now happening in terms of the regional spatial strategy. Yeah. So I would anticipate improvements in terms of how we plan this in the future.
But the reporters can note that the SG, and it's not you said you consulted, that's all you can do, but there are no cross-border opportunities which are visible within the SG.
No, it doesn't show that, no.
Yeah, thanks. And Murray Council followed up SPP 162 by engaging Carol Anderson to update the LCS, and on the back of the LCS, the SG was prepared.
That's correct.
And we've already established that SPP 161 led to the map, which is Appendix 1 to your inquiry report, and to what is now Map 1 on page 64 of the LDP. So we needn't go there. We know that's where we are. And there's also a map on a later page of the LDP, I think it's page 66, which sets out what I call Group 2 areas.
That's correct.
Yeah, that's fine. Now I want to divert, we'll come back to that. I want to go to CD 1420, and 1420 initially. To put the document we're about to look at in context, go to paragraph 4.6, please. The second last bullet, Helen. To give the introduction, officers have contacted the reporter for further information on this recommendation, whilst fully supporting its attention, etc., etc. And one of the actions you had to take at the request of the reporter was removal of the detailed wind energy policy guidance mapping. And are these your words, by the way?
Yes, I'm happy to take responsibility for those words.
Leaving the plan with a largely meaningless spatial framework showing half of Murray, bit of exaggeration, 38% half, well there we are, as an area of search for wind farms of all scales above 35 metres. Well, this is not surprising. It's been a long-running issue, and officers will continue to lobby for this to change in MPF 4 to provide certainty for all parties, especially communities. So that was you speaking to your members.
It was myself and other officers who feel strongly on this issue and would like to have a discussion about the requirements in National Planning Framework and SPP as we move forward.
Yeah, well, I noted what you said about feeling strongly. Let's see how that resonates in the next document we look at, which is 14.2.2, which is the transcript of the meeting on the 6th of June, 3rd of June rather. And we can see on the first page, GT is you, by the way, that second paragraph in the bottom box. Paragraph 4.6 of the report highlights some of the main cases where the reporters have reached a different conclusion. And the report, i.e. your report to committee, recommends that the Council accepts all the modifications recommended by the reporters and modifications the Council has previously agreed to, and then submit the plan for adoption. And indeed, we know that's what happened. Would you go on to page 5 of that report, which has got the map of Murray at the top? That's the one. And the map we see is the SPP-derived spatial framework, isn't it?
That's correct, yes. Yeah.
And below that, you're speaking to members, this is the mapping that's been left in, proposed in the local plan. It's what the reporter recommends stays in the plan. Sorry I'm going to read that in detail, but I need to set the scene here. My apologies. This is required by SPP, essentially covers the Murray Development Plan area. The area identified as red follows procedure we have to in terms of gathering data and identifying areas of potential for wind farms. Our case has always been this is really a fairly meaningless piece of mapping. It covers all scales of turbine, gives no certainty to developer, communities or anybody. The detailed mapping about which a councillor was asking, there was further detailed mapping on different scales of turbine. This is for large, so yes, this is for the large typology. And you start to see where that starts to refine areas of search for available wind farms. So what we're referring to now, I think, is what was map 1 in the SG. Is that right?
I'm not sure. I'd have to have time.
Let's have a well, if you go to Appendix 2 to your inquiry report, is that the map you're now referring to?
I'm not sure, Mr. Trinick. I'd need to read the extract in full. If you're comfortable that's what it is, I'm happy to take your word for that.
I don't think I'm misleading you. I really don't. It's the detailed mapping which Councillor Fever was asking about, and that was indeed the SG mapping. And you're talking about 80 metres and above, so I think that is the map that she was referring to.
I think it's the 3 maps that were then taken out.
Yeah, that's correct.
Yeah.
But for the 80 metres and above, this is the map.
Yes, yes.
So I think we have the right one. And you said about this map, so a bit more certainty with developers, communities and the like. And if you were to map or plot, which I probably should have done for this one, the existing and operational turbines on top of the red areas, you'd actually achieve a very, very limited scope for further large-scale turbines in Murray. The reporter has taken this out, or recommended we take it out, this detailed mapping, and it remains in supplementary guidance. This may seem minor, etc., and so on. You go on about the statutory status. I don't think I need to go there. And I'll return to that shortly. I'm parking points, and I'm going to come back and pull them all together. If you go to SPP 163, and you have to read 161, 162 and 163 together. The approach to spatial framework preparation set out in the SPP should be followed in order to deliver consistency nationally, and additional constraints should not be applied at this stage. What that means, Mr. Templeton, I suggest, is that local authorities should absolutely not apply additional constraints in their local policy documents beyond the mapping which results from Table 1 in SPP. What's your response to that?
My response, Mr Trinick, is that the supplementary guidance which provided the more detailed mapping, the area's greatest potential, was approved by the Scottish Government. And also in the examination of the 2015 Local Development Plan, I believe the conclusions of the reporter were that additional level of guidance and potentially mapping was required to support the policy and the, may I call it, broad brush spatial framework from paragraph 161. So I think we've had support from the government from the approach we've taken. And I have referred to the limitations of the spatial framework. I think, I'm not sure how that works for a developer, but certainly for communities and landowners, I'm not sure how almost 40% of Moray being identified provides any degree of certainty. So we've always been keen to do something further to hone in on the real opportunities, and I've had that discussion with the Scottish Government.
What I want is your reply to my question as an expert witness at this inquiry. I want your view, not a reference to the fact that, in our view, the Scottish Government has fallen down on its job in the past in approving these plans. I'm looking at SPP as it is at this inquiry, and I want you to look simply at those 3 paragraphs and respond to my point, which is that what 163 is saying with crystal clarity, unmistakable clarity, is that local authorities should not, in order to deliver consistency nationally, and that is important too, apply additional constraints when making their local plans so as to cut back on what might emerge as pink areas as a result of SPP Table 1. That's what it says.
And we, in terms of the spatial framework, we've not added additional constraints. These are policy guidance maps, the areas of greatest potential. And in fact, the reporter was very clear, I think, in the 2015 examination to make that distinction, that they should be referred to as something like policy guidance maps. And they're quite different to the spatial framework. The spatial framework we talked about earlier, that's in compliance with SPP.
Yes, but the trouble is, Mr Templeton, when it comes to development management, it's not the SPP spatial framework which you use to determine applications. It's the SG policy mapping, in our case, map 1. So actually, what you've done is cut back on the SPP Table 1 approach.
No, it's not, Mr Trinick. In determining an application or responding to an application, we consider the local development plan policy, SPP, the guidance, the capacity study, and the advice on a case-by-case basis from our landscape advisor. It's the whole package.
Hold on. The problem is you've got the LDP reporter against you. Let's go to CD 59, shall we? CD 59, paragraph 24 of her findings at page, well, my real page is 137. I can't, if you get to about that point, Helen, we'll see if it coincides or not. Thank you. Paragraph 32 we want. Now, I'm going to rehearse first a point in your favour before I get to one I don't think is in your favour. Noting the discussion this morning, I think we are agreed that the LDP reporter approved your approach to mapping rural groupings and settlements. So I just recall there's no dispute between us on that. If you go to paragraph 50, The reporter noted the Council's intention to adopt SG in some form to support policy DP9, and she said, I got no remit to examine the contents of the supplementary guidance, and so we can record that. Moving on, 51, she recorded the representations, I think that those are from Force 9 Energy and other people, concerns the Council, that the highlight concerns the Council's revised policy indicates the wind farm proposals will be determined through assessment against the SG, including the LCS. And further concerns are raised in the requirement under landscape and visual impact for compliance with the study and maps 3, 4 and 5, which I think are maps 1, 2 and 3 within the 2017 SG. Is that right?
That's correct.
Yeah. Then we've got paragraph 56. I'm also aware that approved SG alongside MDLP 2015 is not statutory in association with the emerging plan. The Council intends to carry it forward as statutory guidance to support a DP9 once the plan is approved. Although that is the intent, the guidance may still be subject to change. So it's for DP9 to set out the main principles and for the guidance to be limited to the provision of further information or detail. You would agree that's the right approach?
That's the approach set out by the reporter.
Yeah, okay. Bear with me a moment. The reporter recommended, didn't she, the removal of maps 3, 4 and 5 from the plan?
That's correct.
And they've been removed? Yep.
Yes, they have, yes.
They've been adopted without. Trying to short-circuit something a minute, so I'm just looking through something. Yeah. Coming back then to the SG, so I'm going to request just a 5-minute comfort break before we go on. That's all right.
That's fine. Well, we'll say 5 to 4. Yeah.
Thanks.
So it's 5 to 4, so we can resume. Mr. Trinick, you were saying that you expect to get finished today, and that that would be about 1:45. Well,
yes.
Can you give an estimate as to how long that might be?
Yeah, my longer estimate took account of a number of questions which I reduced to one by synthesising my approach to the whole issue, and it worked. We agreed, so I moved on. So about 45 minutes, yeah, I would guess. See how we go.
So we'll press on to about 4:45 then.
Thank you. One point I should have raised in connection with the CD59, Helen, the reporter's report of the examination, was at paragraphs 27 and 28, where she discussed maps 1, 2, 3, 4, 5 in more detail. This may go to the heart of the issue that may be between us. Let's explore it and see. I acknowledge the distinction made, paragraph 27, between map 1, areas with potential, which combined with map 2, comprise the spatial framework and reflect table 1 SPP, and maps 3, 4 and 5, areas of greatest potential reflecting paragraph 162 of SPP. Maps 3, 4 and 5 have been identified by removing additional constraints likely to be most appropriate for wind energy development as listed, etc. I note the point made that additional constraints should not be applied at this stage, SPP 163. However, this statement relates to the preparation of the spatial framework. I'm satisfied that Council has followed the approach set out in SPP in preparing its spatial framework. So that spatial framework that's maps 1 and 2, correct?
That's correct, as I said earlier, yes.
Yeah. But paragraph 28, the Council has introduced maps 3, 4 and 5, termed policy guidance maps, into the plan from ASG. While I note the distinction made between these maps and maps 1 and 2, I find their intended purpose in terms of policy DP9 inconsistent. I note the Council's reasons for including these maps is to provide further detailed guidance in anticipation of removal of statutory supplementary guidance as part of what we know is now Section 7 of the 2019 Act. I find that the Council's revised wording for DP9, which requires compliance with these maps, would bring additional constraints into the plan in considering wind farm proposals. This would remove the ability to consider the detailed merits of individual proposals, which would be contrary to SPP. And therefore, we see the issue recommended their removal. So that's the basis on which he did it. Can I ask you, see if we can reach agreement on this, that Moray Council recognises that in development management, in terms of spatial framework, the Group 3 advice in SPP, which applies to the whole of the pink area on your Appendix 1 map, is that the principal development is acceptable and you look at the detail. That's what it says, isn't it?
Yes, I think I talked earlier about the definition of areas of greatest potential. It will always come down to the development management criteria set out, as I said earlier as well, Mr Trinick. It's about the LDP policy, it's about the guidance, about the capacity study, and the detailed criteria on a case-by-case basis.
Well, let's just backtrack. I want to get this right. Table 1 SPP, Groups 3 areas with potential, that's what it calls it. Beyond Groups 1 and 2, wind farms are likely to be acceptable, subject to detailed consideration against identified policy criteria. That's saying, is it not, that in terms of SPP advice, development in Group 3 areas is in the right place? You look at the nature of the development and evaluate the details. You don't look at whether or not it's in the right place on SPP advice, do you?
I'd accept that. That's what it says in SPP, Mr Trinick.
Yeah. So that if you're saying that your approach in SG, the old SG, and I suspect the new SG will come to that, is consistent with SPP, that must mean you're not saying to any developer who proposes a development within an SPP Group 3 area that he's in the wrong place. That cannot be.
I think, as I've tried to explain, Mr Trinick, we introduced a further level of mapping to identify areas of greatest potential because of our concerns about the broad brush nature of paragraph 161. The Scottish Government approved that guidance previously as being in compliance with national policy. Well,
I'm sorry, I'm not interested in what happened in the past. I'm looking at what is now and what the reporter said about your very recently adopted LDP. She removed these maps. So she didn't agree with their inclusion within the plan. Yet you tell me that your approach in SG is consistent with SPP. So that can only be because you're not saying in the SG that a development proposed in a Group 3 area is in the wrong place. You cannot say that.
For clarification, Mr Trinick, we included those plans and other policy subjects a bit more detail with the knowledge that supplementary guidance was being removed as a requirement.
I am going to stop you, Mr Templeton, because you are simply
said.
Avoiding my question, which is a very straightforward one, and I would like an answer to it without going off on something else. if you are saying that your SG is consistent with SPP, it must be that for a Group 3 area, you can never say the development is in the wrong place because of the SG advice. Please deal with my point.
Group 3 areas are areas with potential, and I agree with the wording. It's in front of me, it's in front of you, that has to be subject to detailed consideration against identified policy criteria. I'm not sure what more you're asking me to agree to, Mr Trinick.
Well, I'm asking you to address my question, which you've avoided 3 times now, and I asked the reporters
I think
to
I'm
note
not understanding
that,
it.
and I will
why.
put the point again, with I hope the clarity I put it before, that if you are saying your SG is consistent with SPP, then in any case where a developer proposes something within a Group 3 area, you can't say it's in the wrong place. You cannot.
At that level, I accept that.
Well, at the development management level, you have to accept that. You look at the detail, but that's what you look at. You don't look at the location. That must be so if you accept the advice on SPP. Do you agree?
Yes, I agree with that, yes.
You agree with that. Thank you. Then let's go to the supplementary guidance itself. I want to understand 1 or 2 points within it. If you go to 321.6, here you're talking about the SPP spatial framework, and you say that most of the turbines in the southern group are not areas with potential. Actually, we've been here before. That's because of CO2 soils. I'm ticking a box I've already ticked. My apologies. Move on. I'd like to go to the SG at, as a CD55 at page 12 now. I want to be clear what was done so as to come to examine a particular 7 turbines within Gour and see how they fit with what you've done. The detailed policy guidance maps you're talking about were, in our case, map 1 for SG, were constructed by applying the filters, the constraints, the restraints, whatever you call them, which are set out on page 12. Is that right?
That's correct.
And those constraints are further discussed in subsequent pages. We need to go there, but that's what the application of those constraints resulted in what is your Appendix 2 map for the larger typology development.
That's correct.
Excellent. On your Appendix 2 map, we can see that for the eastern section of Gour, we call it Dallas, eastern section, whatever, there are 7 turbines which are outside the pink. They're in the grey, aren't they? You see the ones I mean?
Yes, yes.
Now, I've asked Helen to bring up, and I'll ask for it now, the interactive map from within the... Oh, brilliant. Helen, would you go to the bottom of it and click on green? Yes, click on green, would you? That's it. Now, you've got layers there, haven't you? Would you take out the spatial framework layer, delete that, and tick the next one down, potential development areas for extension and repowering. There they go. The next one down, policy guidance for large typology, and then go down to landscape character types. Now please close that box if you can, and so we see the whole... Click on the map, it'll probably close it. Then if you scroll down a bit, no, down, and go to zoom on the left, the plus. Right. Now, we can probably, if you center Try zooming once more. No, centre it. All right, carry on. All right, now pull the map across to the right. You should be able to move it across to the right. That's it. Right, got it. Now, looking at your Appendix 2 and comparing it with that map, do we see that actually what's happened is that the 7 turbines within the eastern group are grey because they're in LCT 11, not 10?
Sorry, Mr. Trinick, you can just explain that again?
Sure.
I'm just trying to match it with
no, I
what's in
understand
front of
that.
me.
The trouble is we haven't got a single map that doesn't. That's our fault, not yours. Looking at your Appendix 2, the Dallas section, the eastern section, has 7 turbines, which are in the grey, not in pink. You see those 7?
Yes, I'm with you now, sorry, yep.
But they're also still within forestry.
Yes, yep.
But they are the west or south side of the pink,
Yes.
which is LCT 10. So the reason they're grey is because they're not in LCT 10, they're in LCT 11, aren't they?
Yes.
That's why they're grey. And we know that for LCT 11, no scope was defined in the SG for this typology.
That's correct.
But there's no, I would suggest, there's probably no material difference in landscape type or description of landscape type one side of the boundary from the other. It's all in the forest. It's a line on a map.
I would accept that, but that's maybe straying into landscape evidence.
We both are, but I think that's common sense, isn't it? It's all in forestry. It's just one side of a line. That's why it's grey and not pink.
I know what you say.
So the Dallas 7, as I fondly call them, have fallen at the wrong side of a postcode boundary that has no relevance except it's a postcode boundary. That's what it comes to, isn't it?
Well, this is a sieve mapping process, which you're highlighting.
But in terms of environmental planning, it's an arbitrary line, noting the circumstances which apply each side of it. It's forestry.
Well, it's a landscape character type boundary that's been lifted from the capacity study.
Okay, thank you for that. Now I just want to understand the difference between the LCS and the SG, because there are differences I think the reporter needs to understand between the documents. The LCS areas of potential for turbines of the topology we're talking about today, except for some at Dallas, which are 30 metres higher, that was mapped. And if we go to the map within the LCS for LCT 10, which I'm trying to find. No, Helen, we want the landscape capacity study 5.6. My fault. It's map, character type map 11, open rolling upland. Have you got it in front of you?
Did you say LCT 10? Sorry, did you say?
Perfect. No, LCT 11. My apologies. 11 first. So we see the hatching there, can't we?
Yes.
And the caption says potential scope for large and very large turbines, 80 to 150.
Yes.
All right, there's no mention of extension or repowering on this map, but that's dealt with separately in the report in section 4, isn't it?
That's correct.
And quite obviously, mapping for areas for repowering doesn't need mapping because it's repowering. It's on the site of the existing wind farms.
Yes.
And extensions aren't covered in the LCS, are they? There's no mapping for extensions.
I'd need to check, Mr Trinick. My understanding was that the potential scope for large and very large encompassed extensions and repowering, but I'd need to check that point.
Do check it and come back if you say I'm wrong, but my suggestion is, I won't waste time now because it's not important enough to stop for.
Okay.
But my suggestion is that Section 4 solely deals with repowering and not extensions.
Okay, well, let's not waste time on it. But
if I'm wrong, I'll accept that. If we go to the LCT 10 map, the one before, we actually see, well, both together as it happens, and we see again potential scope for large and very large within LCT 10, can't we?
Yes.
Around Rothes, the area there. If we go to the SG maps now, and we go to map 1 within the SG, which is on page 13, CD55. We're right in saying that there's a distinction here between the LCS and the SG of some importance, because while for LCT 10 there are pink areas for new development, and you've got the hatched area on LCT 10 marked small Roman 2, which is for extensions and repowering, yes?
Yes.
For LCT 11, you've only got the extensions and repowering. There's no area for new development, is there?
That's correct. That's one of the issues we've highlighted to ensure we got consistency between the two documents in the review.
Yeah, okay. But the hatched area within LCT 11 equates to the hatched area in LCS, which is simply marked potential scope for large and very large turbines.
That's correct.
So the SG converted the hatched area in the LCS, which was for any new development, into an area solely for extensions and repowering.
That's correct. As I say, that's a consistency issue we're going to resolve.
I'm not quite clear why. You say consistency, it always means nothing to me unless you tell me what was behind the consistency. What was the reason for taking the view that there's no capacity for new development in LCT 11 as opposed to LCT 10?
I couldn't tell you offhand, Mr Trinick.
You can't tell me offhand?
To be honest, I need to go and look into it. We're aware there is a lack of consistency between the two documents. It may simply be clumsy labelling by us, which we have to accept as an error, and that's something we've identified as addressing.
All right. I mean, you've got the opportunity to come to that opportunity in a moment. But the trouble is that we've got what we've got in front of us. Whether or not this is a material consideration as it stands, I have to look at what we have. Look at page 54, would you, of the SG. Sorry, that's my paper, page 54. I'm looking, Helen, for some boxes. No, you're in the LCS.
I think it's electronic page 52 out of 94.
52 out of 94 of the SG.
On my version, which includes the maps.
Can't hear it. Sorry, Helen, I'm taking you all over the place here. It's page, say 52, sir, was it, on the electronic?
It was 52 out of 94, but I think we identified an issue. Helen,
that's the one.
Different version.
No,
Right.
that's the page. At the top, please, of the page. Thank you. It's a further puzzle to explore here. I've taken your earlier answer. You can't tell us why. But here we have large typology, sensitivity, and character types. And we'll see that for large typology, we have only a medium sensitivity recorded for LCT 10. See that?
Yes, correct. Yeah.
High medium for LCT 11. However, if we go to CD 56, which is the landscape character study, at page 70, say paragraph 16.2, maybe easier. Down a bit, there we are. We can see actually that Carol Anderson assigned a high-medium sensitivity to LCT 10, didn't she? Not medium, but high-medium.
Yes, yes.
And if we went to page 75, if you scroll down to paragraph 17.2, Helen. Here we are, high-medium, so precisely the same sensitivity for LCT 11. That's right, isn't it?
That's correct, yes.
So can you explain why the SG recorded things differently?
I couldn't, Mr. Trinick, at this point in time.
You can't. Another puzzle. Well, that's taken the SG as far as we can.
Sorry, Mr. Trinick. Could
yes,
you
sure.
just, sorry to butt in. Could you take me back to where you were on LCT 10?
Yes, of course. That's paragraph 16.2. Yep.
Just to, sorry to take you back, I'm just trying to clarify. I'm not trying to be evasive, by the way. I just don't want to give you a wrong answer, and I'd rather go away and check it. You were asking about the large typology for LCT 10?
Yes.
Saying that was recorded as medium?
It's recorded as medium in the... Yes, they may be looking at different typologies. It's recorded as high-medium in the LCS for turbines of greater than 130. Well, I see what you mean. It's like in the SG, it's 80 to 130.
Yes, the table is talking about medium for the 80 to 130, the large, so that is correct.
Right. So the SG advice, so far as large typologies is concerned, relates to up to 130 metres. Is that right?
That's correct.
Not to the 150 in the LCS.
Sorry, you couldn't say that again. Sorry, I'm not being evasive.
No, it's all right. It doesn't cover the 100 up to 150 metres in the SG at all, except in the context of extensions and repowering.
That's correct. Yes.
Okay. You must understand. This is not being critical of you necessarily. I want to actually understand so I can submit on what we've got. Would you go back to CD 53 for one more question, please, which is the LDP 2020? Helen, could we have page 4 up, please? In the right column, it says supplementary guidance. The following supplementary guidance forms part of the new plan. We know the story about the supplementary guidance itself, but you look at the second bullet point, it says Murray onshore wind energy policy guidance, including Murray wind energy landscape capacity study. That's got to be wrong, isn't it? The LCS isn't part of the plan.
capacity study, in terms of the 2015 plan, formed a technical appendix to the supplementary guidance. It's probably a grey area, Mr. Trinick. It's maybe one for lawyers to discuss rather than myself.
No, it's not. It's for you to discuss with me now. I'm not talking about the 2015 plan. I'm talking about the 2020 plan. It's right in front of us.
Well,
the
intention
claims that the plan includes the landscape capacity study. That's got to be wrong, isn't it?
At this point in time, that's obviously not the situation, but the intention is that these are the supplementary guidance that will form part of the plan.
LCS as well.
Well, that's what I was just going to say, was that once we submit the new statutory supplementary guidance with possibly an updated LCS to the Scottish Government, with the hope of having that approved as forming part of the plan. Now, that may be that the Scottish Government take a different view of that.
All right. Let's turn to your supplementary precognition then, please. Appreciate the reason I'm interested in going to the future here, because although no doubt the reporters will write the report with all due speed, it's going to be a number of months before we receive any news from the ministers. And in the meantime, who knows what will happen in terms of the SG and your plans for it. So I need to go there. If we go to paragraph 2.6 of the supplementary precognition, thank you for the correction. I understand that. I don't think it really matters, does it? Because none of the SLAs are within areas of greater potential anyway. You're simply putting them on a map, is that right?
That's correct, but we didn't want to muddy the waters in any way. So.
No, it doesn't go anywhere in terms of the evidence for this inquiry, I don't think, does it?
No.
No, it doesn't. You go to paragraph 2.9, if you would. No, that's about rural groupies. We've dealt with that. So despite what the LDP reporter said clearly about the SG, the old SG approach, and maps 3 to 5 being inconsistent with SPP, you're going to carry on with the SG. How do you intend that the new supplementary guidance, non-statutory initially, will be read with policy DP9
then? Excuse me. We intend to identify, well, the train of thought at the moment is that we intend to identify areas of greatest potential, as we have done previously. And if it gets to this stage where the Scottish Government do not approve that in the statutory version of the guidance, we will accept that.
Okay, so looking at page 61 of CD53, which is the DP9, under paragraph B in the right column, sorry, Helen, it's page 61. Sorry, it's paper page. It's DP9 anyway. They got it perfect. In the right column, B2, detailed consideration will be determined through site-specific consideration. Sorry, the proposal will be determined through site-specific consideration of the following matters, on which further guidance will be set out in supplementary guidance and as informed by the landscape capacity study. So noting the answer you gave me earlier about you can't say it's in the wrong place because if it's in a Group 3 area under SPP, and you acknowledge that, this SG will do no more than offer thoughts on matters of detail. Is that right?
To be clear, Mr. Trinick, are you talking about the short-term, non-statutory, or?
Frankly, both, because they're going to have the same content. It's just a matter of whether it's statutory or not. I'm looking at the content. Is the intention that the new SG, the revived SG, or whatever it is, will simply advise on matters of detail? It won't advise on the principle of the development in a Group 3 area, because SPP already does that. Is that right?
asking me to speculate as to the form of the guidance at this point? I think
sorry,
sorry, a little bit echoey. You're asking me to speculate as to the form of the guidance. I think we've made it clear that the quick refresh, if I can call it that, will be very much what's in front of you just now.
Yep.
As for the scope and content of the, what will hopefully be statutory supplementary guidance, we haven't got any detail on that. We haven't thought that through.
Well, okay, but whatever it does, given your earlier answer about SPP and Group 3, I assume that any supplementary guidance in whatever form is going to do no more than inform DP9, as it should do under the 2008 Development Management Planning Regulations. It will give further thoughts on the application of DP9. It won't advise on whether or not development's in the right place. Is that right?
Well, I can't answer that, Mr. Trinick, because we've not written the guidance. So.
No, I think you can answer that actually pretty well now, and I'm going to put the point again. Given your earlier answer about SPP and Group 3 areas and development being in the right place, and attention turning to detail if you're in Group 3 areas, it would be wholly inappropriate for the SG to advise that a development in a Group 3 area was in the wrong place, wouldn't it?
Well, I'm not going to answer that, excuse me, on the hop, Mr. Trinick. I'll take that away, we'll consider it, and consider the scope and coverage of the guidance. I
don't think that's appropriate. I think the reporter deserves and can get an answer to that point now, because it goes beyond the content of the SG. It doesn't matter what the SG actually says in guidance. What matters is that the SG, what it can't do in a Group 3 area, is to advise the developments not in the right place, can it?
Well, I think, Mr. Trinick, we also have to reflect there's new National Planning Framework position statement coming out. There's different things happening. I'd like to reflect that. I'd like to have a discussion with the Scottish Government.
As things are now, under SPP, you're diving all ways to avoid answering the question. I want an answer, please.
Because I'm not in the business of speculating as to what something that hasn't been written is going to cover, Mr. Trinick.
All right, so I ask you to note that I had no answer to that question. One final point, Mr. Templeton, is that, I mean, it may seem strange to you that I'm belittling the SG and the landscape character study, because they say actually some quite good things about where Gour is. Whatever the status of the SG, whatever comes out of the process, as put to other witnesses in this inquiry, for 20 years, through various landscape character studies, through various other documents, through the 2012 LCS, through the 2017 LCS, through the 2017 SG, Murray has been telling developers to look in the area of Gour, and indeed Rothes, for larger typology wind energy development. That's correct, isn't it?
That's correct. We've identified those areas as having some limited scope for further investigation.
Yeah.
In the detailed development management criteria.
For years, Mr. Templeton, Murray's been telling the Gour applicant and people, anyone looking at this area, you're in the right place. It's correct, isn't it?
I would commend the applicants from Gour for the approach they took. They worked very well with a number of stakeholders in the design process up to a certain point.
You've disarmed me completely. Thank you very much indeed. Finished.
Sir, can I, Madam, just indicate, in light of the extensive cross-examination from my learned friend, Mr. Trinick, I will not repeat any of his questions, and therefore I will be much briefer than I would otherwise have been, indeed extremely brief, and could very comfortably finish within a reasonable time this evening, and I do that on the basis that re-examination will also take place this afternoon. That would mean we would finish within a reasonable usual working day and save the very considerable inconvenience and expense of returning tomorrow. I'm entirely in your hands, but our preference / strong preference, sir, would be for economy, particularly having regard to the circumstances of the virus, and not least because I've received an email indicating there may be a lockdown in Edinburgh and the Lothians upon us in the immediate future. So that is another factor in my calculation that may be best for everybody to get down the road sooner rather than later. So my suggestion, really quite a strong one, is to press on. I would guesstimate I might be 15 minutes, I might be 20 minutes, I might be a bit less. It's of that order, but comfortably before 5, but only on the basis that re-examination will also be today.
Mr. Brown.
Sir, thank you. I'm conscious of the fact that we started earlier today. I don't want to appear lily-livered about it, but it has been quite a long day. Mr. Templeton's obviously a material witness, and I wouldn't like to be rushed in the final straits of this inquiry. So I would ask, sir, that we adjourn for today and resume tomorrow morning. I did indicate earlier that I had no difficulty with Mr. Templeton being out in Purda overnight. My learned friend says he might have up to 20 minutes. I'm conscious that you, sir, and Madam may have questions, and then I would be asking for a break in the usual way in any event to consider lines of cross. So my preference, and I'm entirely in your hands, my preference would be to resume tomorrow morning. So far as the lockdown is concerned, I left Glasgow in lockdown to come here for this inquiry, so I don't think that's in and of itself a material consideration at this point.
Well, I think we're looking at. Obviously, there would be a requirement for a break. Would a break not be sufficient to consider re-examination if we press on them? And I'm guessing. Oh, you haven't said, and you maybe haven't considered how long you might take for re-examination. I mean, if we were heading towards 6, is that?
Sorry, sir. Can I just pause there? Apparently, the signal has dropped, and it has not been received upstairs. Sorry to interrupt, but I think that's important.
Well, I'm not sure how much they need to hear the procedural discussion, or a discussion about how much, whether we extend today or adjourn today.
Well, sir, I have often sat in inquiries which sit on until 5:30, 6, or even 6:30, particularly when they're far from the central belt and we are pressing on to get finished.
I must say, if we can get the inquiry finished today, it's a prospect I would very much prefer, unless and I'm quite prepared to give you a reasonable break to consider re-examination.
Well, that would be helpful, sir. That would be helpful.
So unless you feel it would be very unfair on you or the witness, I would much prefer to continue.
No, that's fine, sir. I accept that.
So if I leave the room briefly, don't stop for me. I'll be back.
Mr. Templeton, are you comfortable carrying on? So, Mr. Steele, would you want to take
Yes.
a 5-minute break to?
I'm happy to go, sir. I'm ready.
You're ready to go now? Okay.
Yes, I'm absolutely ready.
Are you content to go now, Mr. Templeton? Yeah.
Mr. Templeton, good afternoon.
Good
I think the
afternoon.
error was mine earlier in calling you Mr. Templeman, so if I do it again, apologies in advance.
That's okay, Mr. Steele.
Thank you. Now, Mr. Templeton, as I understand it, you're here giving the planning overview and you rely entirely on others for landscape and visual matters.
Planning policy overview. I'm not the case officer, and I don't deal with development management issues as such.
But my real point was this, that you are not dealing with landscape and visual matters. You're not giving evidence on that.
Yes. Yep.
You're simply relying on others, because I don't want to go there again.
Yes, that's
And
right.
secondly, I'm trying not to ask any questions of the type that Mr. Trinick asked earlier, so have no fear. I'm not going to the supplementary guidance and all the intricacies of that, because that's been covered. But I would like to ask you a few questions, if I may, of another nature. Could we look, please, at CD 15.1.8, being the Meikle Hill decision? And could we turn, oh dear, it's an unnumbered page, but it's under the heading, two-thirds of the way through. Sorry, I should have numbered the page. That's my error. Consideration of landscape and visual impacts on the 10 and 19 turbine original proposals. Is the heading some halfway down the page? I didn't realise they weren't numbered. Thank you. It's some 10 pages, maybe a bit more from the end of the document. Yeah, it'll be assessment. It'll be a couple of pages after that, I'm guessing. Apologies, I hadn't realised the pages were not numbered. That is my error. No, it'll be after the planning policy. It'll be after that. Landscape and visual assessment. Yeah, Nick, yeah, I think that's the page precisely. Thank you very much. Sorry, I hadn't got the page number identified. Second bottom paragraph, Mr. Templeton. We see discussion about the Lossy Valley cyclists and so on and so forth. And if we can go 2 pages after that, Helen, please, consideration of landscape and visual impacts. And the very bottom paragraph on that page, yeah, beginning with the original. Mr. Templeton, do you have that? Do you see that?
Is this starting contrary to the ES and PS?
Yeah, no, the last paragraph with the original.
Right. Okay, yes. Yep.
The point I'm interested in is reference some 4 or 5 lines up to the Council's landscape advisor. Do you know who that was at that time?
I think it was Carol Anderson.
Yeah, I was going to say it would be Carol Anderson, wouldn't it? And did she advise there, as we see, about unacceptable effects from that proposal and recommend it should be rejected as being inappropriate? Two or 3 lines up from the bottom of that page.
It says the Council's landscape advisor highlighted a similar occurrence of significant adverse effects, adding the proposal would be rejected in being inappropriately cited.
Yeah, exactly.
I'm not aware of the context of this. I'd just like to point that out.
No, I understand that. My point is a completely different one. Have no fear. If we turn the page some 6 lines down, does it appear that the Council's landscape advisor again advised that turbines would be located close to the outer edge and so on and so forth, advising clearly in relation to particular turbines?
Yes.
Yeah. And if we look at the bottom paragraph on that page, in summary, the original development was considered to be basically unacceptable because of significant adverse landscape and visual effects.
That's correct, and then it was negotiated to a more suitable development.
Well, that's exactly right, and that was because of the advice given by the Council's landscape architect, Carol Anderson.
That's correct, and I think planning officers were involved in those discussions.
Yes. Well, the reference here is to her advice, and you relied on that very properly, and the scheme was reduced, as we'll look at in a moment. Is that correct?
That's correct.
And would it be fair to say that it was her professional duty to advise you if she found the turbines to be too large or too close or too many or whatever?
Yes, we relied on Ms Sanderson's guidance.
Yeah, and she would express that professional opinion to you if that was her opinion, as is reflected here.
I'm sure she would, yes.
Yeah. So if we turn the page, do we see under the heading amended proposals that the Council's landscape architect, for which we can read Carol Anderson, acknowledged the improved design and appearance and so on and so forth? The first paragraph under the heading amended proposals.
Yes.
And if we turn the page to the first, second, third, fourth paragraph, was there an acknowledgement of the significant adverse effects of the development that would remain on the Dallas Knockandoo Road because of proximity?
Yes.
Yeah. However, following upon the advice given by Carol Anderson, do we see at the bottom of the page that the amended proposals would reduce the otherwise intrusive impact, etc., and over the page on balance, following the advice, consent was forthcoming to the smaller amended proposal. Over the page, immediately above the heading impact upon built heritage, we see on balance, based, etc. And
yes.
And to be clear, all of that followed upon the advice as reflected there by Carol Anderson. Is that correct?
That's correct.
Yeah. Could we look now, please, at CD 15.1.9, which is the Kellis wind farm, and this time, very helpfully, I have in front of me a numbered page. So if we could go to, courtesy of Nicola Martin, thank you, because I'd forgotten to do it. Page 6, please. Unacceptable effects of the original proposal. And it's the same point again. Do we see there the reflected advice of the landscape architect about difficulties with the initial scheme and the number of the turbines and the precise location, reflecting her professional opinion? Bottom paragraph.
Yes.
Yeah. And if we turn the page to the third paragraph, do we there see the reflection of the Council's landscape architect, Carol Anderson, that the proposals would have increased the extent of the turbines seen on the upland skyline? And her advice was given as reflected in 4 lines above the heading amended proposals to omit certain turbines, it so happens 1 to 4.
Yes.
Yeah. And she gave that advice as she was duty and professionally bound to give to the Council as to what her opinion was on landscape and visual matters.
That's correct.
Yeah. And it would have been negligent of her had she not given that advice if that was her opinion. Is that correct?
Well, essentially that's what Ms Anderson was commissioned to do.
Yeah, to give you advice as to what the difficulties might be, whether turbines are too tall, too small, or unacceptable altogether.
That's correct.
So? Right. If we look at the amended proposals, did the Council, the landscape architect, this is the bottom paragraph, considered that the emissions of certain turbines had lessened the intrusion, and to cut matter short, consent was issued for that amended scheme, following upon her advice?
That's correct.
Yeah. Could we now look, please, at document CD 2.1.22, which relates to Clash Gour, and I'm not in the slightest bit interested in Clash Gour, only 1 or 2 factual matters. please, Mr. Templeton. If we look at the conclusion section of that, and in case you haven't seen this document before, as I understand it, I'll be corrected if I'm wrong, this is the consultation response from Carol Anderson in relation to that scheme. And if we go to the end, to the conclusion section, a couple of brief points only. In the middle paragraph, do we see her advice was that certain turbines, her opinion, be it right, be it wrong, I'm not interested, but her opinion here stated that the turbines were too large and too close to particular issues listed there. Is that correct?
That's what it says.
Yeah. And in the last line or two, do we see that her recommendation was that it was inappropriate development, taking the matter short?
Yes.
Yeah. Can we then please go to look at document CD 15.2.31, 15.2.31, and the last page and a bit under the heading Conclusions. And can we agree, as a matter of fact, Mr. Templeton, this relates to the consultation response from Carol Anderson in relation to Rothes 3 wind farm. Can we accept, as a matter of fact, and I'm not getting into the merits of landscape or visual, but a matter of English and a matter of fact, in the conclusion section, there is no statement that the turbines are too tall, nor that they're not set back enough, nor in the wrong location. Can you firstly confirm that?
I think that's a slightly unfair question, to be honest, Mr. Steele. I think I need to want to read the whole statement. If I remember from previously reading this, there is wording in reference to Ms Anderson's concerns about it, and I think it has to be read in its
well. Have you read the whole document before, Mr. Templeton?
I have, but it's quite some time since I've done that. So.
Right. Well, let me just confine you now to the question of the conclusions, because you would expect in the conclusion to have the important points. Can we agree that as a matter of English and construction, there is no suggestion in the conclusion section that the turbines are too tall? That is not said. Simple matter of fact.
As a matter of fact, in terms of the conclusions, I would accept that. But as I said a moment ago, I think it has to be read in its entirety.
Thank you, Mr. Templeton. My question related to the conclusions. And the next related point, can we also agree that in the conclusions there is no reference to them being in the wrong location or not sufficiently set back? There's no mention of that point either.
There is reference to the turbines needing to be set well back in the first paragraph into the interior.
Yes, absolutely. That's what it said. But is there any suggestion in this that the turbines are not set well back enough?
Again, it's a kind of bit of a leading question, Mr. Steele. I'm not seeing the whole response. So, in terms of conclusions, if it doesn't state that, it doesn't state that.
It is not a leading question. I simply ask you to confirm, as a matter of English and construction, whether in the conclusion section there is any statement that the turbines in question are not set well enough back. And I would have thought and hoped the answer was a simple one and an obvious one.
Well, if I can qualify it as with my previous concerns, yes.
Yes, thank you. And I'm only asking you about the conclusion. The reporters, no doubt, can will read the rest of the document, and I think they'll find exactly the same answer. But I'm only asking about the conclusion just now. Can we also agree this finally? There is no statement in the conclusion section that the development which she has identified here is inappropriate, not appropriate, or should be objected to either, is there?
I think there is really. It talks about diminishing the special landscape of the Spey Valley and such like. So I think there are references in there that flag up concern.
Mr. Templeton, please be fair to yourself, please. Show me where the words not appropriate, inappropriate, or should be objected to appear in the conclusion section, please.
I'm sure you've done a word check on that, Mr. Steele, so I'll take your word for it.
Don't take my word.
It doesn't say that.
Can we agree these words are not expressed in the conclusion section?
I can agree to that.
Thank you. Can we also agree to this, that if that had been her professional opinion at the time, these words, being so critical, should have appeared in the conclusion section?
I think that's inappropriate for me to comment without reading the whole statement.
No, in the conclusion section, Mr. Templeton, should they not? I've shown you 3 examples where she did exactly that in other applications and has not done it here. Can you not agree that if that had been her professional opinion, she was under a professional responsibility to express that opinion in the conclusion section?
I don't think that's for me to answer, Mr. Steele, so I'm not going to answer it.
You refuse to answer that question, which is critical for my clients.
I think it's a very unfair question.
It's not unfair.
I think it is.
No, Mr. Templeton, you're a very experienced planner. That's obvious from your credentials and the way you've conducted yourself today. You will have read many consultation responses. Are you refusing to answer that question? Because if so, I'll be making significant comments about your refusal in my closing submission.
Well, I think you're making statements about a professional integrity of our landscape consultant.
No, I'm not. I'm absolutely not. I'm trying to get to the bottom of her professional opinion, Mr. Templeton. That's quite different. She did not, for whatever reason, give evidence here at this inquiry against our proposal. That in itself may be a subject of comment, but I'm asking, if you refuse to answer the question, so be it.
Sir, my recollection is that Carol Anderson covered this herself.
Yes, I think I agree. I think those questions were put to Carol Anderson.
Yes, they were, sir.
And so I'm not sure if it's necessary to ask the witness to read Carol Anderson's mind.
Well, I take that point absolutely, sir. My recollection is that the Carol Anderson given answer was that she must have made a mistake. Now, that'll be a matter for submission, sir, but what I'm now doing is asking a very experienced professional planner whether he would have expected to see such a thing, such a statement in a consultation response. We've all read many of these, and I can only say I'm surprised that it would be such a difficult question, because every consultation response I've ever seen comes to a conclusion whether there's an objection, a holding objection, or something's inappropriate, or otherwise there isn't a difficulty.
Sir,
I can deal with that in submissions.
Sir, just on that point, again, for the avoidance of doubt about this matter, and it was covered when Carol Anderson's evidence was taken on this point, there's a risk of confusion here about consultation responses and the fact that Carol Anderson, as a consultant to the Council, has provided advice to the Council. It's not a consultation response in the way that might be understood in the context of planning matters. The Council is the consultee. It went to Carol Anderson as its usual advisor on these matters and got this report. It's not a consultation response.
Sir, the witness is declining to answer the question for whatever reason, so I shall move on. One further matter, Mr. Templeton. The appendix at the back of which is part of your evidence, if I may just take you to its Appendix 2, dealing with the 23, just for the ease of reference, dealing with the 23 turbine scheme. And obviously I'm only interested in, for the avoidance of doubt, in Rothes. Now, can we agree firstly that so far as what we see in the screen is concerned, the vast majority of our turbines are in the hatched area and the pink area as well?
Yes, I agree to that.
Thank you. There are one or two that are on the edge of the line, and we've been over that, and I'm not interested in going over that again. But there are certainly a couple that are in a white area not touching the line. Now, can we agree quickly, as you did with Mr. Trinick, that the white area there, this is the one to the south with a couple of turbines not touching the line, relates to deep peat?
That's correct.
Yeah. And you also know that we now have no objection in relation to peat issues from SEPA or indeed anybody else.
That's what I understand, yes.
Yeah. And that being the case, that constraint is removed. And is it correct, therefore, to treat as you answer to Mr. Trinick that all of our turbines are in a Group 3 area?
Well, I didn't actually say that to Mr. Trinick. I think Mr. Trinick clarified a point about other cases determining that.
Well, do you agree with that proposition, Mr. Templeton? Just to save time, we can go to all the cases if you want, but as a matter...
Sorry, yes, I didn't mean to...
You do agree? Okay.
No, sorry, I was just going to say that I agree that the peat constraint has been resolved, and now it's down to detailed development management criteria.
Yeah. So we're now in an issue, we're now in a situation where all of our turbines are either within or to be treated as Group 3. Is that not so?
Well, I suppose from my point of view as a planner that looks at the spatial framework, they're not in Group 3 at the moment. But I accept your point.
Okay, so you accept that they should be effectively treated. Well, the vast majority are undoubtedly in Group 3. We're in agreement about that.
Yes.
And those that are in the white area should properly be treated as in Group 3 because they have, on detailed examination, satisfied the peat issue.
I'd accept that.
And that being the case, as you accepted to Mr. Trinick, you cannot say that we're in the wrong place because our turbines are in Group 3 or to be treated as being in Group 3. Is that not accurate?
The right place is maybe subject to debate. These are areas of greatest potential for further examination, and that's where we come in with our landscape advisors' advice as to whether it's the right development in the right place.
Now, Mr. Templeton, I'm afraid you've rather slid out of that question. I'm sure you didn't do that deliberately. Let me repeat it. Given that all of our turbines are to be treated as being in a Group 3 area, and you accepted to Mr. Trinick that if you're in a Group 3 area, you cannot say it's in the wrong place, the conclusion of that is that you cannot now argue that our turbines are in the wrong place as a matter of principle. It's now a matter of detail.
I'd accept that Mr. Trinick and yourself are taking me to Group 3 in SPP, that these are areas where Group 3 are likely to be acceptable, subject to detailed consideration against identified policy criteria.
And that is the position in which Rothes 3 finds itself, that as a matter of principle we're likely to be acceptable, subject, of course, to matters of detail which you're not dealing with.
That's what SPP says.
Thank you very much. No further questions. Thank you very much, Mr. Templeton.
Right. I wonder if... Just give us a moment. Mrs. Black has some questions.
Yes, I just have the one question for you, Mr. Templeton. I think right back at the start of your, I think it was your evidence in chief with Mr. Brown, you referred to wind farm proposals being at a tipping point, I think was the word that you used, and I think you've also referred to that in your inquiry report. So I'm just wondering, from our perspective, how would you quantify the tipping point? How would we assess it on that basis?
Probably a very difficult issue. I think that's. I think it maybe takes us back to where we've been perceived to be negative, but what we're trying to do is reflect that there is a limit as to what the landscape can accommodate. I think we have made allowances for bigger or larger turbines, I should say, repowering and extension opportunities. I think that tipping point is moving on from the strategy that was set out in the 2017 guidance and the landscape capacity strategy, where we recognise we've consented a lot of turbines, got quite a lot of operational turbines, more in the pipeline, and the landscape is starting to get to that tipping point where significant change is happening. So yeah, I think we're there at that tipping point. I think the concerns that we raised in 2017 about the cumulative impact, they've obviously been things that moved on. We've got more consented wind farms, so I think there is a concern that we're there at that tipping point. How you deal with that, I'm not sure, to be perfectly honest. We're trying to take a balanced approach in terms of climate change targets, supporting renewable energy, but respecting that there's only so much the landscape can take, and looking at the sort of wider opportunities in terms of hydrogen, solar, and all the other kind of energy efficiency sort of initiatives that are ongoing.
If you have reached that tipping point, does that then imply that potentially there could be restrictions in terms of further wind farm development through your policy reviews?
I think it will be a very difficult issue for us, and that's why I've probably been construed as being negative myself for referring to the spatial framework as meaningless. But really, that's actually probably a passionate point to the government, is that we think our more detailed mapping is a good thing, and that more authorities should be doing that to try and hone in. And I appreciate that any sort of civ mapping exercise has got its limitations, but we think it's more value to try and hone in on areas of real potential. And I think we've always tried to guide developers in, as I said earlier, Gour was actually quite a good sort of iterative process up to a certain point, where we try and negotiate with developers to get the right development in the right place. But I think that's going to be a very challenging issue for the full review to tackle. And it may well be that we get a steer from National Planning Framework 4 position statement on that.
Okay, thank you very much.
I think at a number of points in your recognition, you refer to, in particular in paragraph 5.3 and 5.4 of your recognition. So in 5.3, you refer to the unacceptable landscape and visual effects identified by the Council's appointed landscape advisor. And in 5.4, you refer to unacceptable effects of the proposed development on special landscape areas, as detailed in the reports by the Council's appointed landscape advisors. Just that word unacceptable, is that your assessment or their assessment, the appointed landscape advisor's assessment that you're referring to, the unacceptability of it?
I think that's my wording to reflect their conclusions.
Right, I don't have any more questions. Should we take? Do you need a break for?
Yes, please.
How long would you want?
Sir, 15 minutes.
Yes, shall we take till past?
Yes, I don't expect it'll be very long, sir, when I return. And while we have our break, could I ask that Mr Templeton is given an opportunity to read CD 15.3, sorry, CD 15.2.31, because he did say that he would have to read that, and I would certainly want to go back to that re-examination.
Okay, do you have a copy of that, Mr Templeton?
It is CD 15.2.31. I don't think you'll have a copy, but perhaps Helen here will assist you during the break in being able to read it on the screen in front of you.
Okay.
Did you mention another document, Mr Brown? No, just the one.
No, sorry, Madam, just the one.
So, till past.
Thank you, sir.
Mr Ryan.
Thank you, sir. Mr Templeton, I'm going to ask for CD 5.3 to be brought up, which is the 2020 local plan. And hopefully I've got this right, Helen, it's electronic page 77. Yes, and you could scroll maybe down a page, so we've got the start of EP3. Sorry, the other way. Yep. Right, thank you. Now, Mr Templeton, I'd like to take you back to Mr Trinick's cross-examination of you when you were taken to the particular policies in the 2020 local plan. Do you remember that?
Yes, I do, Mr Brown.
And Mr Trinick took you to policy EP3. And in the course of that passage of your evidence, you referred to the second part of EP3, but you didn't have the opportunity to continue while you were referring to that second paragraph. So if I give you that opportunity now, what was it you wanted to say at that point? And can we scroll to see part 2, please, Helen? It's just the next page down. Oh. Yes, sorry, that's it. There you are. You have it in front of you. So what, if anything, was it you wanted to add?
I just wanted to point out that we'd be applying this policy in terms of the second part, which refers to landscape character in its widest sense, and we'd be linking it to, I think Mr Trinick was quite rightly trying to stop me jumping to other policies, but taking them one at a time, I was trying to link it to the fact that policy DP1 and policy DP9 both make reference to landscape character. And when the plan is read as a whole, there are various landscape character references to it, which support the view of our landscape advisor in suggesting that, or expressing concern about the impacts, unacceptable impacts on the Spey Valley SLA, and therefore applying this policy, in our view, is correct.
Okay, thank you. And if I could take you to the end of Mr Steele's cross-examination regarding Carol Anderson. Now, this is a Section 36 application. In a Section 36 application, who ultimately makes the decision as to the Council's position?
To the Council's position?
Yes.
Do you mean the Scottish Ministers?
No, who ultimately makes the decision as to what the Council's position is in relation to the application?
Oh, sorry, the committee.
And by that you mean?
The Planning and Regulatory Services Committee.
Yeah, so the decision is made by them. Now, how long has Carol Anderson been a consultant for the Council?
Quite considerable time. I'd be guessing, Mr Brown, but I'd be thinking 15 years plus.
And how would you describe your working relationship with Ms Anderson?
It's very good. Yes, we worked on various projects, the special landscape area, numerous wind farms, some settlement-related matters.
And how formal are your communications with Ms Anderson?
My communications are a mix of formal and informal, depending on where we are in terms of projects.
And we just tease out that mix. When you say there are a mix of formal and informal, if we were talking about formal, what would you have in mind?
It could be procuring a service, scope for a project, that sort of thing, a formal response to something. Informal, maybe more about exchanging views, ideas, discussion.
And how would you go about the communication process with Ms Anderson?
A mix of email and telephone calls, mainly email.
And in relation to this, what about meetings? Would you have meetings?
We'd have meetings, yes, site meetings and such like. All large-scale wind farms, we would usually visit all the viewpoints with Ms Anderson.
And on this particular occasion, what instructions were given to Ms Anderson?
For Clashgour
for Rothes 3.
And Rothes 3. Well, I think between Mr Macpherson and myself, we will have commissioned Ms Anderson to undertake a landscape and visual review of the proposal.
And who is Mr Macpherson?
Mr Macpherson, Neil Macpherson, who's the case officer, principal officer in development management for Moray Council. And
to whom did Carol Anderson report, do you know?
I think it was Mr Macpherson.
You say you think, how clear are you in your mind?
I'm fairly sure it was Mr Macpherson as case officer.
So to what extent then would you know about the communications between Mr Macpherson and Ms Anderson?
Fairly limited at certain points in time until we discussed the Council's response, if you like, in terms of pulling together a committee response.
And you talk about pulling together the committee response. Where were you drawing your conclusion from when preparing that response?
We're taking that response from national guidance, national policy, national guidance, local development plan, our own guidance, landscape capacity study, all other factors, benefits, impacts, all the consultee responses.
And what role would Ms Anderson have had in that?
As an expert landscape advisor to inform us on landscape and visual impacts.
And at the time of preparing that report, what was your understanding of Carol Anderson's opinion?
I think Carol Anderson had significant concerns, as are outlined in the reference that you asked me to review during the break.
Yes, well, that's perhaps a convenient point to read on to that letter. Then I appreciate you had an opportunity to read it over the break. But if you could read it through with us now, and stop us when you get to points you wish to draw our attention to. That would be very helpful.
You want me to read the whole thing?
Well, if you can navigate us towards the correct paragraphs, I'm sure we'd all be grateful for that at this time.
Okay, well, I think in summary, Mr Steele took me to the conclusions, and I think I expressed my concern that...
Sorry, Helen, could you bring up the... Sorry, could you give us the page numbers, Mr Templeton, so that Helen here can bring them up on screen for us? I think it's unnumbered, so you'll just have to count your way through.
Just to be quite clear, the precise questions I asked were whether the words too tall appeared, or whether there was a suggestion they weren't set back, the turbines were not set back further enough, or whether the words inappropriate appeared. These were my questions.
Well, actually, what happened was that Mr Templeton said that he wanted to read the letter. He's been given an opportunity to do that, and I'm asking him to comment on it, the matter having been raised during cross-examination. So, if you could direct us to the pages, that would be very useful, so that Helen can pull them up for us to see on screen.
I think yes, throughout, just as a general comment, Mr Brown, I think throughout the paper, Ms Anderson's concerns come through. In fact, when Mr Steele took me to the conclusions, there are actually earlier conclusions, and they are towards the bottom of page 2.
Yeah. Now, if you can give us a heading.
The heading is remaining. That's the one, remaining significant.
We've got that in front of us.
Where it states that notwithstanding the improvements made to the scheme in terms of reducing landscape and visual effects in some areas, the alternative proposed development would still incur significant adverse effects on. It then continues to list a whole series of concerns from Ms Anderson, significant adverse effects on the upland, moorland and forestry LCT.
Sir, the word concern simply doesn't appear. What is said is there are significant effects. Well, of course, that's true of any wind farm.
Sorry,
Mr
Steele, I'd be grateful if you'd allow the witness to...
You cannot read words into it that aren't there.
Well...
Perhaps I just read it word for word.
Read it word for word. Read the relevant parts you want to draw our attention to, please, Mr Templeton.
If I just carry on from the still incur significant adverse effects on the upland, moorland and forestry LCT, within which the proposal is located. While the operational Rothes 1 and 2 wind farms are located in this LCT, this proposal would substantially extend the wind farm development and also introduce larger turbines to this landscape. The alternative proposal would have a less dominant effect than the original proposal on the smaller scale, lower settled hill fringes, and so on. On the following page, that continues the bullet points where Ms Anderson is expressing, I won't use the word expressing, notes that would still incur significant adverse effects on the Broad Farm Valley LCT, on part of the Spey Valley area of Great Landscape Value, and the Spey Valley Candidate Special Landscape Area, on views from the A95, east of Aberlour and from the settled southeastern slopes of the Spey Valley, where, although the overwhelming dominance of the original proposed development would be reduced, the proximity and size of the turbines to these views would result in major and significant adverse impacts from settlement and roads in this area. Views from part of the intimately scaled inner Spey Valley, views of the proposal from the B9102 road, and so on. Views from Ben Rennes. And then at the bottom of that page, the subheading is Cumulative Landscape and Visual Impacts. It refers to the above conclusions on the key landscape and visual effects. So already some conclusions have been drawn about the individual effects. On the next page, which I think is page 4, at the very top it talks about there will be significant adverse effects on the Broad Farm Valley and upland, moorland and forest LCTs if the consented Hunt Hill wind farm and so on. And the next heading is effects of this proposal with existing consented and other proposed wind farms. The consented Hunts Hill and proposed Paul's Hill 2 and Clashgour wind farms have the greatest potential to incur significant adverse cumulative effects with the Rothes 3 proposal. The combined cumulative effect of all these developments would be significant on, and then lists a series of bullet points, the character of part of the Broadfarm Valley, and so on. Sequential views from minor roads in the Upper Nakando area, affecting visual amenity from the B9102 and from minor roads, which are often used by local walkers and cyclists. Views from the A95 between Aberlour and Ballindalach, and so on. Views from elevated viewpoints such as Ben Aigan and Ben Rinnes. Views and appreciation of the character of the River Spey, which weaves through a narrow floodplain and is tightly contained by steep wooded slopes, where this proposal would be seen sequentially from minor roads with the proposed Gour wind farm. We then have the conclusions that Mr. Steele spoke to me about.
Okay. So, having instructed Ms Anderson as a consultant to provide advice to the Council, and having received her advice and preparing the report, and you said you participated in that process of preparing the report?
Mr Macpherson would consult and discuss the report with us.
So, in that process, what did you understand Ms Anderson's position?
Can we just wait a minute? Can we just establish if Mr Templeton was at the meeting to hear what was said? That would be the starting point for this. And this doesn't arise directly out of my cross-examination, because I asked precise questions as to whether the report said too tall, not set back enough, or inappropriate, or to that effect.
No.
Let me finish, please. Despite having now scrutinised the entire report, these words simply don't appear.
No, Mr Steele, what you did was you put it to Mr Templeton that would it not be, and I can't remember the exact words, but it was to the effect, would it not be reasonable to expect that Ms Anderson would have expressed an opinion? And my question is germane to that point. So, Mr Templeton.
Well, can we establish if Mr Templeton was at any meeting on the matter with Mr Macpherson and the witness?
Well,
because otherwise...
Well, I'd understood that Mr Templeton had said that he discussed the matter with Mr Macpherson as the report was being prepared for the committee. Is that correct?
That's correct. Mr Macpherson and myself met to discuss the report.
And as you prepared that report, what was your understanding of the advice you had received from Carol Anderson?
Well, Mr Macpherson, as case officer, prepared the report in discussion with the strategic policy section. Our understanding of Ms Anderson's position is that she had significant concerns about it, as expressed in the paper.
So that's entirely inappropriate. This witness was not at the meeting. This is at best hearsay and really should not be admitted, particularly not in re-examination, given the limited... Let me finish. Given the limited nature of my questions.
No, the point...
This has gone well beyond my re-examination. I was very precise what I asked, and we're now into simple hearsay.
No, we're not into hearsay, because Mr Templeton, as I understood it, said that he was in discussion with Mr Macpherson when the report for the committee was prepared.
That's correct.
We are in hearsay because what is being said is what Mr Macpherson said about Carol Anderson. That is hearsay.
I don't believe there's any rule against hearsay in a planning inquiry, is there?
No, there can't be, sir, because it's not a civil rule. It's a criminal process rule. And I asked Mr Templeton what his understanding was of Ms Anderson's advice. So, Mr Templeton, so there's no doubt on it, could you please say what your understanding was of that advice?
My understanding of Ms Anderson's advice was that she had significant concerns about the scale of proposal and expressed those concerns, I think, very well in this paper in front of us.
Thank you very much.
Sir, I'll deal with that matter in submissions, but that's just not an accurate reflection of the paper.
Okay. That brings us to the conclusion of evidence in this inquiry, as I understand. So there remains the question of submissions. We've obviously got written... we set a deadline. We allowed written submissions from the public, and we set a deadline for in relation to matters that have been raised in evidence in this inquiry. we set a deadline of tomorrow for those written submissions. So obviously we will, those written submissions would be to the case officer, Scott Mackenzie, at the DPA. We will draw any submissions we receive to the attention of parties, which we'd expect them to take account of in closing submissions. So there is the potential of one further round of written submissions in relation to certain matters raised by Mr. Chatterton. Yeah. In respect of, well, in relation to certain matters raised by Mr. Chatterton. As regards the timing of concluding submissions for the inquiry, what I suggest is that the applicants make their the objectors make their concluding submissions, including the council, make their concluding submissions 2 weeks after the inquiry. Is that sufficient time?
Sir, I'd be grateful for 4 weeks, and the reason for that is that, of course, I've got 2 sets to do, and I have court commitments the week after next. So I would appreciate 4 weeks, sir.
Well, 4 weeks, I'm content with 4 weeks if others are. Yep. So 4 weeks after conclusion. So that would be, I think that's the 16th of October.
Yes, thank you, sir.
That's right. Okay. And then, what if would 1 week after that be sufficient, or rather longer?
For me, 1 week will be sufficient.
Right.
For me, 1 week will be sufficient as well, sir.
Okay. So, closing submissions for the applicants are by the 23rd of October. Okay. Is there any other business before we close the inquiry?
One matter, sir. Wind speed table that you asked about, we'll send that in tomorrow. We have something available, but I'd just like to check it, if I may, with the clients, and we'll email that to you tomorrow, if that's acceptable.
Yes, that's acceptable, yes. Okay. So with that, we'll close the inquiry.